1 Civil Appeal 981 of 2018, etc. Sardar Confucius Imam Kasrani versus Sardar Mir Badshah Khan Kasrani and another.
Mr. Uzair Bandhari is here. We had appointed 3 amicus. Ms. Rima Umar could not come. She had just arrived, but she submitted something in writing. ये इनको भी दे दीजिए, ठीक है? And Mr. Uzair Bandhari and Mr. Faisal Siddiqui, is he here?
I don't see him in the courtroom, sir.
He did mention that he's got some case in the High Court. So, Attorney General, would you like to continue?
My lord, and I'll take 30 minutes and I'll conclude my.
Opposed to, so, and who else is opposed to the
Sabzwari साहब थे.
Sabzwari sir? We just want to hear your version first, then we can.
Then you can also respond to maybe that may be better than just to save time.
Ji.
My lord, to start with, there is a writ petition pending before Lahore High Court, Lahore, and in which reply by the Attorney General Office has also been filed. The next date of hearing is 9th of January.
जी
जी
आप इधर किस केस में हैं?
Which is your case here?
My lord, I am in 880 of 2015. I am for the respondent number 1 and respondent number 3.
नाम बता दें.
Arif Hussain
Arif Hussain
versus.
You are for Arif Hussain.
I am for Fayaz Ahmed Khan Gauri and Sajadul Hassan.
Takes in Fayaz
Ahmed Khan Gauri
Ahmed Khan Gauri
and Sajadul Hassan.
Sajadul Hassan.
My lord.
1 and 2. This one.
1 and 3. 3.
And this is civil appeal or civil petition? Which number is it?
Civil appeal arising out of
Civil appeal number
880
जी, ठीक.
2015
Okay. Arising out of Election Commission's judgment.
ठीक. चलें जी, बताइए.
My lord, my first submission is regarding the maintainability of these proceedings, because my lord has clubbed all the cases together. There are appeals as well, and there is a petition under 184(3) by the Supreme Court of Pakistan, and there was objection on that petition, and there was a chamber appeal. That is also fixed here. My first submission is, under what provision of law these proceedings are being conducted? Number 1, are they appeal under Representation of People's Act or Election Act? I am before my lord in appeal under Representation of People's Act. But there is this 184 petition also pending.
आप अपना केस चलाएं ना.
मैं अपना केस में चलाता हूँ. My submission is कि इस अपील में my lord ने सारे की सारे petitions को क्लब किया है.
आप अपना केस चला लीजिए ना. Don't repeat it. We've heard that point.
So my lord, my submission is, are my lords exercising power under 187 or 184(3)?
Please proceed with your case.
My lord. My lord, I have 4 submissions.
जी.
Number दे दें petition.
Civil Appeal 880.
880.
Civil Appeal 880.
Respondents 1 and 3. जी.
My first submission is, the court of law mentioned in Article Supreme Court in its appellate jurisdiction. I'll just submit the brief.
जी.
The declaration mentioned under section 162 or section 62(1)(f) is outside section 42 of the Specific Relief Act, because Specific Relief Act puts a certain conditions
Ji.
to obtain declaration. It has been held by the superior courts that the proceedings under section 42 are not exhaustive. Courts can issue declaration without satisfying the condition under section 42. I rely on two case laws.
Ji.
One is AIR 1967 Supreme Court 436.
AIR
67 Supreme Court 436.
Ji.
11,
11.
my lord.
Ji.
It says, in our opinion, Section 42 of the Specific Relief Act is not exhaustive of the cases in which a declaratory decree may be made, and the courts have power to grant such a decree independently of the requirements of the section. The same view has been expressed by Mr. Justice Mansoor Ali Shah while sitting as judge of the Lahore High Court in PLD 2010, Lahore 583.
Ji.
That is para 24, my lord.
In the Indian Supreme Court judgment,
My lord,
you have read this line that section 42 is not exhaustive.
not exhaustive.
So let me just ask the question. Is it not exhaustive in terms of the Specific Relief Act or exhaustive with regard to constitutional jurisdiction as well? I mean, you've just read that line and I can go along with that. That section 42 may not cater for all eventualities.
My lord.
The question here is not just that, but it is a question whether the declaration that is being envisaged,
My lord.
can it be a declaration by a constitutional court, for instance?
It can be declaration by constitutional courts as well.
Where does this judgment say that? The one that
It does not talk about constitutional court, but the judgment now I am referring, it talks about constitutional court as well.
ठीक नहीं, कोई सुप्रीम कोर्ट का जजमेंट नहीं है इस पे।
सुप्रीम कोर्ट का जजमेंट इस पे नहीं है।
अच्छा,
42 आपका मतलब है तमाम कोर्ट्स पर एप्लीकेबल?
मैं ये कहता हूँ कि
42 is applicable to civil court, but civil court can also give declaration without satisfying the requirement of section 42. Similarly, other courts can also give declaration.
The High Court in this case was following the Supreme Court precedents already settled. So is there a Supreme Court judgment on this point?
There is a Supreme Court judgment, my lord.
ठीक, next point आपका?
I will read para 24 of Lahore's judgment.
That is taking cognizance of the High Courts are bound by judgments of the Supreme Court. So there is no question about that. The High Court had to follow it. But now we are the Supreme Court and a larger bench.
My lord.
Ji.
Now,
The next point.
next point is a court of law has not been defined in Article 62 or anywhere else in the Constitution. But superior courts has held that it's a court of plenary jurisdiction.
that is PLD 2017, Supreme Court 265.
So can you repeat the citation?
PLD 2017, Supreme Court 265. That is at page 490.
490.
490, my lord.
It's in the second part of the page. It starts with the expression "a court of law" has not been defined in Article 62.
Which placidum are you referring to?
Double S, my lord.
Double S. G.
From the middle.
G. Read it.
The expression "a court of law" has not been defined in Article 62 or any other provision of the Constitution, but it essentially means a court of plenary jurisdiction which has the power to record evidence and give a declaration on the basis of the evidence so recorded.
Such a court would include a court exercising original, appellate, or revisional jurisdiction in civil and criminal cases. But in any case, a court or a forum lacking plenary jurisdiction cannot decide question of this nature, at least when disputed.
What is plenary jurisdiction?
Plenary literal meaning is a court exercising full powers. All the powers.
Plenary jurisdiction means where the original jurisdiction has been exercised under Section 42. If you mean to say that Section 42 of the Specific Relief Act can be exercised by the High Court under Article 199
No, my
and
lord.
184 and 185 by the Supreme Court.
No, my lord.
So declaration means for all such type of declarations, the case must be under Section 42 or not.
It need not to be under Section 42.
Then-
that is my submission.
Then how the declaration can be granted in any other law?
Declaration can only be granted by election tribunal. That is my submission.
It means that it exercises the jurisdiction under Section 42.
Not under 42. Under Representation of People's Act or Election Act. That is the only form.
And after recording evidence or without recording
Recording
evidence?
evidence, after framing issues, now I will come to the power of the election tribunal.
This can be exercised by the High Court directly
It cannot be exercised by
and
the
the
High Court.
Supreme Court directly.
No, my lord. Supreme Court in appellate jurisdiction.
Your last argument is in contradiction with the judgment you have relied. 490 पे आइए दोबारा.
My lord.
जहाँ से पढ़ा था उससे 2 लाइनें ऊपर. Even the election tribunal
Even the election tribunal, unless it itself proceeds to give the requisite declaration on the basis of the material before it,
would not disqualify the return captain where no declaration as mentioned above have been given by a court of law. Now I will demonstrate how I say election tribunal is court of plenary jurisdiction.
नहीं वो नहीं है, वो भी नहीं कर सकता unless by the court of law.
We explain the formation and the power of election tribunal.
आपका आर्ग्यूमेंट ये हुआ ना कि सिर्फ प्लेनरी जुरिसडिक्शन के कोर्ट्स डिक्लेरेशन दे सकते हैं और आप कहते हैं कि अदर देन द नॉर्मल रेगुलर प्लेनरी कोर्ट्स लाइक सिविल कोर्ट्स एंड ऑल द इलेक्शन ट्राइब्यूनल आल्सो फॉल्स इन दैट कैटेगरी. This is your argument.
This is my argument. I also say that
कौन से सेक्शन में ये पावर
in constitutional jurisdiction,
show us the please provisions of the law. Election Act में कौन से provisions है declaratory jurisdiction exercise करने की?
my lord, उसमें मैं आ रहा हूँ. Basically, election tribunal is constituted.
No, election tribunal is a different thing. आपने कहा ना election commission भी एक power exercise.
I'm saying election tribunal.
Election tribunal की जो power है वो तो फिर civil court के power हैं उसके पास सारे.
Yes, my lord.
They can exercise the civil court powers and they can record evidence because
My lord.
before declaring any person disqualified, they must be.
True. The provision.
But this debate won't resolve what the problem before us is. Let us not go into the powers of the election tribunal. Here, the power is, it's not a question of election tribunal exercising a power or election commission exercising a power. It's the power being exercised by a constitutional court. Now, you premised your argument by saying court of law is not defined anywhere in the Constitution. Can I first of all correct your premise and take you to Article 175 of the Constitution? If you read the Constitution provision, the chapter is titled The Courts. And now please read 175(1) and then 175(2). So I may be subject to correction, but there are courts of law and the courts, Supreme Court and the High Courts have other powers as well. Please read.
My lord, there shall be a Supreme Court of Pakistan, a High Court for each province, and a High Court for the Islamabad Capital Territory, and such other courts as may be established by law.
By law comes here. Now read subsection 2.
No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by any or under any law.
Now, first of all, the court has been defined. There are Supreme Court, there's a High Court, and any number of courts that a law may enact. Correct?
My lord.
So it is a clear distinction between the Supreme Court, the High Court, because the Supreme Court and the High Court exercise, and I presume this is the distinction, there is appellate power of the Supreme Court and the High Court where it acts like a court of law.
My lord.
And then there is an extraordinary constitutional jurisdiction of these courts,
My lord.
which it does not in the classical sense act as a court of law, but as a constitutional court. Therefore, they are called constitutional petitions. And we used to earlier write extraordinary constitutional jurisdiction. So it's an extra jurisdiction conferred by the superior onto the superior courts of Pakistan. And now we come to sub-article 2. No court shall have jurisdiction save is or may be conferred on it by the Constitution or by or under any law. Now,
Article 199 confers jurisdiction under the Constitution, which is in addition to appellate jurisdiction. Article 184(3), other articles of the Constitution confer certain jurisdiction onto the Supreme Court. Does Article 62(1)(f) confer any jurisdiction on the Supreme Court? That is the question. Because there it says court of law, not the Supreme Court, not the High Court. So surely we cannot interchangeably use these terms. If it had not used the words court of law,
which it does, so then it is, otherwise this power should have been mentioned in Article 184(3), or such powers as can be exercised by High Court under Article 199 or whatever it you say. So we cannot just disregard the two concepts of a constitutional court and a civil court under section 9.
My lord.
You assumed a lot of things.
Because when I use the word, it has not been defined. The phrase court of law is not defined.
It is. Because I've just read 197.
Supreme Court and High Court, that's the word they use. I am just referring to the phrase.
And are you saying Supreme Court is one in the same court within its exercising appellate jurisdiction as opposed to extraordinary constitutional jurisdiction?
No, my lord.
So technically speaking, they're two separate creatures.
My submission is anything arising out of election tribunal is decided by the Supreme Court in its appellate jurisdiction.
Correct.
Any declaration in election tribunal or by the Supreme Court in appellate jurisdiction is covered under 162(1)(f). Not any power under 199.
थोड़ा सा और clarify कर देना. Election tribunal will exercise powers only under the law, which used to be the Representation of People's Act and now is the Election Act of 2017. Correct?
My lord.
Therefore, when the Supreme Court is exercising such powers, it cannot have more powers than the Election Tribunal or the Election Commission of Pakistan. Unless you can show that the Election Commission of Pakistan and an Election Tribunal can also disqualify for life, then that power, of course, will be with the Supreme Court as well. Otherwise, it will be an additional power given to the Supreme Court under 62(1)(f).
Mr. Khurram, could I just summarize what you're trying to say? You're saying that the declaration from a court of law under 62(1)(f), court of law is only the court of law under the plenary jurisdiction, plus the election tribunal, and as a consequence, the appellate forum that hears the election tribunal. These are the plenary jurisdiction plus these two which can give such a declaration. There can be no declaration coming from the High Court. Any 199. That's what he's saying.
That's what I'm saying.
Proceed आगे क्या कहते हैं?
What I'm submitting is plenary jurisdiction for 162(1)(f) is only exercised by election tribunal. And Supreme Court in
आप दिखाइए ना, हमें लॉ से दिखाइए ना. आप show us from the law.
That's what I'm
Only show us from the law.
because PLD 2017
Read the Election Act to us, ROPA or Election Act.
a lot. रोका मैं आपको दिखाता हूँ.
Powers दिखा दें election tribunal.
My lord, are we going to ROPA first or Election Act first?
First, I'm going to the Constitution, and then I'll go to ROPA. And I'll refer the Election Act sections as well. Article 219 creates the election tribunal. It says duties of commission. The commission shall be charged with the duty of appointing election tribunals.
We come to the point.
Then Article 22 to 5, election dispute.
ये बात.
No election to a house or a provincial assembly shall be called in question except by an election petition presented to said tribunal and in such manner as may be determined by the Act of Parliament. Then Representation of People's Act, Section 52, which says how proceedings are initiated.
Representation of People's Act, Section 52.
My lords.
You've relied on 225?
I relied on 219 and 225. 219 for the creation, 225 for the dispute resolution exclusive power.
And 62 or what?
Section 52 of Representation of People's Act.
Okay.
No election shall be called in question except by an election petition made by a candidate for that election, hereafter in this chapter referred to as the petitioner. Then Section 57, appointment of tribunal. Who appoints the tribunal? For the election petition under the Act, the commissioner shall appoint as many election tribunals as may be necessary. Then
Aren't you undermining your own proposition when you rely upon Article 225, which is a very strong categorical language? No court. So how is the Supreme Court then can give a declaration under 62(1)(f)? Supreme Court, read 225 again. It's very categorical.
that's why I've submitted. Supreme Court can only give in its appellate jurisdiction coming from election tribunal against the decision of.
I think there are slightly two different propositions which you're mixing up. One is the competence or category of the court who can declare. First. Second is to what extent. For instance, in a civil suit, a civil court has jurisdiction to defeat the plaint, dismiss the plaint, right? Or anything in between, reject the plaint, or whatever. But it cannot tell the plaintiff to go and stand in the corner. That jurisdiction it doesn't have. Unless the law confers on it. Yes, you can ask the plaintiff to go stand and filing a frivolous suit. So let's not mix up the two concepts. Where if you read 225, it says no court, then that excludes the Supreme Court as well. Then the Supreme Court's power is only limited to acting as an appellate forum of the Election Commission of Pakistan or the Election Tribunal. Where will it get, where it is assuming additional powers from?
Because Section 67 of ROPA gives
67.
appeal lies to the Supreme Court. 67. G. Appeal from the decision of the election tribunal, it lies to the Supreme Court.
Please refer to that provision of the Election Act or ROPA, which says 62(1)(f) can entail a lifetime disqualification. वो कहाँ लिखा है?
मैं आगे आ रहा हूँ. आगे power of tribunal है, which says that
Where is that section?
आपके आर्ग्यूमेंट के मुताबिक तो प्री ट्रिब्यूनल ही कर सकता था ना, तो फिर आपके आर्ग्यूमेंट तो म्यूचुअली डिस्ट्रक्टिव नहीं है, व्हाट यू आर एक्चुअली ट्राइंग टू आर्ग्यू, मतलब कि सुप्रीम कोर्ट ने सही किया या गलत किया?
मैं कहता हूं सुप्रीम कोर्ट कर सकता है, डिक्लेरेशन दे सकता है ओनली इफ इट हैज अरीजन आउट ऑफ इलेक्शन ट्रिब्यूनल।
ठीक है, अभी जरूर
कैन नॉट गिव डिक्लेरेशन ऑन इट्स ओन।
हाँ, तो ये फिर तो आप यू आर नॉट सपोर्टिंग समीला बलोच, then you're not supporting Samila Baloch.
To some extent I am, because in most of the cases disqualification arose out of election tribunal. In some cases they arose out of writ jurisdiction. In some cases they arose out of pre-election dispute.
You are only supporting those.
I am only supporting those cases where they have gone through the trial.
Okay, ठीक है, I
They
got
have recorded evidence.
got that point.
I got the point.
ठीक है।
तो आप कहते हैं कि प्री इलेक्शन
चेंज
वो नहीं आ सकते,
वो नहीं आ सकते because there is no evidence recorded.
तो सिर्फ लिमिटेड हो गया ना, सिर्फ इलेक्शन ट्राइब्यूनल से जो अराइज कर रहा
My
है।
lord.
अब हम ड्यूरेशन की बात करते हैं।
मैंने बस ये क्लैरिटी आ गई ना, इसीलिए पूछा था आपसे कि जरा वो आर्ग्यूमेंट कुछ
मैं इसमें सेक्शन 64 में पावर ऑफ द ट्रिब्यूनल है, इट हैज ऑल द पावर ऑफ अ सिविल कोर्ट।
नहीं वो ठीक है, I got it now.
अब आगे मैं सिर्फ ये दिखा दूं, ग्राउंड्स फॉर डिक्लेयरिंग इलेक्शन ऑफ रिटर्न्ड कैंडिडेट वॉइड, दैट इज अंडर सेक्शन 68. व्हाट एन इलेक्शन ट्रिब्यूनल कैन डू, state of proper, that is section 68. The tribunal shall declare the election of the returned candidate to be void if it is satisfied that the nomination of the returned candidate was invalid, the returned candidate was not on the nomination day qualified for or disqualified from being elected as a member.
Wait a minute. On the date of submission of nomination paper, he was not qualified.
Yes.
So it means before presenting the papers, there must be some declaration that the person was not qualified.
A lot.
And in result thereof, his nomination papers should have been rejected straight away.
That can only happen.
It can happen at the first stage, when
That's
the
what I'm
nomination
saying.
papers are submitted.
That is that is also my
And
argument.
secondly, after election, post-election,
Yes.
the tribunal can de-seat the candidate on the basis that prior to election you were disqualified.
That is my second argument when I distinguish between Article 62 and Article
My
63.
question is whether under 62, whether somebody can be disqualified. Or 62 says if somebody is earlier disqualified, so his paper should be rejected.
He has to be earlier qualified on the date of the nomination paper.
So 62 does not clearly say that the person who is scrutinizing the documents has the power to disqualify somebody.
The date is the nomination date.
Many people understood that point.
My lord.
If I can just re-articulate my colleague's question, this 68, I've just run through it.
My lord.
It talks about disqualification.
My lord.
The nomination paper आपने दिया, I'm the returning officer or the election commission or the election tribunal, I say you're disqualified for you're 24 years of age, for instance, you can't contest election. ठीक है, you are a bankrupt, you can't contest election. You have not paid your bijli ka bill, you have not contested. You are not a graduate, etc., etc., etc. This paper gets rejected. Where is the power of the commission or the tribunal to say that you're disqualified for life? The next election comes along, you are disqualified in this election, you again present your paper. I again look at your papers, and again I find, no, you are not qualified for these reasons. How an earlier disqualification, suppose now I'm 25 years of age, suppose I filed 24, naturally I can't contest elections. Or I'm a bankrupt, now I'm not a bankrupt, or I'm a loan defaulter, I've repaid the entire loan, or I've not paid my electricity bill, I've repaid everything. So that will not travel through. Where is section 68 say that once disqualified, you're disqualified for life? Where is that provision? That provision has only been inserted by Samila Baloch.
That's what I'm saying, that for the time being, I am just arguing on one point, that is who can give the declaration of
I
disqualification.
agree with you.
First, there is no dispute. Second thing is, to answer my lord's question, I have to create a distinction between 62 and 63. That is my second.
No, first of all, where is the power in the court
in this court to do this? That is the essential question.
Court has to determine whether he was qualified on the day of nomination under 62, 63.
वो रिजेक्ट कर देना उसे, और अगर उसे गलत बयानी से किया उसको रिजेक्ट कर दिया, पर नेक्स्ट इलेक्शन जब आ रहा है तो हाउ इज ही स्टिल डिस्क्वालिफाइड, ये बताएं ना सिर्फ पॉइंट.
Now I will come to answer this question. I will come to my second.
देखिए एक आदमी ने एक रोपा में चेंज हुआ कि जी ग्रेजुएट होना चाहिए, एक ग्रेजुएट नहीं, उसने दरखास्त फाइल कर दी, वो मेट्रिकुलेट है,
He'll be disqualified. अगले इलेक्शन में ये कंडीशन है ही नहीं, तो he can't be a lifetime bar. It's illogical. That's what I'm saying. Article 62 में, if there is a declaration, that person is not honest. Why he was not honest? Because in my case, now you've taken a leap of faith. No, my lord. No. Again, अब आ जाती है बात ये leap of faith वाली. So you are saying honest. Now, honest. Suppose. Okay, let's take another case. Make it simple. He honestly declares in his nomination papers that he's a matriculate. He honestly declares in his paper that he's 16 years of age. Honestly, उसने लिखा 16 साल का हूं. Consequence तो वही होगा ना. If he is not 16 years of age, भाई वो कह रहा है मैं हूँ 16 साल का. If he is not 16 years of age and he is 14 years of age, अब बात नहीं समझ रहे हैं ना. 25 साल का सिर्फ लड़ सकता है ना इलेक्शन. वो सचमुच कहता है मैं 16 साल का हूँ, वो सचमुच कहता है मैं ग्रेजुएट ना हूँ. आप इसको नेचुरली कांट कंटेस्ट इलेक्शन. सो ये जो ऑनेस्टी और डिसऑनेस्टी वाली बात बिकम्स इररेलेवेंट. इट्स अ फैक्चुअल डिटर्मिनेशन. दैट्स व्हाट आई एम सेइंग. फैक्ट, हु हैज टू डू द फैक्चुअल डिटर्मिनेशन? ओके, आगे बढ़े. मैं ओनली इलेक्शन ट्रिब्यूनल थ्रू रिकॉर्डिंग ऑफ एविडेंस.
You understood the first point. We now move on to the next point, please. The duration part.
इसी पे देखें ना, जो फर्स्ट आपने कहा कि प्री इलेक्शन जो उसकी नॉमिनेशन पेपर की रिजेक्शन है, that does not cover the grounds mentioned in 68. वो तो होने ही आफ्टर द इलेक्शन है, आफ्टर द इलेक्शन. तो इसलिए वो तो जस्ट रिजेक्शन ऑफ द पेपर्स. दैट्स फॉर योर आर्गुमेंट्स. दैट इज व्हाई डेक्लेरेशन कोई फर्दर हिस्ट्री होगी.
वो क्वालिफाइड था या नहीं था पहली डेट के ऊपर, वो तो रिटर्निंग ऑफिसर ने चेक करना है ना. अगर रिजेक्ट होगा तो अपील हो जाएगी, अगर कोई अपोज करेगा तो भी अपील हो जाएगी. ठीक है ना. मगर बात क्वेश्चन इज दिस के आफ्टर सेवरल इयर्स वो कहेंगे इवन एट द टाइम ऑफ फाइलिंग योर नॉमिनेशन पेपर you were disqualified. That declaration is to be given by which court? Election tribunal. Election tribunal.
Understood that. Now I will let's proceed, brother. एक बात इसमें और बता दें. Election tribunal क्या disqualification 63 आर्टिकल 63 से हट कर दे सकती है, और कोई डिक्लेरेशन वो कर दे कि disqualified, और वो डिस्क्वालिफिकेशन 63 में नहीं आता. नहीं, क्या उसकी बुनियाद पर इवन फॉर सिंगल डे ही कैन बी बार्ड फ्रॉम कंटेस्टिंग. इलेक्शन ट्रिब्यूनल हैज टू डिसाइड ऑन द बेसिस ऑफ 62 फॉर क्वालिफिकेशन. नो, इट्स डिस्क्वालिफिकेशन. डिस्क्वालिफिकेशन इन 63. दिस इज क्लियर. If any declaration is made by the tribunal which is not in accordance with Article 63, they say even on the declaration of tribunal, somebody can be debarred from life or even for a day. No, my lord. Without trial cannot. When trial is conducted, the tribunal comes to even after trial it cannot. He can disqualify.
Without the ground given in 63, he cannot.
So, Khurram, could we just summarize what's happened? Your submission is that, first of all, disqualification can only come through a plenary court of plenary jurisdiction, plus the election tribunal and the appellate forum hearing that election tribunal's appeal. That's one, and declaration cannot come from any other source. मैं कुछ और कहना चाहता हूँ. So, this we've understood. I'm just saying that the premises on which Samuel Baloch proceeds is that once that declaration is in the field, that you're disqualified. Unless that declaration is set aside, you remain disqualified. That's the premise of Samuel Baloch, number one. Number two, Samuel Baloch also says that declaration is not right in your face, saying that you infer from the circumstances of the case. For example, वो कहेंगे कि आपने misdeclaration की है, इससे infer कर रहे हैं आप honest नहीं. Because nobody is directly इस पे evidence नहीं ना आप honest, I mean आप infer कर रहे हैं. That's what Samuel Baloch also says. So you construct it, you say कि आपका form गलत था, आपका ये गलत था, इससे हम कंस्ट्रक्ट ये करते हैं कि आप अमीन नहीं हैं. These are the two premises on which Samuel Baloch proceeds. Now we just need to understand whether at all the fact that the disqualification stands, can continue forever, and if that disqualification was taken into a criminal proceedings and he went through H63H and went through a actual conviction, he comes back. And there are a number of other offenses where he commits even a heinous crime, he comes back. तो बस इसका हमें आप बताइए कि the fact Samuel Baloch goes on the premise that declaration on the civil side done will continue as long as that declaration is set aside.
My lord has properly rephrased Samuel Baloch, but my argument is a bit different from that. My argument is any declaration coming from a high court in a constitutional
We
jurisdiction.
understood, that's not a declaration, so that's all the declarations are out. Only court of plenary jurisdiction is elected. Understood. Now, the whole argument revolves around whether Article 62 and 63 are inherently same or distinct. If they are inherently same, they can be used interchangeably. Then we can interpret 62(1)(f) in view of 63(1)(h). But if they are distinct, then we cannot interpret these two. We cannot try to resolve the ambiguity. So I have to demonstrate that Article 62 is distinct than Article 63. Is it not dependent? Article 62 is not dependent upon 63. No, my lord. How do I demonstrate that? If I just go to Article 62, it says, a person shall not be qualified to be elected or chosen as a member of Majlis Shura unless it talks about an event prior to the election. Yes. Yesterday. Hello, 63.
Yes, I don't see much turning on your point, but shall I proceed with it?
A person shall be disqualified from being elected or chosen as and from being a member of Majlis Shura if in 63 after the election, after the he becomes member, the event, any of the event given in 63 can trigger and he can be disqualified. But in 62, after he had election, no event subsequent to the nomination can disqualify him.
I don't agree with you, because if that is the case, then a non-citizen can contest elections, which is not provided for in 63, which is only provided for in 62. So I don't think you have a distinction draw here. I don't think anything turns on it. My lord, 62, it says he is a citizen of Pakistan. This provision is not found mentioned in 63. Suppose a non-citizen files a nomination papers and somehow gets elected. So you mean to say that challenge cannot be made about him? I would not agree with that proposition, my lord.
Because the entire section of 62 has to be read in view of the opening clause. It says, a person shall not be qualified to be elected or chosen.
Court where he was declared non-righteous.
So what are the likelihood?
No, ye baat aapki, sorry, doesn't hold any water. Let's read first disqualification. He is a citizen of Pakistan. Suppose Mr. James Gray from America comes and contests, born American citizens, never been a Pakistani citizen, and gets elected. Please wait. Now go to 63(1)(c). He ceases to be a citizen of Pakistan. That is, a person was a citizen of Pakistan, has now taken on citizenship of America. So you are saying, yes, once that somehow Mr. James Gray got elected, you can't touch him now. ये sorry to say, ये आप ऐसा distinction not draw करें.
I am not saying
Mr. Khurram, there's one way of looking at it. Just read the first line of 62 and the first line of 63. It will show to you that it's interchangeable. There is hardly any difference. A person shall not be
qualified.
to be elected. रुक जाएं, आप 63 पढ़ें.
A person shall be
disqualified.
From being
person
elected.
shall be disqualified.
From being elected. So
From
both
being
are
elected.
happening before the election has taken place.
Elected
The
or
word is-
chosen.
हाँ,
वही बात.
दोनों चीजें एक है,
फर्क नहीं पड़ना.
disqualified or qualified है, but it's synonymous. I mean, it makes
मतलब 63 के जो second तो फर्क क्या पड़ना है इस argument से आपके? How will it support you?
So because if I can convince my lordships that they are two distinct sections because of their,
Because there are two distinct sections, but what will turn on it? ये बताएं ना.
then we have to interpret 62(1)(f only.
अरे वही उसी पे तो आप आपको ले जा
And
रहे
we
हो.
do not have to interpret 62(1)(f in view of 63(1)(h.
चलें 62(1)(f) को कर लेना फिर आप.
आपका आर्ग्यूमेंट ये है कि 62 and 63 are distinct articles and we cannot interchangeably read them to give them a meaning.
My lord.
So उनको separate पढ़ेंगे, इनको separate. We've understood your point.
आगे बढ़े. थोड़ा सा स्पीड कर ले फिर. We don't want to leave this case unresolved.
10-15 moments. Now, when I distinguish that they are two distinct, then we have to read 62(1)(f) on its own. Every word has to be given its meaning.
चलिए चलिए थोड़ा जल्दी करिए.
Is that when we will read 62, then as long as the declaration by a court of law is in field, disqualification will remain.
Court of law declaration is the Supreme Court itself. ये point पे आ जाइए ना.
Supreme Court itself cannot give in any other jurisdiction other than in its appellate jurisdiction.
हो गया ना
from the elected tribunal.
चलो अच्छा
तो आपका फिर समीला बलोच वाला आर्ग्यूमेंट है ना कि once the declaration is there, 62(1)(f) has to be read alone. Once the declaration stands, disqualification stands.
My lord.
And it goes on as long as the disqualification. So the question to you is that we have to look at the Constitution in totality as a whole. Does it not appear odd to you that for other crimes as big as perhaps treason in G and others, you can always come back and contest election? It's not a lifetime situation. But for a civil wrong, which could be as small as committing a misdemeanor of misdeclaration or just lying through omitted one entry in a return, the punishment in a way is for life. But if I were to go murder somebody, if I would commit treason, if I were to kidnapping, I could come back and contest election.
Where from the tribunal gets the powers for life time disqualification?
It has declared.
No, where from gets the powers to declare him
Has
for life?
declared a decree given remains intact for all purposes.
आगे बढ़े.
Now,
next point.
now this argument basically it lies in basically Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is wherever mens rea is dishonesty, we are talking about public office holder.
जो आपने you just very casually referred to Islam, either back it up because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam. And then they became Khalifs, Khulfa Rashideen. वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है। और शुरू में तो 2-4 ही मुसलमान थे।
I mean, we are.
तो ये आप ऐसे जस्ट डोंट थ्रो इन इस्लाम टू गिव इट वैलिडिटी।
No, my lord. What I am submitting is, if repentance or tawbah, when we look at it,
रिपेंटेंस और तौबा की तो बात से आगे मैं चला गया हूँ।
so that's what I am submitting.
These are three things kept by God to himself. Number one,
Not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No submission, you refer to the Holy Quran. You can't just make a submissions contrary to Islamic principles like this. ऐसे नहीं होगा।
Could I change the subject? Let me just introduce one other aspect. Let's stay on 62(1)(f). If you look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all this is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification under declaration of contrary under some law. And if the law parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law. And law has been corrected and given a period. So there's a distinction. Had there been a constitutional provision disqualification like age being 25, then perhaps to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on the validity of the law. That's why I tried to argue that under what proceedings we are before my lordships. I rely on PLD 2012 Supreme Court 923, Baz Muhammad Kakar Federation of Pakistan. It is the case where Contempt of Court Act 2012.
सारा आर्गुमेंट सुना हुआ है, proposition बता देना please.
My proposition is through ordinary law. Parliament cannot amend the Constitution.
No, fair enough. That's not amended. That's what I'm trying to tell you.
Edit in the Constitution, because how do I demonstrate
Whether the court can amend the Constitution,
court can interpret it?
interpret in a manner to amend the Constitution or to read into the Constitution. So this is what we are asking from you, whether the interpretation can be done. देखिए इसमें एक बात आप ये आप कह रहे हैं 62(1)(f) में ये बताया गया है कि डिक्लेरेशन होना चाहिए कोर्ट से, और आपने कहा कि डिक्लेरेशन सिर्फ ट्राइब्यूनल दे सकता है। ट्राइब्यूनल अंडर सेक्शन 157 वो ग्राउंड्स बताए गए, ठीक, क्या उन ग्राउंड्स में ये बात है कि ट्राइब्यूनल इस बात पे आपको डिस्क्वालीफाई कर सकता है कि आप राइटियस नहीं हो, आप सजेसिव नहीं हो, आप अमीन नहीं हो, आप सादिक नहीं हो? ऐसी डिक्लेरेशन आएगी तो 62(1)(f) इस्तेमाल होगा, अदरवाइज नहीं होगा।
That's what I'm saying. That in my case, FA degree was forced, BA degree was forced. Trial can आप हमें डिक्लेरेशन कहाँ से आया? आप
देखिए खुरम साहब एक चीज है, देखिए speaking for myself, there is no confusion in my mind that to set aside a judgment, the premises on which that judgment stands needs to be taken away. So if the judgment stands on a law, then there could be an amendment in the law, and that foundation of that judgment on which it stands is taken away and that judgment is nullified. If the judgment stands on the Constitution, constitutional amendment is required to take care of. There is no, as far as I'm concerned, no. I'm saying in this particular case, 62(1)(f is not a disqualification. The judgment does not stand on 62(1)(f as such. It stands on a declaration by a court of law.
My lord.
That declaration is not done through constitution. That declaration must be of based on some law. That law now provides a period of 5 years for such declarations. Hence, that premise, that declaration that's coming out of a law has been given a period. So wo khatam ho jati baat, 5 years then plugs that problem.
Election tribunal has to determine on the basis of qualification, disqualification given in Election Act as well as 62, 63. Why I am saying this, I have also appended parliamentary debate from Senate on the amendment. It's at page 28. They have admitted it's silent. Once they have admitted it's silent, the only requirement
It is admitted is silent. What does this mean?
I mean, in parliamentary debate, which we can look into.
So why don't you look at the constitution itself? I don't know. देखिए ये from Hebdo. You know what Hebdo was?
My lord.
One dictator,
My lord.
throwing out everybody,
My lord.
followed by another dictator, throwing out everybody, followed by a third dictator, throwing out everybody. Are you forgetting all these things? No, please, एक second है ना. The constitution, original constitution did not have these D, E, F, G clauses.
My lord.
These are imposed by a dictator, correct or not correct?
Right.
And why you give it no importance? Either say we support dictatorships. Hang on, ऐसे नहीं होगा ना. We can, जरा बात तो सुनिए ना. आइन का तकद्दुस उसी वक्त होगा जब हम उसका तकद्दुस मानेंगे. या हम कहते हैं हम बंदूक का तकद्दुस मानते हैं. जब पार्लियामेंट में जो 326 लोग बैठ करके कानून साजी कर रहे हैं, जो आप 326 से पहले कम होते थे, वो एक कानून साजी कर लें और उन्होंने ये किताब हमको बना के दे दी और फिर एक शख्स टहलते हुए आते हैं, वो कहते हैं बाहर जाए कॉन्स्टिट्यूशन, मैंने एब्डो कर दिया. तमाम पाकिस्तान के सियासतदान इंक्लूडिंग माय फादर वाज डिस्क्वालिफाइड बिकॉज ही हैड द मिस्टेक ऑफ हेल्पिंग मेक पाकिस्तान. But a general, you prevailed over everyone. You are not even attending the constitutional thing. You are supporting everything done by a military dictator, having precedence. Now show us this thing. Then the next dictator comes along and says, no, I introduce graduate condition. The third dictator comes along and says, no, I introduce Sadiq, Amin, righteous, profligate. अगर देखिए एक कॉन्सेप्ट है मुनाफिक का कॉन्सेप्ट. मुनाफिक काफिर से बुरा होता है मेरे हिसाब से. काफिर को तो पता नहीं रोशनी है नहीं. काफिर कुफर का मतलब है खिलाफ. ठीक है, उसको पता नहीं. मुनाफिक को पता हो क्या करता है. अपने ऊपर क्यों नहीं कंडीशन डाल दी है आई विल नॉट बी नॉन प्रॉफिलिगेट अमीन वगैरह. ये चीजें पिक एंड चूज करना, किसी को उठाना, किसी को फिट करना, ये बातें. व्हाई यू नॉट अटेंडिंग द लार्जर कॉन्स्टिट्यूशनल डिबेट? यू ट्रीटिंग दिस एज अ सिविल सूट. You are saying a disqualification by a military dictator, a rapist can contest elections, but a person who makes a mistake, उसमें ये भी लिखा है कि कितने तोले सोना आपके पास है. ठीक है, आपने 6 लिख दिया, मालूम आपके पास 8 थे, तो यू आर डिस्क्वालिफाइड. आप आज हमारे सामने खड़े हुए हैं, हम आपको होल्ड करते हैं कि बुरा न माने कि यू आर अ प्रॉफिगेट, यू वेस्टेड द टाइम ऑफ द कोर्ट. कल आप इलेक्शन में तक नॉमिनेशन पेपर आएंगे, आप कहेंगे देखिए ये जजमेंट लगा हुआ है सुप्रीम कोर्ट, ही इज डिक्लेयर्ड बाय द कोर्ट ऑफ लॉ टू बी अ प्रॉफिगेट, ही वेस्टेड द टाइम ऑफ द कोर्ट, यू आर डिस्क्वालिफाइड. So let's not forget the small things. We start focusing on small things. Look at the larger picture. Look at the context in which these amendments are brought into the Constitution. Look at Article 225. उसको आपने totally नजरअंदाज कर दिया है. Except you're not even saying a word about Article 225. It says no court shall. वहां आप कहेंगे सुप्रीम कोर्ट नो कोर्ट में नहीं आएगा डेफिनेशन में, यहाँ कोर्ट में आ जाएगा. तो ये जरा आप जरा टोटलिटी में बात कीजिए.
Let me submit. I was referring to, if you look at the amendments, 62(1)(f) was amended.
First of all, is it a good amendment?
It was amended.
I'm asking your opinion.
I'm talking about 18th amendment.
I'm asking your opinion.
85 not good amendment, but
62(1)(f) is good.
I'm talking about 18th amendment.
या उसको छोड़ दीजिए, अमेंडमेंट भी तो गन पॉइंट्स पे हुए हैं, क्या बातें कर रहे हैं? वो लोगों ने कहा कि चलिए आधी जमहूरियत आ जाए पूरी से तो बेहतर है। मतलब प्लीज आप देखिए ना, मिलिट्री डिक्टेटर्स के सामने आप लोग कोई बात ही नहीं करते हैं।
आप सवाल के जवाब दें, आप खुद में फिर जो कहना चाहते हैं, जो सवाल के जवाब आप कर रहे हो।
I agree with you. I am against dictatorship. I am for the constitution.
Reflect this in your arguments.
What I am submitting is when they amended and added a law, court of law, declaration by court of law in 62. At the same time, they added 10A.
ये तो पार्लियामेंट ने किया,
ये भी पार्लियामेंट ने किया 18th amendment में.
18th amendment is a validation. Please don't equate it with amendment thought out by the parliamentarians. जितनी भी आप उनको हकारत की नजर से देखेंगे वो हमारे elected representative होते हैं, ठीक है? उनकी एक cumulative wisdom है. Surely it prevails over the wisdom of a military dictator.
My lord.
So why are you disregarding the wisdom? Why is the constitution being just, if it's a dictator, we cannot touch it. ये नहीं करें ना, आप मजीद पॉइंट आर्ग्यू करें.
I am submitting my arguments on the basis
अच्छा,
of...
नेक्स्ट पॉइंट बताएं, क्योंकि you're not making headway now, you stopped.
My lord, the next point is that when they brought in amendment in section 232 of the Election Act, during the parliamentary debate, it was admitted that Article 62(1)(f) is silent regarding period of disqualification. I have appended a copy of Senate's proceedings, which says
We don't need to, it's obvious it's silent.
it's silent.
Yes.
Now my submission is, once they have admitted that it's silent, they have to bring in constitutional amendment.
So let's put it another way.
My lord.
Suppose we say 232 is not good law.
My lord.
And we also hold that judgment of the Supreme Court is also not good law.
My lord.
Then there is no disqualification at all, not even for a day.
My lord.
Yes?
Yes. Then they have to amend.
So you say the wisdom of 5 gentlemen sitting in this courtroom overpowers the wisdom of 326 parliamentarians sitting on in the next building. For what reason? Give us a reason. Give us some logical reason. I mean, just because it said so. That's all.
Parliament had the power to fix 5 years in Article 62(1)(f).
बात ही समझ
But
रहे
they
हैं.
did not.
अच्छा, चले आगे बढ़े ना, थोड़ा डिबेट को आगे ले चलें.
अगर इंटेंशन होती है लेजिस्लेचर की, वकील साहब, अगर लेजिस्लेचर की इंटेंशन होती कि कोई सजा होनी चाहिए, जैसे 63 में बताया गया कि अगर किसी भी ऑफेंस में कन्विक्शन हो, कन्विक्शन पूरी होने के, सेंटेंस पूरी होने के बाद 5 years और 3 मुख्तलिफ बताए, 5 years 3 years, उन्होंने पीरियड बता दिया. तो क्या इनका इंटेंशन नहीं था कि यहाँ पे पीरियड ना बताने का, सिंपली
If they had the number and the intention, they would have expressly mentioned it in 62(1)(f). Like they did.
why not we should consider it as positive कि इसके कोई सजा ही नहीं है, तो कह दिया कि फलां शख्स झूठा है, बस that's all. या प्रिज्यूम किया जाए हर शख्स सच्चा है unless proved to the contrary. ये अल्फाज भी नहीं है. हर शख्स क्यों प्रिज्यूम करें कि वो झूठा है जब तक वो साबित.
The Constitution is silent about period of disqualification. Which constitution?
पिछले next point पे चले ना, you are repeating yourself now.
So your second
A
argument.
lot of people to be heard. थोड़ा speed it up, please.
The constitutional amendment would have done this.
That is my submission, only constitutional
We understood
amendment. And I support this argument with this thing as well. In Article 62, they have given various period of disqualification. 3 years, 5 years, 4 years, depending on the gravity as Parliament thought at that time.
Repeat yourself. ये आपने repeat yourself. I didn't understand.
Article 63 has given 3 different periods of...
So I can just pose you a question. If in Samula Baloch, if in Samiullah Baloch, I'm writing now the judgment of Samiullah Baloch, imagine it, and I say that 62(1)(f) does not prescribe the period of disqualification. However, I will see the other provisions of the Constitution and say that since for treason it's only 5 years disqualification, I think this is a lesser crime and I put 2 years. Suppose it would be as valid a judgment as Samiullah Baloch, correct? For no logical reasoning. It is what I decide. I have to base my decision, a constitutional interpretation on some logic. Either you should say I would be wrong in saying 2 years because you just picked out a number from your head. It could be 3, it could be 4, it could be lifetime. Please address this query.
But there could be only 2 possibilities.
No, why not 2 years? I write Samiullah Baloch and say 2 years.
It's not written there.
Exactly. So it's all up to do with my mind.
But it's
Nothing to do with the Constitution.
It's not written otherwise as well.
चलिए मगर ये आप इसको अटेंड करें ना
If it's silent, that means understood your point. Until it's in field.
तो अगला point
This larger bench can revisit its own judgment. This larger bench can revisit its own judgment. Let's reinterpret.
Election Amendment Act 2023. Now my submission is if we are in 187, then I can object on the vires of Election Act 2023. If we are only in appeal, then we cannot argue on the vires of the Election Act.
तो वैसे चैलेंज नहीं करते उसे. You have not challenged worries of 232.
That's not the question of Why of 232 is not.
Nobody has challenged the varies in the High Court or in this court.
My lord, it has been challenged in the High Court. I've given you the
They have
petition.
not been decided yet.
My submission is, if we, because my lords have combined all these appeals along with section 124(3) petition. So my understanding, the way
Your understanding should be found. The answer is in the order, the first order that we passed. Since election are scheduled for 8th of February, one returning officer will do one thing, another officer will do one thing. There should be clarity. It's as simple as that. Now, if you want utter, total confusion in Pakistan, that every constituency, one returning officer is saying, I will follow 232, another returning officer will say, I will follow Samiullah Baloch. So we have stated very clearly, we want clarity, one way or the other. The returning officer is not a competent lawyer as yourself, it's maybe a bureaucrat, so give him clarity. That's all we are doing.
That's what I'm submitting before my lordship. While you are hearing this, you have also issued notices under section 27 or order 27A to all the Advocate General and Attorney General.
The whole of Pakistan we issued notice.
You might as well decide upon the vires of this thing.
चलें वो भी कर लेंगे आप बता दें अनकॉन्स्टिट्यूशनल है.
That is my submission.
Unconstitutional.
मैं कहता हूँ इस unconstitutional. I rely on Mohammed judgment.
एक बार बताएं कि आप कह रहे हैं कि ये क्लियर पार्लियामेंट ने खामोशी इख्तियार की 62(1)(f) में कुछ बताया नहीं, उसको हमने इंटरप्रेट किया. अब हमारे बाद पार्लियामेंट ने इंटरप्रेट कर दिया. क्या पार्लियामेंट का विजडम हमसे ज्यादा है या कम है एक कॉन्स्टिट्यूशनल प्रोविजन को एक्सप्लेन करने के लिए, इंटरप्रेट करने के लिए? किसके इख्तियारात ज्यादा, ये बताएं.
Parliament has to frame, my lord has to interpret.
They have framed the law,
They have framed
the law,
They had to
interpret the constitutional provision. उन्होंने कह दिया कि ये हमारा विजडम था.
They had to frame it under 239, 238, 39. They had to bring in constitutional amendment.
आप लिखा दे बास काकर की citation लिखा है 2012.
PLD 2012 Supreme Court 923.
And what paragraph are you relying for the
Para 50.
for declaring the law ultra vires?
Declaring the law ultra vires.
लेजिस्लेटिव एंट्रीज के ऊपर वो केस है, उसके अंदर तो उन्होंने होल्ड किया है कि लेजिस्लेटिव एंट्रीज जो
Thank you. Anything else? Huh? Sorry, we are giving you a tough time, but we want sometimes tough questions help us resolve our own difficulties we are having in understanding things. Thank you
very much for giving patience.
Many, thank you very much. Who will next? Amicus को हम पूछ लें या आपका?
नहीं, आपकी कैटेगरी में जो
आप आते ही उस्मान साहब आ जाइए, और सब्जवारी साहब कहाँ हैं?
सब्जवारी साहब।
सब्जवारी साहब पहले करेंगे या आप करेंगे? एक सेकंड, ही सीनियर, वी लास्ट हिम फर्स्ट। सब्जवारी साहब, आप जो मजीद पॉइंट्स ऐड करना है तो आप कर दें।
My Lord, I gratefully adopt the arguments of my friend, and my case is also.
हाँ, बड़ा अच्छी तरह से आर्ग्यू किया।
जी सर,
जी।
I owe an explanation, my Lord, clarification.
थोड़ा सा माइक की तरफ आ जाए। माइक, हाँ।
While gratefully adopting his arguments, I want to offer an explanation, clarification, that in my case of Mr. Muhammad Kashif, that is, my Lord, CP number 2680 of 2021. I am questioning the order of the returning officer who found him disqualified because he had relied on a fake degree in past. The returning officer's verdict was set aside by the tribunal by an appropriate judgment. Dated 4 of May 2023 at page 9 of the paper book, my Lord. Then a writ petition was moved, and in that writ petition, the order of the tribunal was set aside and that of the returning officer was restored.
Zawari Sahab, you support the lifetime disqualification?
My Lord, I am telling that what is the point involved in my case. In fact,
सब्जारी साहब, जरा सा आपके लिए मैं वजाहत कर दूं और बाकी लोगों के लिए मैं वजाहत कर दूं। हम इंडिविजुअल केसेस 5 ईयर बैन है, नो बैन है, या समीउल्लाह बलूच लाइफ टाइम बैन है, तो अब उसके कॉन्सिक्वेंसेस नेचुरली विल फॉलो जो भी डिसीजन होगा, बिकॉज वी आर द सुप्रीम कोर्ट एंड एवरीवन हैज टू फॉलो आवर डिसीजन। तो हम आपके इंडिविजुअल केस, आप बुरा ना माने, हम उसमें टच नहीं करना चाहते हैं, क्योंकि हो सकता है आपकी और भी प्लीज हो वो
फिर ज्यादा सुनेंगे
जी।
ठीक है जी, फिर तो
बराबर हम सिर्फ वो आईनी नुकता और कानूनी नुकता देखना चाह रहे हैं।
मेरे फादर दोस्त ने,
तो आप उनको सपोर्ट कर रहे हैं?
उनको सपोर्ट करता हूँ। एक थोड़ी सी बात ये कहता हूँ
जी जी,
कि the original constitution framers could provide the time limit also in 62F.
तो F था ही नहीं ओरिजिनल में।
कर रहे हैं ना सपोर्ट।
18th amendment, they could do so. Amendment. As far as the amendment, your lordship were very rightly pointing out that was brought by a dictator in it. But then there were subsequent parliaments. And
ये बात सही है आपकी, ये बात सही है।
और फिर वो माइनॉट जो आया है 62 में अमेंडमेंट किया है 2010 में, उसमें कंट्रेरी कोर्ट किया।
ये बात आपकी सही है बिल्कुल।
दूसरी ये है कि ये जो इंटरप्रिटेशन हुई है, मेरे फादर दोस्त ने उस पर बहुत अच्छा एड्रेस किया जी, कि जो वो जजमेंट आई है दैट इज जजमेंट लॉ। सिंधी साहब के केस में जजमेंट लॉ, और जजमेंट लॉ जब आ गया तो वो उसको जब उसके कॉन्स्टिट्यूशनल इफेक्ट होंगे तो कॉन्स्टिट्यूशनल अमेंडमेंट से वो हो सकता है, इससे नहीं हो सकता। बाकी मेरी सबमिशन ये है जी कि जो डिस्क्वालीफाई हुए हैं, जैसे मैं हुआ हूँ, जहांगीर तरीन साहब है या कोई दूसरे हैं, वो चूंकि विदाउट ट्रायल हुए हैं, विदाउट प्रॉपर इंक्वायरी हुए हैं, विदाउट एविडेंस हुए हैं।
आपके क्लाइंट डिस्क्वालीफाई हुए हैं
जी, उसके पेपर रिजेक्ट किए हैं
लाइफ टाइम
जी। नहीं, इस केस में एक इलेक्शन था जो
तो आप उनको पर क्यों सपोर्ट कर रहे हैं खुर्रम रजा साहब को?
खुर्रम रजा साहब को तो
आप कह रहे हैं आपके क्लाइंट डिस्क्वालीफाई हुए हैं। या आपका मुखालिफ डिस्क्वालीफाई?
नहीं नहीं, मेरे क्लाइंट डिस्क्वालीफाई हुआ।
तो आई एम कंफ्यूज देन व्हाई यू?
मैं ये कहता हूँ ना जी कि वो जो पोजीशन है कि वो पूरी इंक्वायरी होनी चाहिए, जो दो
लाइफ टाइम को आप सपोर्ट करते हैं, आप कहते हैं कि अगर इंक्वायरी होती तो आपका क्लाइंट
मैंने सर कर दिया। जो अल्लाह बीनू केस है और जो केस है उसका सरदार,
आप कह रहे हैं कि आप असूली मौके इख्तियार कर रहे हैं इवन दो आपका क्लाइंट डिस्क्वालीफाइड हुआ है। मैं समझ गया आपकी बात,
क्योंकि वो बेसिकली डिस्क्वालीफाइड नहीं है, ये है जी। और दूसरी ये है जी कि ये जो है ना, इसमें जो चीजें जिक्र की गई हैं, होनी चाहिए।
एक बात आपसे पूछ रहे, ये जो आप कहते हैं डिग्री जाली डिग्री थी,
रिपीट ना कीजिए, पॉइंट बाय पॉइंट बताइए जी, जल्दी बताएं।
माय लॉर्ड,
आप उनके आर्गुमेंट्स अडॉप्ट कर रहे हैं या नहीं?
माय लॉर्ड पार्टली अडॉप्ट करूं लेकिन मुकम्मल नहीं
जी।
मैं पहले अर्ज करूंगा डिक्लेरेशन के बाद।
नंबर बताएं केस का।
मेरा नंबर है जी
984
और 2018 में।
आपकी मुखालिफ आप रिस्पोंडेंट है, अपेलेंट है?
एपिलांट हूं माय लॉर्ड।
अच्छा, उन्होंने क्या किया है जिसके खिलाफ आप आए हमारे पास?
उन्होंने मैट्रिक अपने आप को डिक्लेयर किया 2018 के इलेक्शन में।
अच्छा, तो आप डिग्री वाला केस
पहले
चलिए, अब आप लीगल कॉन्स्टिट्यूशन बात करें।
199 के हवाले से मैं अर्ज करूंगा, जो डिक्लेरेशन का क्वेश्चन है कि डिक्लेरेशन 199 के तहत ये मेन फीचर है आर्टिकल 199 का, विदाउट डिक्लेरेशन एंड डिक्लेयरिंग एनीथिंग सुप्रीम ऑनरेबल हाई कोर्ट या सुप्रीम कोर्ट का ऑर्डर पास ही नहीं कर सकती। ये राय नहीं सुनाइएगा 199 में मालूम
जी।
पहला मालूम सबसेक्शन सब क्लॉज 1 में पढ़ूंगा, सब्जेक्ट टू द कॉन्स्टिट्यूशन द हाई कोर्ट में इफ इट इज सेटिस्फाइड that no other adequate remedy is provided by law. Now I'll go to Roman 2. Declaring that any act done or proceeding taken within the territorial jurisdiction of the court by a person performing function in connection with the affairs of the federation, a province or a local authority has been done or taken without lawful authority and of no legal effect. Secondly, my lord, अब सी जो बी का रोमन 2 मुलादा फरमाइए।
उस्मान साहब, ये डिक्लेयर कर देगा कि ये आपका नॉमिनेशन पेपर गलत है या आपकी डिक्लेरेशन गलत है।
जी मालूम,
इतनी हद तक ही कर सकते हैं ना डिक्लेयर?
नहीं मालूम, मैं अर्ज ये कर रहा हूँ कि एक तो मैंने एक एस्पेक्ट बताया,
ये डिक्लेरेशन तो उसके लिए है कि एनी पर्सन परफॉर्मिंग फंक्शन इन कनेक्शन विद अफेयर्स ऑफ द फेडरेशन।
जी मालूम,
सरकार के खिलाफ
के लिए, आम आदमी के लिए।
मैं अर्ज कर रहा हूँ, मैं पहला सवाल ये था मालूम का डिक्लेरेशन क्या 199 के अगला मालूम देखिएगा, इसका रोमन 2 देखिएगा बी का
जी।
On application of any person made order requiring a person within the territorial jurisdiction of a court holding or purporting to hold office to show under what authority of law he claims to hold that office. ये भी declaration इसको subsequently होगी, वो भी जो
वारंटों के जुरिस्डिक्शन में है ना, अभी तो हाई कोर्ट एक्सरसाइज कर सकता है ना।
हाई कोर्ट मैं यही कह रहा हूँ, हाई कोर्ट को वारंट जब इशू करती है तो डिक्लेयर भी करती है साथ, सिर्फ ये नहीं कहती कि आप
This is the original jurisdiction of the High Court under Article 199. Writ of co-warranto can be issued by the High Court.
जी मालूम,
This is the only declaratory power यही है।
मालूम बिल्कुल ठीक है, यही पावर ऑनरेबल सुप्रीम कोर्ट को भी 184(3) में है।
चलिए मान ले,
आगे बढ़े, आगे मैं अर्ज करता हूँ मालूम,
इसको आप देख ले, मान लेते हैं ये बात है, तो हाईकोर्ट के सामने कोई डिग्री होगी, कोई डिक्लेरेशन होगी, तो हाईकोर्ट का हाउ यू आर होल्डिंग द ऑफिस,
तो मतलब यही मैं अर्ज कर रहा हूं, अगर उसके बाद लाजमी नहीं इलेक्शन लॉज के अलावा भी या इलेक्शन लॉज
ठीक समझे, आगे बढ़िए,
आगे देखिएगा, मैं दोबारा आऊंगा मालूम ए का सब जो क्लॉज रोमन 1 है मालूम, on application of regular party make an order directing a person performing within the territorial jurisdiction of the court functions in connection with the affairs of federation, a province or local authority to refrain from doing anything he is not permitted by law to do or to do anything he is required by law to do without declaring that what is the function of the person who is acting under the federal law or the provincial law. ये declaration नहीं हो सकती, ये order नहीं हो सकता। इसका मतलब ये है कि declaration इनबिल्ट है इसमें। और इसी तरह देखिएगा मालूम बी का
ऑर्डर्स चैलेंज होते हैं 199 में, जो पर्सन परफॉर्मिंग फंक्शंस इन कनेक्शन विद द अफेयर्स ऑफ फेडरेशन और प्रोविंसेस, उनके ऑर्डर जिसके अंदर कोई एडिक्वेट रिलीफ रेमेडी नहीं होती है, वो रिट में डायरेक्ट
इसी तरह आप देखिएगा
राइट ऑफ अपील दी हुई होती है तो पहले अपील ही जाते हैं।
बी का 1 देखिएगा मालूम आप, इसमें प्राइवेट पर्सन की हेबियस कॉर्पस के वाले वो भी डिक्लेयर होगी कि दैट इज इलीगल
आप सबसे पहले 191 के ओपनिंग वर्ड्स पढ़ ले, when there is no remedy।
मालूम बिल्कुल ठीक बात है।
इलेक्शन लॉस में
अब काइंडली सी बुलाता फरमाइएगा। बी, ये जो सी है मालूम, ऑन एप्लीकेशन ऑफ एनी एग्रीड पर्सन मेक एन ऑर्डर गिविंग सच डायरेक्शन टू एनी पर्सन और अथॉरिटी इंक्लूडिंग द गवर्नमेंट। अब गुजारिश ये है कि ये डायरेक्शन भी विदाउट डिक्लेयरिंग कि ये आपकी जिम्मेदारी है, ये आप करने पे फेल हुए हैं।
बताइए,
पॉइंट ये है मालूम,
आप हमें इसे पढ़वा रहे हैं।
पॉइंट ये है कि डिक्लेरेशन के बगैर, मतलब डिक्लेरेशन दिए बगैर हाई कोर्ट 199 की पावर एक्सरसाइज नहीं कर सकती।
ठीक है, ओके,
और किसी कहीं
इससे हमारे केस का क्या ताल्लुक हुआ?
इसमें क्वेश्चन जनाब ये पूछा गया था कि क्या डिक्लेरेशन हाई कोर्ट प्लेनरी जुरिस्डिक्शन की कोर्ट के अलावा कोई दे सकता है या नहीं दे सकता? मेरी हम्बल सजेशन ये है,
ठीक है, दे सकता है। चले आगे बताएं, आगे बताएं।
अगली बात देखिएगा कि सेक्शन जो आर्टिकल 62(1)(f है मालॉर्ड, एक सवाल मालॉर्ड ने ये पूछा था,
दो में डिफरेंस क्या है 62 और 63?
मैं इधर यहाँ मैं खुरम साहब से डिसएग्री करूंगा मालॉर्ड। अगर सब आर्टिकल 2 मुलाजा फरमाइएगा ना 62 का ही, उसमें क्वालिफिकेशन का नहीं, उसमें डिस्क्वालिफिकेशन का जिक्र है। यानी डिस्क्वालिफिकेशन हो या क्वालिफिकेशन हो, उसका मकसद एक ही है, चाहे वो प्री इलेक्शन डिस्क्वालिफिकेशन।
आई पर्सनली एग्री विद यू।
मतलब सब आर्टिकल 2 बड़ा बात है, ठीक है।
हाँ, आगे
जी मालूम,
उसको तो हमारे इंटरचेंजेबल है ना
जी, इंटरचेंजेबल, क्योंकि सब आर्टिकल 2 जो है वही वादे तौर पर कह रहा है।
सही है।
अब माय लॉर्ड, जहां तक ये बात है कि सेक्शन 9 की जो ओवरऑल जो जुरिस्डिक्शन मतलब कोर्ट्स एक्सरसाइज करती हैं, सेक्शन 42 में करती हैं, या कोई और लॉ भी है जिसके तहत वो डिक्लेरेशन की डिग्री ग्रांट कर सकती हैं। और मेरी हम्बल सबमिशन ये है कि सेक्शन 9 ऑफ द सीपीसी जो है वो बेसिकली जुरिस्डिक्शन देता है कोर्ट्स को टू ट्राई ऑल काइंड ऑफ मैटर्स ऑफ सिविल नेचर माय लॉर्ड, और उसमें सेक्शन 42 एग्जॉस्टिव इसलिए नहीं हो सकता क्योंकि देयर आर सर्टेन डिक्लेरेशन व्हिच आर नॉट प्रोवाइडेड इन सेक्शन 42, बट दैट मे बी a dispute between one party or another party, and that can be granted under section 9 of the CPC. So this argument is in my humble submission is not correct, that section 42 is an exhaustive provision. Now my lord, मैं अब आता हूँ 232 पे my lord. Honorable my lord ने पूछा था कि 62(1)(f में जब डिक्लेरेशन दी जाएगी तो लॉ के तहत दी जाएगी, लेकिन मेरी हम्बल राय में जब भी 62(1)(f की डिक्लेरेशन दी जाएगी तो कोर्ट किसी को ये डिक्लेयर करेगी कि ही इज नॉट सगेशियस, नॉट राइचियस और नॉन प्रॉफिलिकेट और नॉट ऑनेस्ट और नॉट अ मेल। वो डिक्लेयर करेगी 62(1)(f के तहत। ये नहीं होगा कि लॉ ने उसको इख्तियार दिया हो कि वो कोई ऑर्डर करे और वो ऑर्डर उस लॉ के तहत हो, डिक्लेरेशन इसी प्रोविजन के तहत होगी। इसलिए समीउल्लाह बलोच जो कि कॉन्स्टिट्यूशनल इंटरप्रिटेशन पर बेस करती जजमेंट है, उसको जब तक रिविजिट ना किया जाए उस वक्त तक सेक्शन 232 62(1)(f जो है वो अमेंड नहीं वो उसी तरह रहेगा।
आपके कहने का मकसद ये है कि जब तक कोर्ट से ये साबित ना हो, किसी कोर्ट से, कॉम्पिटेंट कोर्ट से, कि ये सादिक और अमीन नहीं है, उसके अलावा आप उसको ये नहीं कह सकते, आप उस पर कोई पाबंदी नहीं लगा सकते। कोई
63(1)(f यही कह रहा है हमारा, कोर्ट की डिक्लेरेशन जरूरी है, बिल्कुल ठीक बात है।
And what is the definition of Sadiq and Amin? Or what is the definition of Sadiq or Amin?
इसमें एक चीज देखिएगा, ये जो सब
कोई मर्डर करके आ जाए, कोई वो नहीं शुमार।
क्लॉज 2 जो है ना मालूम, वो बहुत जरूरी है इसकी, क्योंकि इस क्लॉज में पैरा डी एंड ई जो है उनको तो अप्लाई किया गया है मुस्लिम्स की हद तक, एफ को नॉन मुस्लिम पर भी अप्लाई कर दिया गया है। ये बहुत अहम बात है जो हमें, यानी एक नॉन मुस्लिम भी ही इज बाउंड टू बी सगेशियस राइटियस, नॉन प्रॉफिलिगेट, ऑनेस्ट एंड अमीन। इट मीन्स के अमीन का जो लफ्ज है इसका वो मीनिंग नहीं लेना चाहिए जो इस्लामिक कॉन्टेक्स्ट में है, अदरवाइज ये
फिर इसकी क्या मीनिंग है?
मतलब अमीन का जो डिक्शनरी मीनिंग है, ही शुड बी अमानतदार, ही शुड बी अमानतदार माय लॉर्ड, ही शुड बी अमानतदार।
अमानतदार इस्लाम में अमानतदार का लफ्ज नहीं
नहीं है, लेकिन ये क्योंकि मुसलमानों पर अप्लाई नहीं, ये भी मुसलमानों के अलावा नॉन मुस्लिम पर भी अप्लाई किया गया है,
तो ये नहीं होना चाहिए।
नहीं, मैं ये कहता हूं इसका मतलब ये है कि ये इसके वो मीनिंग नहीं है जो इस्लाम में लिए जा रहे हैं, ये वो डिक्शनरी मीनिंग है, ऑर्डिनरी डिक्शनरी मीनिंग्स जो अप्लाई होने चाहिए, अदरवाइज ये प्रोविजन मुसलमान
ये बाकी आइन तो अंग्रेजी में है, अंग्रेजी का उनको लफ्ज पता नहीं था कि अमीन के लिए क्या होगा।
मेरी
अमीन जो अगर हम आप कह रहे हैं डिक्शनरी मीनिंग में देखें तो अंग्रेजी की डिक्शनरी में उठाऊंगा उसमें अमीन नहीं मिलेगा,
नहीं मिलेगा जॉन,
तो मुझे लुगत देखना होगी उर्दू की।
ठीक है
या अरबी की आप चाहते हैं हम देखें?
नहीं, उर्दू देखें या अरबी देखें,
मैं हमें नहीं पता, आपसे पूछ रहे हैं।
मैं तो ये करूंगा अमीन अगर ओरिजिनली उर्दू का लफ्ज है तो फिर उर्दू की डिक्शनरी
आप
देखी जाएगी।
बताएं ना कौन सा लफ्ज है, ये अरबी का है उर्दू का है?
मतलब ये तो उर्दू का लफ्ज है लेकिन इसका ओरिजिन जो है वो अरबी ही है, अरबी से ही इसको लिया गया, ओरिजिनली अरबी का लफ्ज, लेकिन अब अमीन पाक उर्दू में भी इस्तेमाल हो रहा है।
जनरल जिया को अमीन का अंग्रेजी लफ्ज पता नहीं था या उनके लॉ मिनिस्टर को नहीं पता था?
नहीं, उनको पता होगा या नहीं पता होगा।
नहीं, आई एम जस्ट ट्राइंग टू अंडरस्टैंड। बाकी सब अंग्रेजी में लिखा हुआ है, ये अमीन आर दिया।
इसका मतलब है कि ये वही इस्लाम में जो इस्तेमाल होता है सादिक और अमीन, इसका मतलब वही है।
इसलिए नहीं हो सकता क्योंकि फिर ये मुसलमानों पे अप्लाई नहीं हो सकता,
उन्होंने
नॉन मुस्लिम पे अप्लाई नहीं हो सकता।
क्यों? नॉन मुस्लिम भी तो सादिक और अमीन हो सकते हैं।
हो सकते हैं, बिल्कुल हो सकते हैं, लेकिन अगर इसकी इस्लामिक टर्मिनोलॉजी के तौर पर इस्तेमाल किया जाएगा, अगर डिक्शनरी मीनिंग हो फिर तो वो हो सकते हैं, अगर इस्लामिक टर्म के तौर पर इस्तेमाल किया जाएगा फिर ये नॉन मुस्लिम पर अप्लाई नहीं
ये जो ऐसी चीजें सिर्फ कंफ्यूजन के लिए डाली गई हैं, कोई वजह भी थी?
ये कंफ्यूजन तो बहुत पैदा हुई है।
इस्लाम और गैर इस्लाम में अमीन की डेफिनेशन डिफरेंट है।
नहीं मालूम,
सादिक और अमीन दोनों की, वो सच्चा आदमी हो, अमानतदार हो, वो कोई भी हो सकता है।
गुड कैरेक्टर का आदमी तो नॉन मुस्लिम हो, मुस्लिम हो, गुड कैरेक्टर की कोई डेफिनेशन
कौन डिटरमाइन करे कि फलां शख्स का कैरेक्टर अच्छा है, फलां शख्स अमीन है?
मतलब ये फाइनली तो कोई खुदा ही डिटरमाइन कर सकता है, हम आप तो कर ही नहीं सकते।
सही जवाब आपने दिया, माशाल्लाह। अच्छा, एनीथिंग एल्स? आपने बहुत आज पॉइंट लिया।
ये काइंडली देखिएगा, मैं कुछ अर्ज ये करना चाहूंगा माय लॉर्ड, ये इस पे मेरी
232 पे बताइए आप।
इस पे मेरी हम सबमिशन ये है कि क्योंकि 62(1)(f) जो है उसकी डिक्लेरेशन इन्हीं ग्राउंड्स पर होगी जो कॉन्स्टिट्यूशनल ग्राउंड हैं, इसलिए समीउल लॉ जो कि पार्ट ऑफ द कॉन्स्टिट्यूशन समझा जाना चाहिए जब तक वो रिविजिट नहीं होता।
समझाना चाहिए, ये बताइए ना।
अमेंडमेंट और
पिटीशन गुजारिश ये है, जब कॉन्स्टिट्यूशन इंटरप्रेट होगा तो उसकी इंटरप्रिटेशंस रेलेवेंट प्रोविजन का पार्ट एंड पार्सल कंसीडर होगी जो कि सुप्रीम कोर्ट ने इंटरप्रेट किया।
आर्टिकल 189 और 190 की बात कर रहे हैं,
189 के तहत वही फॉलो किया जाएगा, ये मेरी हम सबमिशन।
सही है, सही है।
अब ये ऑनर देखिएगा, अब मैं कुछ अर्ज करूंगा मालूम इस हवाले से कि जो समीउल बलोच के बाद कुछ डेवलपमेंट्स हुई वो बहुत रेलिवेंट हैं इस बात।
मुझे एक सवाल का जवाब देते हैं। द सेम लर्नेड ऑथर जज has also authored the judgment in Faisal Wavda case. उसका जिक्र था लास्ट टाइम पे।
बिल्कुल होता है।
तो कैन यू रिकंसाइल द टू जजमेंट्स? यस और नो?
यही मेरा पॉइंट है। मैं अब आज इस पॉइंट पे रहा हूं कि समीउल बलोच किन बिना पर रिविजिट हो सकता है। पहले तो फैसल वावदा के
कैन यू रिकंसाइल देम और नॉट?
नहीं हो सकता मालूम, लेकिन उसकी
नहीं हो सकता है।
लेकिन उस वजह से क्या समीउल बलोच रिविजिट हो सकता है या नहीं हो सकता, ये
सवाल नहीं पूछ रहा हूँ।
देखिए, रिकंसाइलेबल नहीं है, नहीं है रिकंसाइलेबल। एक और भी मैं
अगर इसी प्रिंसिपल को ले लें तो इसका मतलब है सादिक और अमीन अगर आज नहीं है तो कल हो सकता है वापस सादिक और अमीन।
जी बिल्कुल ठीक बात है।
यानी एक व्यू अगर मेरी है आज और कल वो व्यू बदल जाती है, तो इसी तरह अगर मैं आज अमीन नहीं हूँ कल अमीन हो सकता है, आज अमीन हूँ कल
ठीक बात है। इससे मेरी तो
You're being very fair. आगे बढ़िए।
अब जो ऑनर देखिएगा, PLD 2020 सुप्रीम कोर्ट 591 फैसल वावदा तो जनाब ने बिल्कुल नोट फरमा लिया।
दोबारा ऐसा बताएं।
PLD 2020 सुप्रीम कोर्ट 591
नाम बताएं जजमेंट
है जी। अलादीनो भाइयों केस ये रिव्यू जजमेंट है। ओरिजिनल जजमेंट जो अलादीनो भाइयों की है ना जो ऑनर, दैट इज 2013 SCMR 1655।
दोबारा क्या ऐसा
2013 SCMR 1655।
जी
समीउल्लाह बलोच में अलादीनो भाइयों को कोट किया गया और ये कहा गया कि समीउल्लाह बलोच
ये
करेक्ट
कहता क्या है
अलादीनो भाइयों का जो ओरिजिनल जजमेंट है ना, जो वो ये कहता है योर ऑनर, इसका 1657 है रेलेवेंट पेज मालूट 1657
क्या कहता है?
इसमें दवानियत करता हूं, उसमें उन्होंने कहा कि लाइफ टाइम डिस्क्वालिफिकेशन है अगर किसी ने जाली सनद जमा करवाई है
लाइफ टाइम। और
टाइम
रिव्यू क्या कहता है?
रिव्यू में ये जजमेंट सेटिस्फाइड हो गया,
सेटिस्फाइड हो गया।
ये रिव्यू में जो जजमेंट सेटिस्फाइड हुआ PLD 2020 सुप्रीम कोर्ट पे 5 पे कानून, उन्होंने कहा जी ये दैट इज नॉट ए गुड लॉ, और जबकि समीउल्लाह बलोच में इस पे रिलाई किया गया है, ये इसको कोट किया गया है,
पिटीशन अलाउड।
जी मालूम
ये रिव्यू भी 3 मेंबर जजमेंट थी।
जी ये 3 मेंबर बेंच जजमेंट है,
ये डिफरेंट बेंच है
मालूम, ये मिस्टर जैसे उमर का बंदियाल साहब की जजमेंट है मालूम।
तो ये एक और वेरिएशन
यही मैं कर रहा हूँ मालूम कि अलादीनो भाइयों समीउल्लाह बलोच में एक्सट्रैक्ट कोट करके अप्रूव किया गया, और बाद में
कौन सा वाला भाई हो? रिव्यू वाला भाई हो या
मालूम ओरिजिनल अलादीनो भाई, क्योंकि 2018 की जजमेंट है ना समीउल्लाह बलोच,
उसको रेफर किया,
उसको रेफर करके उसको इंडोर्स किया गया।
रिव्यू का जिक्र नहीं किया।
रिव्यू तो अब पेंडिंग था, डिसाइड 2020 में हुआ,
तो रिव्यू के वक्त इसको फिर समीउल्लाह को नहीं उस पर
नहीं मालूम, उसमें समीउल्लाह भी डिस्कस कर दिया गया, यही प्रॉब्लम है मालूम।
आपने वेरी गुड वेरी गुड। देखिए आपकी तरह प्रिसाइज होना चाहिए, आज आप बहुत प्रिसाइज हैं।
ओवर स्पीड है आप।
इसके इसके बाद पहले देखिएगा मालूम कि डिससैटिस्फैक्शन ऑफ द सुप्रीम कोर्ट ओवर द समीउल्लाह बलोच इज एपरेंट ड्यू।
आप कहां से पढ़ रहे हो?
मतलब मैं तो मुकम्मल कर दी, मतलब यही मेरा पॉइंट था कि जब एक बेसिक लॉ जिसको आप रेफर कर रहे हैं, जजमेंट को रेफर कर रहे हैं, उसको आप सब्सिक्वेंटली रिव्यू कर लेते हैं, तो समीउल्लाह बलोच की फोर्स खुद आप कह रहे हैं कि खत्म हो रही है, वो फिर वो उसको आप उस तरह का एक अप्रूव लॉ नहीं बना के पेश कर रहे या उसको नहीं देख रहे जिसके मुतल्लक आपने उसको रेफर किया हुआ है, उसको इंडोर्स किया हुआ है। ये जो रौनक लहजा फरमाइएगा जो मैं
आपने कहने का मकसद ये समीउल्लाह बलोच प्रैक्टिकली आप समझें कि इस जजमेंट के मुताबिक इज नो मोर इन फील्ड।
माय लॉर्ड, दैट इज इन फील्ड, but this is one of the consideration for reviewing of the judgment of the Samiullah Baloch.
But the only difficulty is that these two judgments of the same learned author judge are 3-member bench judge.
My lord.
And Samiullah Baloch is a 5-member.
My lord.
So to that extent, it will prevail over the 3 judges, even though the authors are the same.
My lord, ये बिल्कुल ठीक बात है, लेकिन मैं इसलिए अर्ज कर रहा हूँ कि इसको इस बिना पे देखा जाएगा फोर्स क्या रही है समीउल्लाह बलोच की इस वक्त। आप काइंडली 2021 SCMR 988 देखिएगा योर ऑनर, 2021 SCMR 988 माय लॉर्ड।
सॉरी दोबारा कहिए।
2021 SCMR 988
टाइटल 988।
मैं जुबानी अर्ज कर देता हूँ मालूम से टाइटल में मालूम सॉरी मैम
जी
टाइटल में ढूंढ रहा था मालूम, सॉरी
हम आपको बता देते हैं।
सॉरी
किसरानी केस है, किसरानी।
अब इस पे
टाइटल है शमूना बादशाह केसरानी।
जी मालूम। अब मालूम गुजारिश इसमें ये है कि इसमें भी समीउल्लाह बलोच में जो डायरेक्ट डिक्लेरेशन थी उससे इस तरह बचा गया मैं अर्ज करूंगा बचा गया कि ये कहा गया कि मिस डिक्लेरेशन मैलाफेडे नहीं थी।
The same author
shades no my lord, that is the judgment,
लेकिन one of the member was same.
जी यानी मिस डिक्लेरेशन को मैलाफेडे नहीं डिक्लेयर किया गया, दो का मिस डिक्लेरेशन थी। अगर समीउल्लाह बलोच को मुकम्मल तौर पर और फुली फॉलो किया जाता तो फिर ये डिक्लेरेशन नहीं आ सकती।
आप ये कह रहे हैं कि सक्सेसिव जजमेंट जो हैं
जी
the court is trying to get away from some
my lord and last judgment on this point
the learned author is also member of the bench,
my lord,
though this judgment is by Zahir Ali Akbar Naqvi.
And the last judgment on this point, that is Supreme Court Bar Association versus Federation of Pakistan, PLD 2023,
PLD
2023, Supreme Court, page 42.
इसमें क्या हुआ है फैसला?
इसमें माय लॉर्ड एक राह निकालने की कोशिश की गई। इसका शॉर्ट ऑर्डर जो है वो पेज 81 पे है माय लॉर्ड।
एक सेकंड,
क्वेश्चन बिफोर द कोर्ट ये था,
एक मिनट जरा आ जाए,
जरा दे दें 23
ए की के तहत अगर कोई आदमी पार्टी लाइंस को वायलेट करके, डायरेक्शन को वायलेट करके वोट डाल देता है, तो क्या वो परमानेंटली डिस्क्वालीफाई होगा 62(1)(f) में या नहीं होगा? उसको शॉर्ट ऑर्डर में ऑनरेबल कोर्ट में पेज 82 पे मालॉर्ड, पेज 82 पे डील किया मालॉर्ड। फिर मैं फाइनल ऑर्डर भी अर्ज करूंगा, वहां भी थोड़ा सा फर्क है।
इसका सेकंड पार्ट दीजिए, पेज
ये सेकंड एंड थर्ड पार्ट पे कंटिन्यू कर रही मालूम जजमेंट।
ये 82 के पेज कौन से पार्ट में?
ये पहला 82 पे है मालूम जो रेलेवेंट है
हमारे
पार्ट में, ये फरवरी के पार्ट में होगा।
फरवरी पार्ट भी फरवरी का पार्ट, इसमें दोनों जगह चल रहा है। इसमें डिसेंट भी है, मेजॉरिटी व्यू, मेजॉरिटी व्यू की बात कर जी, मेजॉरिटी की व्यू की बात कर रहे हैं,
मेजॉरिटी व्यू की बात जो कोर्ट ऑर्डर ऑफ द कोर्ट है मालूम जी,
पेज 82
मालूम पैरा 4 जो ऑनर शॉर्ट ऑर्डर
एक से आने दें
तुम्हारे वाले।
Today you're all charged up, very good, precise, to the point.
Page 82,
paragraph 4.
जी मालूम जी। As regard the third question, it is our view that a declaration of defection in terms of Article 63A can be disqualification under Article 63 in terms of appropriate law made by Parliament under para P of clause 1 thereof. While it is for the Parliament to enact such legislation, it may be said that it is high time that such a law is placed on the statute book. If such legislation is enacted, it should not amount to a mere slap on the wrist, but must be robust and proportionate response to the evil that is designed to thwart and eradicate. The question stand answered accordingly. अब इसको हमारे फाइनली जहाँ डिसाइड किया गया वो काइंडली मुलाजा फरमाइएगा मालूम।
अगर 63 की बात हो रही है,
नहीं फाइनल में 62 आ गया मालूम।
डिस्क्वालिफिकेशन क्या बनी इसमें
मालूम?
इसमें डिस्क्वालिफिकेशन क्या है?
इसमें कुछ नहीं,
सॉरी इसमें मालूम इसी के आखिर में है मालूम, सॉरी मैं गलती से कह गया, इसी की जो है ना इसी पार्ट के फरवरी के पार्ट में पेज में मालूम।
मेरे आप रिलैक्स करें, डोंट बी सो रश्ड
मालूम।
थर्ड पार्ट में तो
डिसेंटिंग ओपिनियन है, इसी में है मालूम, ये
इसी में कब में है, सभी में होगा ना।
146 पेज मालूम, 117 पेज 4146 मैं मालूम
146
मेरा 117 मालूम
लास्ट पैरा ऑफ
जी मालूम।
majority view.
As regard the third question, it is dealt with in para 4 of the short order. It is true that it is at least arguable that a defector may come within the scope of Article 62(1)(f). The question is that if this is to be the case, what should be the punishment? That is the punishment period for disqualification. As noted above, if a member who cast a proscribed vote in a de-seated, he can seek re-election in the by-election. If he chooses to contest the same, he may do so as an independent or even on the ticket of those who sought, engineered, welcomed, brought about and or rewarded the defection. If he loses, then the ensuing humiliation is also a punishment of sorts, but for the defector and his puppeteers. However, the cyclical nature of the electoral process must be taken into consideration. To impose a lifetime ban is to remove the defector for all cycles to come. Since Article 63(1)(p) confers the necessary competence on Parliament, on reflection, it is our view that matter is best left to the legislature while keeping in mind what has been said in para 4. The question stand answered accordingly. तो इसमें भी ये बात नहीं कही गई कि समीउल अपलोड के तहत, क्योंकि प्राइमा फेसी तो 62(1)(f) अप्लाई हो रहा है,
तो दरवाजा खोल दिया लेजिस्लेशन के लिए,
लेकिन
62(1)(f) का दरवाजा इस कोर्ट ने खोल दिया पार्लियामान के लिए। तो अब नहीं सर एक सेकंड ठहरिए ना, अब जो आपने जो जजमेंट साइट किया है ना, इसमें ये भी 5 मेंबर बेंच जजमेंट है, इवन दो इट्स मेजॉरिटी माइनॉरिटी, मगर इस 5 मेंबर बेंच ने पार्लियामान के दरवाजा खोल दिया कि 62(1)(f) को आप अटेंड कर सकते हैं थ्रू लेजिस्लेशन। आप समझे ना बात? ये तो आपका जो पहला मौक़िफ़ जो था ना आपका था कि क्योंकि जजमेंट आ गया है तो लेजिस्लेशन के थ्रू नहीं हो सकता है, तो यहाँ भी तो एक तसादुम नहीं आ रहा है दोनों जजमेंट
ये ऐसे नहीं है, काइंडली देखिएगा, इसलिए हमें पढ़ना पड़ेगा।
एक्चुअली वो कह रहे हैं कि अगर डिफेक्टर वाला है तो इसके लिए कानून होना चाहिए, तो उसे 331P में लेके आ रहे हैं, जिक्र करने वो खाली कहते हैं कि 6218 पे भी बॉर्डर करता है, लेकिन तरीका होगा कि 63(1)P में ले आए।
यही इसका रियल इसका मकसद था, बजाय इसके समीउल ब्लोच अप्लाई किया जाता, 63(1)P में उसको लेके गए।
इसी जजमेंट के पेज 186 पे आ जाए, 168 से 168 पैराग्राफ 10 एंड 11 पढ़ेगा। 168 इसी बुक पे आप कंटिन्यू करें नेक्स्ट। इसी बुक में
जी माय लॉर्ड 168 मालो, पैराग्राफ 10 मालो,
10 and 11 both
11
दोनों पहले 10 पढ़े बेटे।
There are a variety of reasons why members of parliament decide to cross the floor. Therefore, there are views for and against it. Sometimes they cross the floor according to their conscience and in the interest of the constituents. Whereas there is also a general view that the defection is because of corrupt practices, creative incentives, moral turpitude, or for some other reasons. Article 62(1)(f) of the Constitution provides that a person shall not be qualified to be elected or chosen as a member of Majlis unless he is sagacious, righteous, and non-profligate, honest, and mean. There being no declaration to the contrary by a court of law. That provision of Constitution is in clear terms describe that only upon a declaration from a court of law someone can be considered as such. This court is in cases of so and so has held that an elected member can only be declared as no longer sagacious, righteous, non-profligate, honest, and mean. After a declaration by a competent court of law in this regard, in order to further protect the fundamental right of citizen, Article 10A, my lord, introduced by the Constitution through 18th Amendment, according to the said article, for the determination of civil rights and obligation or in any criminal charge against him, a person shall be entitled to a fair trial and due process. Declaring someone as disqualified for any period to become a member of the parliament is a penalty depriving him of his constitutional right without declaration. अगले बुक में चला गया,
अगली किताब में आएगा
जी मालिक।
मैं पढ़ देता हूँ। By competent court of law after adopting due process through fair trial, determining any right and obligation of person would be against his fundamental right guaranteed by the Constitution.
In a democratic system, there is always a difference of opinion, and every member has a decision of right to dissent and debate in order to put a check upon the working and decision of the party and its head. Merely on the apprehension that a member has betrayed his party and thereby depriving him from his right of expressing views and the right of dissent will be against the basic concept of democracy enshrined in the Constitution. Thus, simply on the fundamental right of a member, without adopting due process and fair trial, he cannot be treated to be no longer as sagacious, righteous, non-profligate, honest, and mean. This will also amount to giving unbridled power to the PM which will result in creating a culture of civil dictatorship. No member will then have a right to remove the PM, even if the latter himself remains to no longer as sagacious, righteous, non-profligate, honest and mean, or if his policies are against the state, the constitution, the interest of the constituents, the injunctions of Islam, or even contrary to the party manifesto. For these reasons, the constitution makers intentionally did not include the word disqualification of a member for any period of time in 63A of the constitution. May I read, my lord? Continue.
Yes, we got it.
So, my lord,
एक सवाल मेरे जहन में शुरू में शायद याया साहब ने पूछ लिया था. What was the necessity of bringing two different articles in the constitution? ये 62 and 63. ये 62 says कि a person shall not be qualified to be elected. और यहाँ 63 पे लिखते हैं a person shall be disqualified. What is the difference?
इसको डील किया गया है, योर ऑनर, सब आर्टिकल 2 जो है ना 62 का, उसी में डील कर दिया गया मालूम जी. 62 का सब क्लॉज 2 है, द डिस्क्वालिफिकेशन स्पेसिफाइड इन डी एंड ई. सो दैट इज नॉट ओनली द क्वालिफिकेशन बट आल्सो द डिस्क्वालिफिकेशन. मैं दोबारा पढ़ता हूँ. द डिस्क्वालिफिकेशन स्पेसिफाइड इन पैराग्राफ डी एंड ई शैल नॉट अप्लाई टू पर्सन हु इज अ नॉन मुस्लिम बट सच ए पर्सन शैल हैव गुड मॉरल रेपुटेशन. तो मकसद दोनों का एक है. एक एंट्री के वक्त देखा जा सकता है. हाँ, एक बात जो खुरम साहब फरमा रहे थे कि इसको दो तरीकों से डील किया जा सकता है, उसमें ये जरूर हो सकता है.
बट आई टेंड टू एग्री विथ यू कि मकसद दोनों का
एक मकसद है.
क्योंकि देखिए, अब जैसे अब पहला वाला वो सिटीजनशिप वाली बात है ना, वो पहले वाले में उसको ही हैज टू बी सिटीजन, ठीक है. अब हो सकता है लोग दूसरी नेशनलिटी ले लेते हैं, वो 62 में नहीं फंसेगा, वो 63 फंसेगा. अब उसने दूसरी नेशनलिटी था तो पाकिस्तानी नेशनलिटी, फिर उसने कहा चलो मैं अमेरिकन ले लेता हूं, जो कि फिर वो उधर फंस जाएगा. तो मेरे ख्याल में इतना इस पे फर्क नहीं पड़ता है, दोनों ही डिस्क्वालिफिकेशन और क्वालिफिकेशन.
What I wanted to say earlier was, उसको आपने एड्रेस नहीं किया. देखिए 62(1)(f) में declaration is coming from another source, from another court. Constitution is recognizing that there is a declaration coming from some court. Once that declaration is there, then he's not sagacious and then he's disqualified. So Constitution is relying on a declaration coming from some source, some court of law. Now that declaration itself, किसी केस को निकाल लें, नॉमिनेशन पेपर्स में होगी, वो किसी एक्ट के तहत है ना, उसकी मिस डिक्लेरेशन है, वो भी किसी एक्ट के तहत है. सो दैट actual declaration is arising out of some violation of some law. Now that declaration is then borrowed by the Constitution, and the Constitution says then you stand disqualified. Samuel Baloch says that once that declaration stands, you stand disqualified. Now there could be a law introduced by the Parliament saying that declaration of law, which is arising out of a violation of a law, is being given a period. That's 5 years. So that also sort of comes into Article 62(1)(f) with the declaration that such a declaration which is given under the law, it's not under the Constitution, under the law will have a time frame. That's 5 years. So 5 years. So therefore, one argument is that you don't require the amendment of the Constitution because the disqualification is inherently under a law, not under the Constitution. Hence, correction of the law or time frame given to a law would be read into that declaration, which is being borrowed by the Constitution in 62(1)(f). ये मैं आपसे कह रहा हूँ कि 5 years could be easily brought into 62(1)(f) through that.
अगर तो सिर्फ ये कहा गया हो ना कि इस शख्स के नॉमिनेशन पेपर रिजेक्ट किए गए इस वजह से कि इसने अपनी डिग्री
यही declaration है. देखिए, all over in all the declarations it says कि आपने मिसडिक्लेयर कर दिया है, आपने एसेट्स छुपा दिए है. They're actually identifying an event and then we are building on that event कि इसकी वजह से, क्योंकि इसने रिटर्न में अपनी प्रॉपर्टी शो नहीं की, इसलिए ये अमीन नहीं है. ठीक. सो डिक्लेरेशन तो सिर्फ इस हद तक है कि आपकी नॉमिनेशन पेपर में ये चीज कम है, एफिडेविट में ये चीज कम है, आपकी एसेट्स में ये चीजें नहीं है. इट्स द इवेंट. द रेस्ट इज ऑल कंस्ट्रक्शन करके हम कह रहे हैं. सो डिक्लेरेशन तो सिर्फ इस हद तक है, और डिक्लेरेशन आप देखिए ना, वो कोई डिक्लेरेशन निकाल लें, वो डिक्लेरेशन किसी लॉ में है ना, वो कह रहा है कि जी आपका नॉमिनेशन पेपर इज नॉट इन द कॉन्स्टिट्यूशन, इट इज फ्रॉम द इलेक्शन एक्ट और द रोपा व्हाटएवर। तो डिक्लेरेशन जो कोर्ट दे रहा है वो लॉ में दे रहा है, तो फिर लॉ खुद कह रहा है कि ऐसी कोई भी डिक्लेरेशन जो लॉ में होगी वो 5 साल की होगी, तो फिर वो क्यों नहीं पढ़ी जा सकती?
उसकी वजह ये है 62 कई जजमेंट्स ऐसी ऑनरेबल सुप्रीम कोर्ट की जजमेंट ऐसी हैं कि जिसमें ये कहा गया है कि किसी शख्स को 62(1)(f) के तहत डिस्क्वालीफाई किया। पनामा केस की जजमेंट में वादे तौर पर 62(1)(f) मेंशन करके डिस्क्वालीफाई किया गया। सिर्फ ये नहीं, हाँ वो बात बिल्कुल ठीक है।
वो वाली डिबेट अलग है, होना चाहिए था, नहीं होना चाहिए था। हमारे पास जो इशू है, इज इट फॉर ड्यूरेशन ऑफ दैट पार्लियामेंट, इज इट अ ड्यूरेशन ऑफ 5 years, इज इट अ लाइफ टाइम? वो बातें हम तो नहीं बैठ के देख रहे हैं अभी, हम तो सिर्फ ये पॉइंट देख रहे हैं, क्योंकि इलेक्शन सर पे है और ये मैटर को रिजॉल्व करना है। तो अब आप दूसरों का खत्म हो गए तो दूसरों काफी लोग हैं। और
2 मिनट लूंगा। 63(1)(p) में वो कानून आ सकता है जो जनाब फरमा रहे हैं, 63(1)(p). लेकिन जहां तक 62(1)(f) का सवाल है, उसको बहरहाल कॉन्स्टिट्यूशनल अमेंडमेंट के तहत
3(1)(p) में आए। तो क्वेश्चन इज कि
जब आप कह रहे हैं दोनों को इंटरचेंजेबली आप पढ़ सकते हैं, तो फिर तो आपका
हमारे पास सिर्फ सवाल ये कि क्या लॉ में ये चीज आ सकती थी या आइन में अमेंडमेंट हो सकती थी?
मैं तो ये समझता हूं
नहीं, तो वही देखना ना, अगर सपोज 25 साल जो आइन में डिस्क्वालिफिकेशन लिखी है, अगर उससे रिलेटेड होता तो फिर तो आइन में अमेंडमेंट आती, या आइन खुद लॉ की डिक्लेरेशन पे रिलाई कर रहा है, तो वो लॉ कहता है मेरी डिक्लेरेशन 5 साल की हुआ करेगी, तो फिर क्यों?
सिर्फ अगर तो कोर्ट ने स्पेसिफिकली 62(1)(f) में किसी को डिस्क्वालीफाई किया है,
ठीक है,
फिर तो वो बात वो कॉन्स्टिट्यूशन अमेंडमेंट चाहिए। अदरवाइज जनरली उसको
ठीक समझ गए, चलिए समझ गए।
आखिरी बात है,
एक बात इससे पहले देखे, अगर ये तो सिचुएशन उस वक्त आती है जब नॉमिनेशन पेपर सबमिट करते हैं। सपोज रिटर्निंग ऑफिसर ये कहता है कि आपने फला चीज नहीं जमा की, क्या ये इलेक्शन डिस्प्यूट नहीं है? और अगर इलेक्शन डिस्प्यूट है तो इलेक्शन लॉ तो कहते हैं कि इलेक्शन कमीशन कंप्लेंट फाइल करेगा उस शख्स के अगेंस्ट, केस चलेगा। तो इसका मतलब क्या ये नहीं हुआ कि रिटर्निंग ऑफिसर के पास ये पावर्स नहीं है कि डिक्लेयर करे कि somebody is disqualified for such a period?
इस पे
दिस डिक्लेरेशन ये इलेक्शन डिस्प्यूट बन गया ना।
बिल्कुल ठीक बात है। इस पे 2 व्यूज हैं जो इस वक्त
डायरेक्टली वो कर सकते हैं क्या?
मतलब वही मैं करता हूँ, मतलब 2 व्यूज हैं।
पेपर गलत फाइल किया, ठीक है, ही गेट्स ट्रैप्ड अंडर 62(1)(f). अब मुद्दत पार्लियामान की 3 साल भी हो सकती है, एक सेकंड है जी, बाई इलेक्शन होता है, 3 साल भी हो सकती है। या कोई आदमी मर जाए, उसने कहा चलो मैं दोबारा इलेक्शन लड़ लेता हूँ, तो उसकी सीट पे आ गया 1 साल बाद, तो वो आपका कहना ये कि 5 साल भी ज्यादा है?
बिल्कुल, एक इलेक्शन, एक नॉमिनेशन पेपर, वो चाहे एक और नॉमिनेशन पेपर किसी और सीट पे जाके नॉमिनेशन पेपर जमा करवा दे, अगले दिन जमा करवा दे।
अगर वो फिर किसी ने चैलेंज, आप ना इस तरफ से चैलेंज हुआ है ना उस तरफ से चैलेंज हुआ है, वैसे पॉइंट आपका बहुत अच्छा है।
मेरी हमल सबमिशन ये कि इस वजह से भी 332(2) जो है वो अल्ट्रा वायरस है।
नहीं अल्ट्रा वायरस नहीं है, मगर आप कह रहे हैं कि वो इट्स ओनली फॉर 1 टाइम नॉमिनेशन पेपर,
इसलिए 5 साल भी नहीं गिराया जा सकता उससे कदम।
आप कहते हैं 5 साल भी नहीं,
5 साल भी नहीं हो सकता।
आप कह रहे हैं नॉमिनेशन पेपर क्या
फॉर दैट कॉन्स्टिट्यूएंसी। मतलब ये हुआ कि आप कहते हैं जो रिटर्निंग ऑफिसर है उसका उसका इख्तियार सिर्फ पेपर रिजेक्शन के हद तक है, नथिंग एल्स।
बिल्कुल नहीं, उसके अलावा वो कुछ नहीं कर सकते। ठीक है, वेरी गुड पॉइंट, वेरी गुड एंड नॉवेल पॉइंट यू टेक।
माय लॉर्ड, लास्ट माय सबमिशन माय लॉर्ड, चंद जजमेंट्स में अर्ज करूंगा जो कि सही समीउल्लाह बलोच के इफेक्ट को मजीद खत्म करती है माय लॉर्ड। पहली है PLD 2020 सुप्रीम कोर्ट 137।
पहले साइट तो नहीं हुआ है?
नहीं माय लॉर्ड, आई डोंट थिंक सो माय लॉर्ड जी। 137 इसमें क्या हुआ? 137
What's happened in this?
इसमें माय लॉर्ड ये कहा गया कि डेक्लेरेशन बाय कोर्ट होनी चाहिए, प्लेनरी जुरिस्डिक्शन की कोर्ट।
ये तो अभी
ये दीजिए ना कि ये साइट नहीं हुई है। नहीं, ये नहीं साइट हुई है। ये कितने मेंबर बेंच है?
ठीक है माय लॉर्ड,
ये 1 2 3 नहीं, इसमें नंबर सब 137 सरदार यार मोहम्मद रिंद
जी माय लॉर्ड,
ये तो उधर ही पड़ी।
इलेक्शन ट्राइब्यूनल
जी माय लॉर्ड, 3 मेंबर का जजमेंट है।
but the same journal
जी माय लॉर्ड, मैन माय लॉर्ड
लाइफ टाइम बैन है।
जी ये है लाइफ टाइम, लेकिन इस बात पे कि डेक्लेरेशन बाय द कोर्ट होनी चाहिए। अब अगली जजमेंट देखिएगा 2019।
एक सेकंड, disqualification under Article 62(1)(f of the Constitution entails a lifetime bar eligibility as held by this court in Samiullah Baloch. ये तो इसको फॉलो कर।
पैरा 4 है माय लॉर्ड, पैरा 4 है 141 पेज पे माय लॉर्ड।
आप वो पढ़ें फिर।
The impugned judgment of the High Court have applied the bar of Article 62(1)(f of the Constitution upon the petitioner without giving a finding that his declaration of Sanad al-Shahadatul Alamiya in his nomination paper filed in the year 2008 was a dishonest and deceitful action to meet the condition of graduate qualification in order to become eligible for contesting the general election. Apart from lacking such finding, the discussion in the impugned judgment is at best based upon a presumption and not on any finding or deduction made on the basis of any material qualifying as evidence. In the circumstances, the presumption drawn by the impugned judgment is conjunctural and cannot be made the ground for disqualifying the petitioner forever for contesting for holding an office in the constituent legislature of the country, my lord. Now, my lord, there is another judgment, 2019. बताइए 2019 SCMR 1939 my lord, page 1939 my lord, 1943 and 1948 पे my lord इसका 1943 पे my lord relevant citation my lord 1939
नहीं रेलिवेंट आप बता रहे थे
my lord। एक 1943 पे मुलादा फरमाइएगा, पैरा नंबर 7 my lord। वही मैं रेट मान लो पैरा 7 जी पढ़िए उसमें। I would notice that the order of returning officer dated 6/4/13 is summary in nature. No evidence was recorded.
कहाँ से पढ़ रहे हैं?
पैरा नंबर 7 है मालूम 1943। सॉरी मतलब ये भी उसी पॉइंट को है कि ये RO is not a court. RO is not a court. पैरा नंबर 7 मालूम। We notice that the order of returning officer dated 6/4/13 is summary in nature. No evidence was recorded in the said proceeding, nor does the order give any reason for disqualifying the respondent under Article 62(1)(f of the Constitution. On the other hand, Learned Election Tribunal made a declaration against the respondent only under Article 63(1)(c) and none under Article 62 of the Constitution. In terms of the said law laid down by this court in judgment reported as so and so, the order dated 6/4/13 by the returning officer merged into the order of the Learned Election Tribunal dated 16/4/13. The disqualification imposed on the respondent by the returning officer under Article 62(1)(f therefore did not survive. My lord, इसमें एक minority view क्या था? Minority view भी बहुत relevant है, my lord, that is at page number 1945.
पैराग्राफ 10 पढ़ लें। आई थिंक ये इशू अब हमारे पास आ गए,
कॉपी है कि मगर मेरे साथ
ये पढ़ें। टाइम ऑफ द व्यू दैट सीरियस कॉन्स्टिट्यूशन
time of the view that serious constitutional issues require to be addressed inter alia, whether the disqualification of the private respondent under clause D and F of sub-article 1 of Article 62 of the Constitution was passed by the court of law or otherwise, whether the disqualification of the private respondent, if any, would be permanent or otherwise in terms of the test laid down in Samuel Bloch case, whether the lack of bona fide on part of the petitioner in invoking the constitutional jurisdiction of High Court under Article 199 of the Constitution and having an alternate remedy under the election laws rendered the petition maintainable or otherwise, whether the disqualification of private respondent could be ignored by this court, keeping in view the law, dicta laid down in Sher Alam Khan and Raja Shaukat Adil Bhatti case. Accordingly, for the reasons stated herein above, leave to of this court be granted to consider and address the issue stated above.
So we are lucky to have this. It wasn't a dissent. It was these questions. The learned single judge. require consideration.
ये मानो कि बिल्कुल ठीक बात.
तो ये तो बात कब से चल रही है कि ये इशू आप फैसला कर लें, ये अब कब की बात है? 2019 की. 2019 की बात है. अगर 2019 अब हम 24 में आ गए 5 साल.
तो अगर आप एक पैराग्राफ और पढ़ लें, ये 2019 SCMR पेज 1943 पैराग्राफ 9. पैराग्राफ 9 में सभी लोग फिर डिस्कस किया. ये मानो be that it may, in Samuel Bloch, we have held that disqualification of election candidate or a holder of elected office under 62(1)(f) of the Constitution comes into existence when he is declared by court of law to lack any of the qualities mentioned in clause F of Article 62(1)(f) of the Constitution. In the present case, the only declaration against the respondent under Article 62(1)(f) of the Constitution was given in summary proceeding by the returning officer on 6/4/2013. As already noted above, no evidence was recorded by the returning officer to sustain his finding, nor he recorded reason for invoking disqualification under Article 62(1)(f) of the Constitution. He is not a court of law but a statutory forum of limited jurisdiction. Therefore, the condition that only a court of law can issue a declaration of disqualification under Article 62(1) of the Constitution.
What I think the point that can be made is that this question that was raised by bench has been agitating this court for a considerable period of time. Different voices, different judges are saying, like in this judgment also, let's resolve this once and for all. And so it's good that we are resolving it once and for all.
और मैं चंद जजमेंट में लिखा देता हूँ, पर साइज भी बता देता हूँ, बताएं क्योंकि बहुत बता दें. मलड एक है मलड 2019 SCMR 1684 जी. इसमें ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान ने ये होल्ड किया कि सुप्रीम कोर्ट आज खुद डिक्लेयर कर सकती है किसी को भी that he is not a sagacious, he is not a mean.
नेम क्या है ऑफ योर पार्टीज?
ये है निदा खोड़ो वर्सेस मौजम अली खान.
निदा खोड़ो
वर्सेस मौजम अली खान. Even without recording evidence. जी 1695 है मालूम इसका रेलेवेंट पेज. 1695 पैरा नंबर 7 मालूम.
ठीक है, नेक्स्ट बताइए.
मालूम इसके बाद है मालूम 2019 SCMR 137 मालूम. इस सारी मामला 2019 में हुए.
मतलब 19 SCMR पेज
है मालूम 137. इसका जो रेलेवेंट पेज है 141 है मालूम. पेज 141
नहीं, साइटेशन
का 137 है मालूम.
137 रेलेवेंट है पेज 139
पेज 141 मालूम
जी.
इसमें को वारंटो इशू हुई थी और वो ऑर्डर अपहोल्ड हुआ ऑनरेबल सुप्रीम कोर्ट में. ठीक है मालूम. इसके बाद है मालूम
इसमें क्या हुआ था?
वो वारंटो हाई कोर्ट से इशू हुई थी अगेंस्ट ए पर्सन हु वाज अ रिटर्न कैंडिडेट. उसके खिलाफ ये अपील जो थी ऑनरेबल सुप्रीम कोर्ट से वो और ऑर्डर ऑफ डिस्क्वालिफिकेशन पास इनको वारंट हुआ था फ्रेंड मालूम. नो मालूम TLD 2018 सुप्रीम कोर्ट 732 दैट इज फेमस हबीब अकरम केस मालूम. पेज 732. इसमें ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान की लार्जर बेंच ने ये फरमाया, ये लार्जर बेंच जजमेंट है मालूम.
कितने जजेस?
730 सॉरी मालूम. वो मालूम ये नहीं वो है मालूम
TLD 2018
सुप्रीम कोर्ट 732. ये वो भाई सॉरी मैं इसको मैं बताता हूँ. ये सुप्रीम कोर्ट ने इलेक्शन पिटीशन के ऑर्डर पर डिस्क्वालीफाई किया है फिर अपनी जो अपने सुप्रीम कोर्ट ने अपने लेवल पर. ये पेज ना 732 का जो रेलेवेंट पैरा है हमारा वो मैं अर्ज कर देता हूँ. ये 736 एंड 737 पेज पे मालूम.
नहीं, हबीब अकरम नहीं,
ये मालूम ये हबीब अकरम नहीं है।
बीबी यास्मीन शाह।
जी सॉरी, ये हबीब अकरम नहीं, वो हबीब,
और ये 3 मेंबर बेंच है।
जी मालूम, वो जो हबीब अकरम केस है मालूम, दैट
ये एक बीबी यास्मीन शाह का केस है, और इसमें प्रिलिमिनरी प्रोविजन क्या है?
337 and 336 and 337 मालूम।
732 पे थे आप।
सॉरी 737, 36 and 37, ये पैरा नंबर 14 है मालूम।
इसमें क्या होल हुआ है?
From perusal of original record, it is clear that and obvious to us that it's number one whose name is BB Yasmin Shah and whose father name is Nadra, database is Ali Hussain Jamali and whose date of birth according to her NIC and Nadra record.
ये डिस्क्वालिफिकेशन कितने दिन का था?
ये डिस्क्वालिफिकेशन परमानेंट सुप्रीम कोर्ट ने की है मालूम। इसको ये जो ऑर्डर था नीचे इलेक्शन ट्रिब्यूनल, इलेक्शन अथॉरिटी का, उसको अपहोल्ड किया गया मालूम।
नहीं, डिस्क्वालिफाइड पीरियड तो नहीं लिखा है, ये लिखा है
मतलब 62(1)(f में ही किया है इसको।
पीरियड नहीं लिखा है,
पीरियड नहीं लिखा, लेकिन 62(1)(f तो ये
जो लाइफ टाइम नहीं है।
अब उस वक्त तो लाइफ टाइम था हमारा, जिस जजमेंट था उस वक्त
नहीं, इस जजमेंट में लाइफ टाइम का लफ्ज नहीं इस्तेमाल,
इसमें सिर्फ 62(1)(f
इसमें लिखा है डिस्क्वालिफाइड।
ही माना।
सो द इम्प्लीकेशन विल बी इट वाज डिस्क्वालिफिकेशन फॉर दैट नॉमिनेशन पेपर।
मतलब इसमें क्योंकि 62(1)(f पे रिलाई किया गया, इस उसके तहत डिस्क्वालीफाई किया गया, और उस वक्त के लॉ के मुताबिक पीरियड नहीं बताया, अलग पीरियड नहीं बताया।
ठीक,
आगे जो
पीरियड नॉट मेंशन। ठीक,
TLD 2018 सुप्रीम कोर्ट 578 मालूम,
2018 सुप्रीम कोर्ट पेज
578 मालूम। इसमें मालूम ECB का ऑर्डर था, इलेक्शन कमीशन ऑफ पाकिस्तान का ऑर्डर समरी प्रोसीडिंग में था, वो ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान में अपहोल्ड हुआ। इसका 589 पेज मालूम रेलेवेंट है।
शौकत अजीज भट्टी।
जी मालूम, पैरा नंबर 19 है मालूम।
जी, इसमें क्या हुआ था?
मतलब इसमें ECP ने एक आदमी को डिस्क्वालीफाई किया, वो रिट में गया, रिट जो है वो रिमांड हो गई कि आप दोबारा डिसाइड करें। उस रिमांड ऑर्डर के खिलाफ ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान में ECP आया, और ECP की ये अपील, वो ऑर्डर अपील मंजूर होकर उसको परमानेंटली डिस्क्वालीफाई डिक्लेयर किया गया।
परमानेंटली?
जी मालूम। इन व्यू ऑफ द फैक्ट सर्कमस्टेंसेस, पेज 589 मालूम, पैरा नंबर 19।
Here the matter was converted into suo motu proceedings under Article 184. ठीक,
मालूम ये मैंने एक पेपर बुक तैयार की, मालूम आखिरी मेरे सबमिशन सिर्फ ये होगी कि क्योंकि पाकिस्तान में जो लॉ ऑफ जुडिशियल प्रेसिडेंट है उसके बारे में कि कौन सा जजमेंट किस हालात, किन हालात में रीविजिट हो सकता है, रिव्यू हो सकता है, उस पे मैंने एक ये पेपर बुक तैयार की है जो बेसिकली मैं पढ़ूंगा नहीं, मालूम देख लीजिएगा। वैसे अगर कहें तो मैं प्रिसाइज भी कर देता हूँ वो ग्राउंड्स क्या हैं जिन ग्राउंड्स के ऊपर किसी भी प्रेसिडेंट को रीविजिट किया जा सकता है। ये एक्सट्रैक्ट है फ्रॉम द बुक द लॉ ऑफ जुडिशियल प्रेसिडेंट मालूम।
इसमें ये जो आपने केस साइट की पिछले ये 2018 सुप्रीम कोर्ट 578, इसमें ट्राइब्यूनल में नहीं गए थे बल्कि इलेक्शन कमीशन में गए थे।
इलेक्शन कमीशन में गए थे, इलेक्शन कमीशन के बाद हाई कोर्ट में आए थे, हाई कोर्ट ने केस रिमांड किया। ट्राइब्यूनल या आरओ नहीं था मालूम।
रिलेवेंट पोर्शन बता दें,
इसमें कोई खास पेजेस हैं जो हम पढ़ रहे हैं, सारा पढ़वाओगे हमसे?
नहीं, मैं सिर्फ अर्ज कर रहा हूँ, मैं सिर्फ एक ही करके बताता हूँ,
इसमें पेजेस से बता
मैं पेजेस बता देता हूँ, मैंने ये नोट किया है अपने पास।
लॉ ऑफ जुडिशियल प्रेसिडेंट एक किताब है गार्नियर की, लेकिन इस बस पेज बता दें।
मैं इसके जनाब पहला पेज है मालूम, पेज 3 मालूम देख लीजिएगा, नोट पर वाले बाकी बाद में।
पेज 3
ये है अप्रूवल एक्सेप्टेंस एजुकेशन ऑफ जजमेंट। ये मैंने अर्ज किया कि कितनी अप्रूवल,
पेजेस बता दे।
पेज नंबर 3 मालूम, पेज नंबर 9 है मालूम, आउट क्रिटिसिज्म एंड डिसएग्रीमेंट। ठीक है, पेज नंबर 40 है मालूम,
40
पल्पेबली रॉन्ग डिसीजन।
पढ़िए नहीं, बस ठीक बता दें, खुद पढ़ लेंगे।
48 मालूम,
48
then 56 मालूम।
आप सारे चैप्टर्स ही बता रहे हैं ना?
जी जी, बेसिकली वो रेलेवेंट चैप्टर जो है वो मैंने
56
And then पेज नंबर 13 पे भी मालॉट ये इसका वो क्योंकि दूसरे सब्जेक्ट है, पेज 13 भी रेलेवेंट है इसका. Then 18.
These are all the grounds to revisit and overrule it.
मेरी अम्मा का मिशन ये है कि ये कि सिर्फ ये है कि ये इंप्रेशन जाता है और मीडिया पे इस पर बहुत बात होती है कि जजेस की कॉम्पोजिशन चेंज होने के बाद फैसले चेंज होते हैं. ये जजमेंट ऐसी है समीउल्लाह बलोच की जिसको रिविजिट होना चाहिए और इसके लिए जस्टिफाइबल ग्राउंड मौजूद हैं. और ये अगर ये लॉ जुडिशियल प्रेसिडेंट इस तरह डिक्लेयर किया जाए तो फिर ये मामला आइंदा के लिए खत्म हो सकते हैं. जो हाई कोर्ट या कोई भी कोर्ट जो है उसको गाइडलाइन दी जा सकती है कि ये पैरामीटर हैं जिसमें आपने जुडिशियल प्रेसिडेंट को चाहे कितने मेंबर जजमेंट हो उसको रिविजिट करने हैं और किन चीजों को
आपका कहना ये कि वो जो इंटरप्रिटेशन हुई है वो प्रॉपर नहीं है.
मेरा कहना यह है कि वो प्रॉपर नहीं हुई और उसको रिविजिट करने के लिए ये ग्राउंड अगर सफिशिएंट ग्राउंड हैं जिनको रिविजिट किया जा सकता है.
प्रॉपर अगर अटेंड नहीं किया तो क्या वो जजमेंट इंक्योरिंग है?
सिर्फ प्रॉपर अटेंड ना करना काफी नहीं है, उसके साथ पल्पेबली रॉन्ग डिसीजन होना, अप्रूवल ना होना उसी जजमेंट का सेम कोर्ट से, क्रिटिसिज्म आना फ्रॉम द कोर्ट एंड आउटसाइड द कोर्ट, लीगल स्कॉलर्स का, पार्लियामेंट की तरफ से डिसअप्रूवल आना, ये सारी चीजें कंसीडर हो गए. और फिर स्टेरे डिसाइसिस का प्रिंसिपल कहाँ उसकी वैल्यू, मतलब कॉन्स्टिट्यूशन इंटरप्रिटेशन में स्टेरे डिसाइसिस जो है वो इतना फोर्स नहीं रखता. स्टैट्यूटरी इंटरप्रिटेशन में स्टेरे डिसाइसिस बहुत फोर्स रखता है, लेकिन जहाँ कॉन्स्टिट्यूशन इंटरप्रिटेशन होगी वहां उसका स्टेरे डिसाइसिस का इतनी ज्यादा फोर्स नहीं है, क्योंकि कॉन्स्टिट्यूशन अमेंडमेंट एक मुश्किल काम है और सुप्रीम कोर्ट अपना अगर समझे कि हमसे रॉन्ग हुआ है उसको करेक्ट कर सकती है.
सारी डिसाइसिस का प्रिंसिपल शायद आपने हमने अभी सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट में जिक्र किया है, पता नहीं आपने पढ़ा है या नहीं.
मैंने 3 जजमेंट्स पढ़ी है, ऑनर की पढ़ी है, जज साहब की पढ़ी है एंड
अभी नहीं आई.
अभी जनाब की
हमने पहले ही पढ़ी.
नहीं जनाब की पढ़ाई
नहीं, वैसे माशाल्लाह you argued very well. You argued before a larger bench before of this strength or no? This is your first experience.
5 member bench के सामने आर्गू किया.
चले okay, we appreciate your very precise and I would request others also to be very focused and precise. So thank you for your. We will take a short break and so Ajit, Larissa, we will come back.
If I can just make a request, I don't claim any preferential right of audience.
We will next we'll hear you.
My lord, because I have to, for personal and professional reasons, I have to be back in Lahore and the motorway closes because of fog. That's also an issue. So if your lordship can...
If you've heard all this, probably they have reduced your, Mr. Khurram and Mr. Usman have reduced your work. So just more precise as you can be.
I'm in the happy position of not representing anyone, just representing myself. So
And you are in the unhappy position of not being paid.
not being paid. That is true, my lord. Grateful.
So we will return after a while. ठीक है.
वो कौन सर?
ये सब भी मौजूद है जी.
So we'll hear
आगे
resume.
अच्छा करते हैं. We will hear you last.
जी जी मैं आखिर में आऊंगा, but we resume at 2 or 2:15.
Then at least 2:15. It may be even longer.
Mikey can be heard first.
जी जी, we hear Mr. Bandari, then we'll hear Mr. Faisal Siddiqui, and then we'll hear you. And in the meantime, ये दे दीजिए इनको, पता नहीं इन्होंने देखा है. Another amicus has submitted a note. तो वो अगर किसी के पास नहीं पढ़ना चाहे वो पढ़ लें. Thank you everyone.
एक छोटी सी सबमिशन मैं करना चाहता हूं. There is another serious question of law in this case, and that is with regard to the applicability of Article 63(1)(h). मेरी अपील्स में जो 63H के जी कन्विक्शन अगर हो जाए और 2 साल की हो तो वो डिस्क्वालीफाई होता है जब तक वो 5 साल का टाइम लैप्स नहीं होता. तो जो इम्प्यून जजमेंट है मेरी अपील्स में उन्होंने उसको रिडंडेंट कर दिया है. उन्होंने ये कहा है कि इवन इफ व्हाट यू वांट, माय नॉट, आई एम सेइंग कि वो जजमेंट को सेट असाइड कर दिया जाए. आप बेशक फैक्ट्स पे, आई नो यू नहीं
63(1)(h) में आप चाहते क्या है कि 5 साल डिस्क्वालिफिकेशन हो, क्या हो?
माय लॉर्ड वो तो लिखा हुआ है उसमें, मैं तो कुछ चाह ही नहीं रहा. मैं तो ये कह रहा हूँ कि आइन को फॉलो किया जाए, उस प्रोविजन को, क्योंकि जो लाइफ हुई है
आपकी लाइफ हुई है.
सर लाइफ नहीं हुई. We'll hear you. I mean, okay, the batting order we've just explained. Thank you.
उजैर साहब आइए.
My Lord, first of all, I'm very grateful to your Lordships and your Ladyship for this honor of having me here in this capacity.
Thank you for sparing time for us.
My Lord, it's a duty that one owes to the court, and I hope I'm able to discharge it to the standard that your Lordships might expect of me. My Lord, I'm guided as a preliminary point only by the order that the court associate very kindly sent me yesterday. I haven't read the pleading. I don't have the file, so I'm not really sure what the precise contours of individual cases.
Let us, for your benefit,
My Lord.
there is judgment of Samulla's case which interprets 62(1)(f) and disqualifies a person in violation of that provision for lifetime.
My Lord.
Then Parliament has enacted legislation and brought an amendment in the Elections Act of 2017, 232, within bracket 2, saying that such a disqualification is of 5 years. Mr. Usman Karimuddin contended that disqualification can only be for the purposes of that nomination paper, and that will end because if the disqualification goes away in the next by-election or in the next general election. That's one argument. The other argument is that the 232(2) cannot be enacted in the light of Samullah Baloch's judgment, and for that a constitutional amendment is required. And however, all are so far unanimous that we can revisit Samullah Baloch if we don't find it to accord with the larger constitutional premises.
Absolutely.
This is, and the only reason why this question has been agitating different benches of this court by different judges, but since 2019, but unfortunately it's not been resolved. So since elections are there and every returning, there are, I don't know, thousands of returning officers, one will reject the paper, one will accept it, one will follow 232(2), one will follow Samullah Baloch. So just wanted to facilitate smooth election. Of course, other objections will be taken, but these, on this matter at least, okay, it's a one-time bar, then he just has to count 5 years past, not 5 years past, simple. So this is, we wanted your assistance on this.
Absolutely, I vouch that. My Lord, about that, this actually, your Lordship's order of 11th of December, when I read it, I was reminded of what Chief Justice Marshall confronted in Barbary versus Medicine. He too posed the question that anyone enforcing the law, when faced with two norms, one, the Constitution, and one, the law made under the Constitution, what norm is that authority or person or official required to give effect to? That's the question here also. That the RO, that's how I read your Lordship's order. The ROs have two norms before them, 232(2) and Samullah Baloch. Which of these two norms is the higher norm which the ROs have to enforce? That's the first thing that, my Lord, my king.
I just want to add one thing. No one has attacked, at least so far, 232(2). We are surprised because we expected someone or the other to launch an attack on that. Nobody has attacked it, but you can canvass your proposition on that.
Hello, as I said, I'm in the happy position of not representing anybody, so I don't need to challenge that. But my sense, in my humble submission, that the question of whether Section 232(2) is a valid law will inevitably arise. Because if the question is framed in these terms that I've just set out,
let's proceed.
That there are two norms. Which of these two norms?
Yeah. What do you say?
The question will arise, my Lord.
Yes, it is. We agree with you.
So, my Lord, the way I see it, my Lord, the starting point, as I see it, is the sort of historical context for 62(1)(f). That I believe is important. But pre-18th Amendment, what happened was that pre-18th Amendment, it was settled, and there are judgments. Samullah Baloch in paras 33 and 34 discusses those judgments, that 62(1)(f) entailed a lifetime disqualification. This was settled before the 18th Amendment.
The 18th Amendment is dated 2010?
Well, the 18th Amendment is April 2010.
So this is pre the 18th Amendment. This is one important
The
factor.
only addition that was brought about by the 18th Amendment was by a court of law, if I
In 62
recollect.
Yes. Well, the pre-18th Amendment, the second important factor that your lordships, in my humble opinion, ought to note, is that there are various provisions in Article 63, which imposed a disqualification, but did not lay down any time frame for how long the disqualification would operate.
Yes.
My lord, this is 63, 1G, H, I, and J.
Now what is the disqualification?
My lord, now there are different, and I'll come to them. So pre-18th Amendment, these two things were there before the Parliament. Judgments, various judgments of the Supreme Court, and 62, 1F, and 63 in this form. In the 18th Amendment, my lord, for our purposes, Parliament did three things and did not do one thing. Parliament, number one, substituted Articles 62 and 63 in their entirety. So the entire Articles 62 and 63 were substituted, number one. Number two, and this is very important, 63, 1, G, H, I, and J had time limits inserted in them. And there were different time limits, ranging from 5 years to 2 years. C to G, for different. And that probably that gradation is justified based on the severity or egregiousness of the wrong that they entail. The third thing that the Parliament did was that in 62, 1F, they inserted these words that my Lord the Chief Justice has just mentioned, there being no declaration to the contrary by a court of law.
What do you understand by these words?
Well, I'll come to that in a minute. The fourth thing which the Parliament did not do was insert a time limit in 62 1F. So the Parliament consciously inserted time limits in various provisions of 63 1, but did not do so for 62 1F. Well, and the inference that one draws from this, and this as drawn by in various judgments of this court, for example, Shamroz Khan versus Muhammad Amin, PLD 1978, Supreme Court 89.
PLD?
1978, Supreme Court 89. The relevant is at 95. Well, the principle laid down, and it's very well settled, that if a law has been interpreted in a certain manner by the court, the Parliament then does not change it, but enacts another law or uses the same word in the same sense, then the presumption is that the Parliament wanted the same meaning to continue. In my humble submission, that principle will apply here, that there is a presumption, and it's only a presumption, that since the Parliament was aware that 62 1F had been held by this court to entail a lifetime ban, but it chose not to insert a time limit for the disqualification, the presumption is that the Parliament wanted that duration to continue, subject to the insertion that it has made.
Lifetime ban was held by the courts when? Before the 18th Amendment or after the 18th?
Before the 18th Amendment, and those judgments are noted in paras 3 and 34 of Samiullah Baloch. There's the 2007 judgment, there are various judgments from 2009-10. They are mentioned in Samiullah Baloch. And this is something that is discussed. And the point, and what is also important is
could it not be interpreted, you drawing one inference, what about another inference? The other inference is that 63 1GHIJ prescribed periods, and in this 62 1F period was not prescribed. So the period is, as Mr. Usman had mentioned, only for that particular nomination paper. Why can't we draw that inference?
Well, but because that is not what this court had held.
Where did it hold?
Well, it's starting from 2007.
कोई case बताए ना?
This is mentioned, my lord, this is it mentioned in Samiullah Baloch. For example, 2007 Supreme Court, this is what is quoted there.
2007
Supreme Court. PLD 2007 Supreme Court 369. Imtiaz Ahmed Lali versus Ghulam Muhammad Lali.
This declaration part was in 1985. ये जो 62(1)(f) की अमेंडमेंट पहली दफा कब हुई है?
62(1)(f) की तो अब वो पहले भी होती रही है,
हुई है ना,
पहले भी होती रही है, बट ये जो डिक्लेरेशन अब आया
18th अमेंडमेंट में आई है ना
जी, ये 18th अमेंडमेंट
2010 अप्रैल 2000। आप जजमेंट्स दे रहे हैं हमसे उससे पहले की।
मैं ये कह रहा हूँ जी कि उस 18th अमेंडमेंट जब पार्लियामेंट इनैक्ट करने बैठी तो पार्लियामेंट इज प्रिज्यूम टू नो द स्टेट ऑफ केस लॉ, दैट्स अ प्रिजम्पशन। They knew that 62(1)(f) has been interpreted in this manner. They knew that there is a presumption. They consciously made changes in various articles of 63, but did not make changes.
Where are you getting this presumption from?
Well, this is settled.
Even judges don't know sometimes what the law, early judgments are, and the parliamentarians are expected to know what the judgments are.
But your lordship is wearing all the laws of the country on the sleeves of your lordship's robes. That's
I don't profess that.
that is the law of the
ये जरा क्लियर कर दें कि 2010 से पहले what was the language?
2010 से पहले 60
because those judgments that you're relying on उसमें life की बात।
He is sagacious, righteous, and non-profligate and honest and immune. That's it.
That's it. And this was interpreted to be a lifetime ban.
This was interpreted to be a lifetime.
देखिए एक चीज है ना, there's another, Khurram Saab has drawn a distinction between 62 and 63. And 62 is the entry gate according to him. So this entry gate does not open to you if you're not honest, sagacious, non-profligate, mean, etc. Right? Now, where is this entry gate may suddenly open because now you are honest, sagacious, non-profligate. I mean, so it's not a permanent shutting off date. Like, so this is again called judge-made law. This is again judge-made law.
It is, and your lordships are free to revisit it. And I will be submitting that there are aspects of Samiullah Baloch which need to be revisited. But my submission is that
clear कर दें, Samiullah Baloch proceeds on the assumption that there is a disqualification by a court, and unless the disqualification is set aside, it continues. Prior to this, your judgments थी, what was the rationale in those judgments for a lifetime ban?
That simply because the Constitution
read one of them
did not.
हम आपके साथ पढ़ना चाहते हैं।
जी, if I can just answer this, that there was no time limit given in the Constitution in contradistinction to some other.
And where did they draw the disqualification at that time from? Because there was no declaration of any court of law.
There was no declaration.
So how would they?
What was happening at that stage, my lord, was that even the ROs were rejecting papers, asking questions. ROs were in their summary inquiry.
Mr. आप अपना point बताएं, आप अपना point बताएं।
अभी तो मैं सिर्फ आपको historical background दे रहा हूँ। My point, जी, my lord।
किस तरह से देखते हैं कि 62(1)(a) को देखते हैं। There is a declaration he is not a citizen of Pakistan.
जी।
Thereafter he becomes a citizen of my lord. तो वो भी permanent disqualification as per Samiullah case.
My lord, if I can, I was going to proceed step by step, but let me say this: the way I read Samiullah Baloch, I don't see it as laying down a permanent disqualification. It only lays down, in my humble reading, an indefinite disqualification. And that can come to an end. The problem with Samiullah Baloch is it doesn't discuss the mechanism for that. And I will be making submissions on that. So, and that's why I'm saying that for me, Samiullah Baloch, I can just state my view on this. Samiullah Baloch need not be overruled, but there are problems with it which can be fixed. I don't see it as laying down a permanent disqualification, but as an indefinite disqualification, and that indefinite disqualification can come to an end. The problem is Samiullah Baloch doesn't deal with that mechanism. I will make some submissions on that, and that do serve for your lordship.
This is a new novel point,
my lord.
Ji.
But I will, because I'm here in a neutral capacity. Yes, yes. I will also make submissions on what happens if your lordships choose to overrule Samiullah Baloch. My lord. But the point, the historical context, the other point is that subsequent to the 18th Amendment also, there have been various constitutional amendments. We have 25 or 26 now. And this, despite the fact that the court's unease with this lifetime ban was evident in 2018 and onwards, no constitutional amendment ever chose to deal with this issue. Even though this was something, the disqualification of politicians or those running for a parliamentary office
is something that affected Parliament directly. But nonetheless, the Parliament chose not to deal with it. So, my lord,
Could it be because एक वो उन्होंने लैंग्वेज चेंज कर दी थी वो ओथ में, तो पूरा पाकिस्तान को बंद कर दिया, तो हो सकता है उन्होंने कहा इसको छोड़ ही दें। ये भी तो हो सकता है ना, क्योंकि लोग जब होते हैं ना, what word should be used for them who don't want to follow the legal or constitutional path, but want to impose their will on the state. But the state is still cognizant of the fact that who will deal with these people.
my lord, if one could go back in time, one could want to change a lot of things. वो, as Ghalib said, वो हर एक बात पे कहना कि यूं होता तो क्या होता, वो we don't know कि क्या होता. We are stuck with the letter of the law, right? What as it is, and we have to deal with that. Whether that is how it came about. So my lord,
हम आपसे सुनना चाहते हैं कि अब होगा तो कैसे होगा?
my lord, yes.
सुनना चाहते हैं कि अब क्या होना चाहिए, कैसे होगा?
I mean, I don't think a lifetime ban ought to be there, frankly, and I don't think the way I read it, something
Be there or should not be there?
should not be there. Should not be there. But I have tried, and as will be evident from my submissions, to find a way out from on the basis of Samiullah Baloch, and I'll say that. My lord, and this fact that Parliament chose not to deal with this issue through the 18th Amendment is actually considered in Samiullah Baloch itself. Your Lordships may just note paras 17 and 23. Para 17 at 432 and para 23 at 436. And it becomes actually very clear from para 9 of Justice Azmat Said's separate note. Very clearly says that, well, this is what Parliament has done, and why are you asking us to change? And those of us, my lord, who knew Justice Azmat Said in his personal capacity knew that there is a touch of exasperation in what he's written in para 9. So this is the game. My lord, my submission is, what has Samiullah Baloch actually done? It has interpreted these words, and my lord, the Chief Justice asked this question, what do these words mean? There being no declaration to the contrary by a court of law. What Samiullah Baloch has done is that it has linked the disqualification to the declaration by the court, and extrapolated from that since the basis of the disqualification or lack of qualification is the declaration by the court, therefore it should be coterminous with the decree itself, the declaration by the court itself. So long as the decree continues, the judgment continues, the disqualification continues. So if there is some way to end the effect of the decree, the disqualification will also end. That's a logical consequence. Samiullah Baloch in para 35 alludes to this, touches upon this, but then doesn't really go on and explain this. So, I will come back to this, but one point, as I said, your lordships are sitting in a larger bench. Your lordships can obviously revisit Samiullah Baloch. Should it be revisited? My lord, the argument for its overruling it or revisiting it is weighty. I don't dispute that. But in my humble opinion, even without overruling Samiullah Baloch, a way out can be found. And why do I say that, my lord? Why do I say that Samiullah Baloch should not be overruled? My lord, the prime argument that I am aware of, and I heard bits and pieces on during the live broadcast a day ago, was that 62(1)F should be read along with 63(1)H. And this seems to be the main argument. This argument was considered in Samiullah Baloch in great detail in paras 27 to 32, pages 438 to 442. And they said that it was held that these two are separate. Qualifications and disqualifications are separate, and we can't use them. An expression that I have used earlier also before, my lord, is that in my view, they are like Siamese twins. Siamese twins are joined at the hip. So they are one for many purposes, but actually they are two separate persons, two separate entities. So they are separate for some purposes and they are joined for some purposes. For example, your lordship, the Article 100 of the Constitution talks about the qualifications for the Attorney General.
And those have been interpreted, Article 100 has been interpreted to mean that only the qualifications given in Article 62 shall apply, or for the qualifications required of a judge of the Supreme Court in that case will apply, and not the disqualifications. My lord, in Rafiq Tarad's case, PLD 1998, Lahore 461,
PLD 1998
Lahore 461. It was a full bench decision of the Lahore High Court. Just note, I'm not. There the question was that Article 41 says the president has to have the qualifications for same qualifications as member of parliament. And the question was whether the disqualifications mentioned in Article 63 will also be applicable. And it was held by the full bench that because the word qualifications is used, only Article 62 will apply and Article 63 will not apply. So there is a conceptual difference between the two, but for certain matters, they have to be read together, but not always.
So my lord, my submission is that this argument that 62(1)(f) should be read together with 63(1)(h) and draw its, inspiration in terms of the duration from 63(1)(h) was considered and was not accepted. Since and it relied on earlier judgments starting from the 1960s, hence, since it has been there for a long time, there are many precedents for it. Therefore, in my humble opinion, it should not be overruled. My lord, I just place 2-3 judgments on that for you.
आप हमें अपना बताते ना
जी, मैं तो अपना बता रहा हूँ.
When you say it should not be overruled, we observe number of judgments have been cited, including Faisal Barda, same learned judge, not following Samula below.
I will, when I come to this way out, I will rely on Faisal Barda. I think it is consistent.
How do you reconcile the two?
My lord, they will be reconciled. They are not.
Can you reconcile the two?
My lord, I will make submission on that. I think
कर देना.
वो तो आखिरी पॉइंट
नहीं, आखिरी नहीं, देखिए हमें थोड़ा स्पीड अप करना ना.
मतलब वो फिर मैं अपने नोट्स की आखिरी पेज
नहीं, आप आ जाए मैं और लोगों को भी सुनना है ना.
मैं बिल्कुल जी, मुझे तो
आप लाहौर नहीं जा सकेंगे
सर. मैं आज लाहौर में गया तो जी मैं लाहौर शायद कभी भी नहीं जा सकूंगा.
ये भी हो सकता है.
तो इसलिए मुझे प्लीज आज जाना है.
Motorway closes at 3:30. Motorway closes at 3:30.
चले देना जल्दी बताए ना.
I'll finish in 20 minutes. For me, the key to this issue, and I'll sort of jump into the last page of my argument. The key to this issue,
आपने लिखा हुआ है वो हम पढ़ लेंगे.
वो मैंने अपने लिए, मैं आपको दे दूंगा. मैं एक आध दिन में आपको दिया तो मैंने गाड़ी में कल टाइप किया जी, टाइम नहीं था मेरे पास. The key for me to resolving this issue really is in para 6. Of same judgment of Samirullah Baloch.
जी पढ़े.
A point which was put before the court, but then the court.
तोबा कॉन्सेप्ट.
तोबा को
हाँ वो डिस्कस किया, आगे जवाब नहीं उसका.
नहीं है. वो इसलिए कि उन्होंने कह दिया. And what they have said there, the reason they did not consider it, my lord, is also significant. He was, however, candid to accept, and where the court is dealing with Sardar Aslam's submissions here. He was, however, candid to accept that except for submitting their affidavits in court, his clients had not made any expression of remorse, regret or repentance before the concerned authorities or the public. And the question arises, what would have happened if that had been done? The way out, as I see it, and which something Samir Abloch doesn't deal with, is exactly because of this, that if this is established, that there is genuine repentance, there is, and penance has been paid, then the effect of the declaration can come to an end. And
again we are reading words into the constitution.
That is something, it's a question of interpretation. It is a question of interpretation. And
I just earlier posed a question. If I was the author of Imagine, it's not been written yet, Samirullah Baloch, and I'm hearing it for the first time, and I said it should be a 2-year ban. So it's entirely up to me what I do.
I'm not saying that there should be a fixed plan. That's the
I'm just saying what is the test before me. It's not because Samirullah Baloch has held this. That's the end of story. There must be a logical reasoning behind it, reaching that conclusion. So I'm saying if I was author, I say if that is 5 years, I do 5 years. Or I say that is much more serious, I do 2 years. So it's entirely my discretion.
But
unguided by any legal concept of constitution.
I'm not in favor of that at all. I'm not
asking you.
in that.
So it would be as valid a judgment as Samuel Baloch.
No, my lord, I am not saying that. I am not saying that. I am not saying that the judges should have a carte blanche to write whatever they want. Whatever they write has
Guiding principle बताइए ना हमें.
So Mr. Rosaire, your principle is that one principle or way out is that if there is a declaration, it can be washed away through penance and repentance immediately, whenever given. So if the declaration is given today, in 1 hour I submit an affidavit of repentance, the matter comes to an end, or is there a time frame?
No, my lord.
How would that work?
As they say, my lord, the devil is always in the details. My lord, 62(1)(f encapsulates 5 different concepts. Like, for example, there is a requirement that the candidate be non-profligate. Now, profligacy, the simple meaning is, spendthrift. You wasteful of resources.
Yes.
Now, that's something that's probably easier to
Suppose the
fix.
declaration is that there was a misdeclaration in a form which has left the declaration, then there is no direct declaration in any case. We are assuming that the declaration is that you're not honest because you're... So next day he comes and says, I'm very sorry, this will never happen again, sir. I'll never misdeclare ever. And he's repented. What else would you want him to do?
My lord, because the first, I don't agree with what your lordship has said in the first part of your statement. The fact that there is a form and there is something wrong with that is not enough. That is not enough to disqualify.
That's happening in all these cases.
No.
There is no declaration. The declaration is based on a construction. It says that the form is incorrect. The assets form is not incorrect. You've left out this paragraph. You've done this. That's all there is that they discover. And then they build it on that. They say, because this is omitted, you are not a mean. That's the declaration in every case.
But we are, your lordships and your ladyship are here precisely to see whether that's right or not.
So that's a separate...
Are here to see, but to
That's
be
not-
assisted by you.
So that's a separate basket of questions here. Then whether at all in any of these cases so far till date, is there a declaration looking straight into your eyes saying you're not honest because of the following issue? No, it's not. Nobody's saying that. One is just building, and that's what Samuel Baloch also says. You'll have to construe from the facts, and you say that you're not honest.
My lord, इसीलिए मैंने कहा था कि वो आप मुझे page 6 पे लेकर मेरे notes से, if I had through pages 2, 3 and 4, maybe I may have some submission. My lord, I am very clear that merely because somebody finds that I haven't dotted all I's and crossed all T's in my nomination form, I am dishonest. I am not saying that is correct. That's wrong. That's wrong.
Then in that case, Mr. Rosaire, there is no declaration ever so far in any case.
But the point is, what is the declaration to the contrary by a court of law that 62(1)(f contemplates? Where does that come from? And that's, I will make some submissions on that. For me, that's a formal process that has to be followed. It's not something that the RO can do. It's not something that the election tribunal hearing appeals against acceptance and rejection of nomination papers.
Or a constitutional court.
Constitutional court can do it. There is your lordship's judgment in 2010.
There could be mistakes made, but the question is
that is not a mistake. That's a conscious judgment by my lord, and I rely on it.
You know, I'm not noting anything.
My lord, so what I'm saying is, my lord, my submission was that for me the way out is provided by the logic, the rationale of Samuel Baloch itself. Samuel Baloch is deficient because it doesn't follow through with the consequences of its own logic. For example, so that's the problem. And if that gap can be filled, then there is no need to overrule Samuel Baloch. Samuel Baloch is a judgment
So,
of...
sir, on that point, that's why you want to take it forward. You said the Samuel Baloch gives an answer in paragraph 6 and there should be repentance, but it doesn't talk about it. And I asked you that how do we follow through? Then you say, no, there is no declaration. So please tell us, the declaration is just the way it is. When does the repentance kick in and how do you bring that in?
There are 2 stages. First, there will be a declaration by a court. There will be a declaration by the court, and that declaration would be for the purposes of 62(1)(f). One problem with Samuel Baloch is that it doesn't really deal with what proceedings, what nature of dispute would lead to this declaration.
Mr. Bhandari, in paragraph 36 of the Samyojna, there is a word declaratory judgment. The declaratory judgment, what is the declaratory judgment? By the civil court or the high court or the supreme court?
My lord, it is, and I heard submissions on that also, my own submission, and I'm guided by my lord's judgment in 2010 Lahore. This is not a declaration in terms of section 42 specifically. It's a constitutional declaration. It is not shackled by the constraints of section 42 specific relief act. It is, and this is not the first time that the constitution has provided for it. Kindly look at article
How to give the declaratory judgment unless you examine and cross-examine and produce, allow to production of evidence?
Absolutely.
How you can reach the declaration?
That has to be done. It can't be done without that. But आप कहते हैं कि अगर वो deficiencies, if we give any detail of those deficiencies, वो पूरी कर ले तो फिर वो ठीक है लगता है. मैं तो कह रहा हूँ लाइफ बैन है ही नहीं, वो लाइफ बैन है ही नहीं, क्योंकि अगर आप रिपेंटेंस कर ले, अलाउ मी टू सबमिट माय लॉर्ड. और समीला बलोच ने ये डिस्कस किया है कि कॉन्स्टिट्यूशन में और भी सिचुएशंस हैं जहां डिस्क्वालिफिकेशन कोर्ट की जजमेंट से फ्लो कर रही है, और कहा है कि जी वहां भी ये है कि जब तक वो कोर्ट की जजमेंट इफेक्टिव रहेगी तब तक डिस्क्वालिफिकेशन रहेगी. फॉर एग्जांपल 63(1)A, 63(1)B, 63 जब कोर्ट की डिक्लेरेशन सेक्शन 45 मेंटल हेल्थ ऑर्डिनेंस का कहता है कि अगर कोई पहले डिक्लेयर हुआ है एज मेंटली डिसेबल्ड, अगर वो ठीक हो जाता है तो कोर्ट अपने ऑर्डर वापस ले सकती है, तो वो डिस्क्वालिफिकेशन खत्म होगी. सेक्शन 63(1)B अनडिस्चार्ज इंसॉल्वेंट को डिस्क्वालीफाई करता है, बट सेक्शन 41 ऑफ द इंसॉल्वेंसी एक्ट आगे बढ़े जी वो आगे बढ़े. बट आपके सर इन रिस्पॉन्स टू माय लॉर्ड्स क्वेश्चन काइंडली सी आर्टिकल 184(1) and 2. Article 184(1) says the Supreme Court shall, to the exclusion of every other court,
उसके लिए है ना declaratory judgment. It is with regard to the provinces and the federation.
Yes, but kindly read 184(2). In exercise of the jurisdiction conferred on it by clause 1, the Supreme Court shall pronounce declaratory judgments only. So this is a declaration created by the Constitution. This is not subject to any law. No law is required, nor can any law change this. This is a declaratory relief, a remedy created by the Constitution itself. And by definition, my lord, the declaration envisaged by 62(1)F cannot be given under section 42 unless you have banned section 42. For example, it says,
but this declaratory judgment is only in the context of clause 1
के लिए है. तो अगर आपका आर्गुमेंट चले, हम आगे नहीं एक सेकंड ठहरिए ना, आपने 184(2) का एग्जांपल दिया, तो आइन खुद तयन कर रहा है कि सुप्रीम कोर्ट डिक्लेरेटरी जजमेंट दे सकती है. जरा ठहरिए ना, 62(1)F में आइन ये नहीं कह रहा है. 62 में लिखा है कोर्ट ऑफ लॉ, या तो आप कहें वो इम्प्लाइड सुप्रीम कोर्ट एक्टिंग अंडर 184. इधर लिखने में क्या दुश्वारी थी?
मैं अर्ज कर देता हूँ,
ये तो सारी चीजें मेरे अदालत ने की है ना, आइन ने तो नहीं की है.
अग्री. लेट मी जस्ट एक्सप्लेन कि मैं क्या कह रहा हूँ. पहली बात मैं ये कह रहा हूँ क्योंकि ये आर्ग्यू भी हुआ कि जी ये, और आपने भी सवाल पूछा कि ये क्या डिक्लेरेटरी जजमेंट है. मैं ये कह रहा हूँ कि जी ये जो डिक्लेरेटरी जजमेंट्स का कॉन्सेप्ट कॉन्स्टिट्यूशन में है, ये सेक्शन 42 वाला नहीं है. नहीं तो ठीक,
यहाँ भी लिख देते हैं.
नहीं सर, वो इसके अंदर है. मैं आपको स्पेसिफिक है. मैं ये कह रहा हूँ कि ये जो है, ये डिक्लेरेशन ये सेक्शन 42 में दी भी नहीं जा सकती, आपकी अपनी जजमेंट है.
फिर वो मान ली बात,
नेगेटिव, ये तो नेगेटिव डिक्लेरेशन है. देयर बी नो जजमेंट टू द कॉन्ट्ररी. सो द डिक्लेरेटरी जजमेंट हैज टू से दैट समवन इज नॉट ऑनेस्ट, समवन इज नॉट.
way to draw the strength from that. कहाँ से कॉन्स्टिट्यूशन में लिखा है कि ऐसी डिक्लेरेशन दे सकते?
नहीं, मैं तो कह रहा हूँ कि ये पहली my point number 1 is that this is a unique kind of declaration which is not given in terms of section 40.
मैं तो ये कहता हूँ, ये एक एग्जाम्पल, अब आपको एक एग्जाम्पल दे देता हूँ. एक केस है सिविल केस, ठीक है, या क्रिमिनल केस ले लीजिए. एक गवाह आकर के झूठ बोलता है, कोर्ट उसको परजुरी के तहत उसको कन्विक्ट कर देती है, परजुरी के तहत. Is he disqualified for? It's a declaration now. You are a perjurer. You have lied in court on oath. You can't possibly be honest. So he's not allowed to contest elections for life. इसका जवाब दे दे.
मतलब मेरे ख्याल में तो he is not disqualified on that basis.
तो फिर तो it will directly conflict हो गया ना सर. खत्म हो जाती बात.
Because आप जब किसी को परजरी देखिए
तो डिक्लेरेशन हो गया ना, कोर्ट ने उसको कन्विक्ट भी कर दिया.
मैं जवाब
सुप्रीम कोर्ट ने फोल्ड भी कर दिया. चलिए
मैं आपको जवाब देता हूँ. आर्टिकल 10 में उसका जवाब है. वो कैसे? Let me explain. Article 10 में says there will be due process and fair trial. An elementary principle of due process and fair trial is notice of the charge against you. Now, when somebody is being tried for perjury, is he under notice that he will also be disqualified?
Then that sort of kills the whole thing. अब आपके मुताबिक 62(1)(f की डिक्लेरेशन कहाँ से आ रही है?
मैं आपको आप
just explain that.
वो कई स्टेजेस पे कई फॉर्म्स पे आ सकती है. स्टेप नंबर 1 बाय प्रोसेस ऑफ एक्सक्लूजन चलते हैं. सबसे पहले आरओ के पास नॉमिनेशन पेपर्स जाएंगे. वो नहीं दे सकते. It's not a court of law.
He has to be shown some declaration at that time from some court of law.
By some court of law, and that declaration has to be specific for the purposes of 62(1)(f).
वो कहाँ से, मतलब give us an example.
मैं चलता हूँ. हम स्टेप बाय स्टेप वो स्टेजेस के थ्रू जाएंगे, शायद मेरी बात क्लियर हो जाएगी. The fact कि आरओ नहीं दे सकता has already been held by this court in Aladino's Bhaios case, PLD 2020 Supreme Court 591.
अभी वो नोट किया
जी ठीक है. नेक्स्ट स्टेज, आरओ ने फैसला किया, अब हम इलेक्शन अपील में चले गए. आर्ग्यूबली अब ये प्री इलेक्शन है. आरओ ने ये फैसला किया, इलेक्शन अपील में हम आ गए. अब इलेक्शन अंडर सेक्शन 63 of the Elections Act, election tribunals comprise generally of sitting judges of the High Court. So they are judges, but then acting as persona designator. So arguably, if they have admitted facts before them, they have admissions, or they have undisputed facts before them, then they can make this declaration.
At best would be regarding the fact that yes, there was a mistake in filling the form. That's the mess.
Or there can be something more than that. Something more than that. For example, an objection is filed that this gentleman has already been convicted for perjury. That's an objection taken before the election tribunal.
Convicted.
So that is when the election tribunal, if it is a court of law, can arguably make that determination that whether this conviction for perjury actually
नहीं ऐसे नहीं हो सकता. या देखें, ये बात आपकी बिल्कुल आप कॉन्ट्रडिक्ट अपने आप को कर रहे हैं. या तो आप कहें कि परजुरी का डिक्लेरेशन आ गया, कन्विक्शन आ गया, सुप्रीम कोर्ट ने होल्ड कर लिया इन दैट लाइन ऑफ रीजनिंग कि ये कन्विक्शन परजुरी का हो गया. फिर कोर्ट के पास कोई चारा नहीं, वो कहेगा तुम ये डिक्लेरेशन है, यूर आउट. फिर कोर्ट बैठ के करेगा क्या? या तो आप ये आर्ग्यूमेंट लीजिए, या आप उसके बरक्स आर्ग्यूमेंट लीजिए कि वो वाज इन द कॉन्टेक्स्ट ऑफ गिविंग फॉल्स एविडेंस इन अ पर्टिकुलर केस व्हिच विल हैव नो बेयरिंग विथ रिगार्ड टू एन इलेक्शन मैटर. यू कांट हैव अ मिक्स एंड मैच. जैसे अच्छा एक जज बैठ के कहेगा हाँ ये तो हो गया डिस्क्वालिफिकेशन, दूसरा जज कहेगा नहीं हुआ डिस्क्वालिफिकेशन.
ये जो आपने सेकंड पॉइंट किया है, दैट इज एग्जैक्टली माय पॉइंट कि जो कन्विक्शन है फॉर परजरी, दैट इटसेल्फ इज नॉट डिसाइसिव. वो तो कानून शहादत के नीचे भी डिसाइसिव नहीं है.
आप कहना है फिर तो आप कहिए ना कि समीउल्लाह बलोच इज रॉन्ग.
Samiullah Baloch doesn't deal with this issue. That's my point. The Samiullah Baloch doesn't deal with the issue of how, in what proceedings, by which forum will this declaration be given.
That's correct. ना कह रहे हैं wrong है.
मैं ये कह रहा हूँ it is deficient.
नहीं देखें ना,
that's why I'm saying it is deficient because it does not deal with this.
But that creates a problem. Samiullah Baloch says that disqualification is for life because of this very declaration by a court of law, and yet it does not deal with the fact that where is this declaration actually coming from.
Yes.
So it is very important to understand because various counsels are given a different viewpoint on this. Is it that when the nomination papers are filed, the RO will sit there, but somebody is going to produce a declaration from a court saying that this person is not sagacious, or will the RO start determining that? So if it is to come from outside, some other court, फिर किसी court की declaration is specific होगी ना that this person is not honest. Now I don't know of any declaration that can be possible under 42 which would say that he is not honest. So मुझे ये पहले तो ये this conundrum तो solve ही नहीं हो रहा ना कि declaration आएगी कहाँ से?
42 की declaration.
अच्छा मैं एक और चीज कहता हूँ. मैं कहता हूँ declaration as envisaged under 62(1)(f cannot be legally passed. Hang on. Now hear me out. first word in 62(1)(f) is it can never be passed. Now please chew over this concept. Sagacious. Which court of law can ever determine this? It cannot be passed. A declaration to the contrary. We are not the क्या कहते हैं जो Spanish Inquisition की जो court say. No court, unless you tell me, yes, a court can pass such a declaration of sagacity. Can a court pass a declaration of righteousness? Can a court pass a declaration of non-profligateness, honesty, and Amin? You cannot pass these declarations. I gave you a tangible example, even that you can't handle. I said, what about perjury, conviction of perjury? Which court? You said, a court of law, a court of law. So I am now a civil judge and I say, you are not sagacious, Mr. Uzair Bhandari, because you misled me in that case. You cited a judgment of the High Court which was overruled by the Supreme Court. You are not an honest lawyer. Is that a declaration? So I am saying these are just words on a piece of paper which are utterly meaningless. What would you say to that?
My lord,
I'm just proposing this, not holding it, mind you.
My lord, actually, if your lord, since I am in that happy position that I mentioned, I agree with your lordship. These are not enforceable standards. These are given in the constitution.
There is a problem we're facing.
So, as my lord, as a citizen and as somebody who knows something about politics and constitution, for me, these are completely amorphous, subjective, vague concepts which are not judicially enforceable. But we have to give some meaning to
Mr. Uzair, it's a wish list. It's a wish list. It's a wish list. Mr. Uzair, we could go along with that.
If the lordship says that, then that takes care of all the problems.
Mr. Uzair,
these are not enforceable standards.
We could take this to be a wish list and this could be used by the electorate for whatever subjective analysis whenever they want to. But the point is, we cannot attribute redundancy to the Constitution either.
Yes.
So that's we have to figure out what does this mean. So first of all, it is very clear to all of us now that there can be no declaration saying you're not sagacious. वो बताए ना.
मैं इसीलिए तो कह रहा हूँ वो आप मुझे अगर sequentially चलने दें. That's how
मुझे
I have proceeded.
आपको हमने engage किया किसी ने कि यार ये मेरा मुखालिफ है, ठीक है, इसको डिस्क्वालीफाई करो. अब आप सूट बनाएंगे, क्या बनाएंगे जिसमें कहेंगे ये सजेशियस नहीं है, जरा बना दीजिए मुझे और प्रेयर मांग लीजिए उधर.
मैं क्योंकि ये नेगेटिव डिक्लेरेशन है,
ये से मांगेंगे प्रेयर.
मैं प्लेन ड्राफ्ट करना तो प्रॉब्लम नहीं है, उसको प्रूव करना मुश्किल नहीं.
बताए ना मुझे ड्राफ्ट करते मैं
एज आई सेड, जब डोनाल्ड रम्सफेल्ड ने कहा था वी जंप ऑफ दैट ब्रिज व्हेन समवन पेज मी फॉर इट आई विल थिंक अबाउट इट. नोबडी हैज पेड मी.
जुडिशियल मैकेनिज्म क्या होगा ये बताया ना जी. संजुल्ला केस में अगर आप पैरा 35 देखें, आखिरी 4 लाइनें लिखी हुई हैं. The judicial mechanism in Article 62(1)(f) of the Constitution grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate himself. What is the judicial mechanism?
वो नहीं दिया समीउल्लाह बलोच में.
इसमें लिखा है, समीउल्लाह से पढ़ रहा हूं मैं.
नहीं दिया. उन्होंने
ये नहीं कह रहे नहीं दिया, वो कहते हैं कि बड़ा अच्छा जुडिशियल मैकेनिज्म दिया हुआ है इसके अंदर टू विंडिकेट द ऑनर ऑफ दैट पर्सन.
यस.
तो व्हाट इज द जुडिशियल मैकेनिज्म?
वो मल्टीपल, मैं यही अर्ज कर रहा हूँ जी, वो मल्टीपल मैकेनिज्म्स हैं. वो कैसे प्ले आउट करेंगे मैं वो बता रहा हूँ. पहली बात, जैसे मैंने कहा कि जी आप इलेक्शन प्रोसेस देख लेना जी, एंड टू एंड कहां पे ये चीज हो सकती है. आरओ के पास नहीं हो सकती. अगर कोई प्रायर डिक्लेरेशन नहीं है तो आरओ खुद डिक्लेरेशन कर रहे हैं.
आप रिपीट कर रहे हैं कि हमें सिर्फ इतना बता दें, आरओ के पास ही पेश तो हो सकती है ना कोई डिक्लेरेशन. आप हमें बताएं डिक्लेरेशन आएगी कहां से?
माय लॉर्ड, वो डिक्लेरेशन
कहां से आएगी?
आर्टिकल 199 में.
199 में, एक सेकेंड, 199 में you're only there to declare an act of a public functionary to be correct or incorrect or wrong, or right? How could you go ahead and declare a private person to be non-sagacious in 199?
My lord, why can't I file a writ of quo warranto against somebody holding a public office that he is not entitled to?
He doesn't have the qualifications. Fine. चलो उसने कह दिया, हाई कोर्ट ने कहा कि आपके पास क्वालिफिकेशंस नहीं है, quo warranto में cannot hold this seat. Does that mean he's not sagacious?
No, but I can
the High Court can grant that declaration.
From how I कहीं लिखा नहीं, उन्होंने तो सिर्फ सेट डिक्लेयर करना है कि ऑर्डर ठीक है गलत है।
बट अगर उसमें डिटर्मिनेशन ये होती है कि वो इसलिए
every time we pass an order in co-warranto, we must also go ahead and say this guy is not honest.
आप को-वारंटो में या किसी भी किसी भी पिटिशन में वही आप ग्रांट करते हैं जो रिलीफ में मांगा होता है। दूसरों को तो आपके पास 199 में पास नहीं है। तो अगर कोई
199 में गाइडेड बाय दिस ना, 199 में मुख्तलिफ चीजें सर्चुरारी है, मैंडेमस है वगैरह वगैरह। तो मैंने तो आप पब्लिक फंक्शनरीज के एक्ट्स को सेटिसाइड कर रहे हैं या ठीक है, that's about it. We just declare that this action of the government or this public authority is incorrect. Now we don't go ahead and say that this private respondent in this case, or maybe even that public functionary who was doing this, who's passed this act, is dishonest or not a mean. Where is it coming from? So समझ ये आ रही है कि कॉन्स्टिट्यूशन कोर्ट्स में तो ये हो नहीं सकता, 42 में आप प्लेनली कोर्ट से भी नहीं कर सकते। तो पहला सवाल तो ये है कि डिक्लेरेशन आएगी किधर से?
मेरा ख्याल मेरी सबमिशन ये है कि आप 199 में भी कर सकते हैं। आप कोर्ट्स ऑफ प्लेनरी जुरिसडिक्शन
भंडारी साहब वारंटों में कर सकते हैं ना,
क्वेश्चन नहीं पर ये इसे फर्दर क्लियर करने के, लेकिन वो इन लाइन विद आर्टिकल 62 होनी चाहिए एज पर योर आर्गुमेंट। जैसे सेल डेफिनेशन प्रीएम्पशन एक्ट में डिफरेंट, सेल ऑफ गुड्स एक्ट में डिफरेंट, ट्रांसफर ऑफ प्रॉपर्टी एक्ट में डिफरेंट। अब उसके अंदर जो भी डिक्री होगी वो फॉर स्पेसिफिक पर्पस। जी। अब इसमें आर्टिकल 62 के तहत जब तक डिक्लेरेशन नहीं होगा दैट विल नॉट बी इफेक्टिव।
बिल्कुल ठीक है, दैट्स व्हाट आई एम सेइंग।
Before the start of election, how a person can be declared that he is not entitled to contest election if even he was a public servant and there is a declaration of writ of co-warranto against him? How that declaration can be used?
My lord, अब 62 देखिए, आप co-warranto तो हर होल्डर ऑफ पब्लिक ऑफिस के पास हो सकती है ना।
जब पहले होल्ड कर लेगा, ये तो इलेक्शन स्टार्ट ऑफ इलेक्शन है, he is going for election।
किसी पार्लियामेंटेरियन के खिलाफ भी तो हो सकती है ना। अगर 62 में ये
पब्लिक ऑफिस में आएगा तो रिमूवल होगी ना उसकी।
तो ये एंटर करने के लिए
प्रिंसिपल तो आपको पता है ना कि हाउ ही इज होल्डिंग द पब्लिक ऑफिस, ही शैल बी रिमूव्ड।
मेरी एक सबमिशन है विद ऑल ड्यू रिस्पेक्ट। I'm here as an amicus. Let me give my views. If you persons don't want to accept it, then right.
Everything you said.
I feel I'll be cross-examined as if I am.
No, apologies.
I'm not a party.
Relax. Totally agree with you. Totally agree.
Clarity. Just for clarity.
I'm only turn around and say I want to withdraw my amicus brief.
Ready. अच्छा चलिए, आपके अगला पॉइंट बताएं।
नहीं, अभी भी खत्म नहीं हुआ जी। अब आप लिख लें, आप शुरू करें। नहीं, जहाँ से सिलसिला टूटा था वही शुरू करें। मैं आज ये कर रहा हूँ, दिस इज द पॉइंट, इट डिपेंड्स ऑन द नेचर ऑफ प्रोसीडिंग्स। ठीक है, मैं अब थर्ड स्टेज पे आ जाते हैं। मैं लेट मी गो एज पर द स्ट्रक्चर ऑफ माय ओन आर्गुमेंट। सो माय लॉर्ड, आई से stage 2 was appellate tribunal against the RO, can't do it, most probably not a court of law. Third stage, where the order of the election tribunal hearing an appeal against the RO's order is challenged in writ petition. That's Article 199. My submission is it can be done by the High Court in that, and your Lordship did that in Muhammad Jameel versus Amir Yar, PLD 2010, Lahore 583. Your Lordship actually did that. Your Lordship discussed 621F, rejected domination papers. That was precisely the entire dispute was in the context of an election matter, somebody's eligibility to contest elections, somebody's qualifications, and the facts spoke for themselves. And your Lordship has dealt with them in great detail there.
I see no reason why doing that, why exercising that jurisdiction, this unique constitutional declaration, and that's how your Lordship Justice Mansoor described this. This is a constitutional declaration, not a Section 42 declaration. Why it can't be granted in the exercise of Article 199? In my humble submission, it can be, and your Lordship did not actually grant that declaration, but could have done that. The facts actually justified that, the admitted facts. Well, then I come to the next point. Supposing I'm still at the pre-election stage. And here, co-warranto can come at any point in time, but I'll deal with it at the post-election stage. If pre-election stage, then, my lord, in my humble view, a declaratory suit before a civil court ought also be competent. Your lordship, I know in the same case, Mohammed Jamil versus Amir Yar has held that no declaration can be granted to this effect. And that's consistent with the law that your lordship laid down in Laila Qayyum case 2019.
I need to help. Don't mind my saying interjection. Again, we want to simplify things, not complicate things. What you are doing, with respect, we want the RO, he has to take a returning nomination paper. उसकी जिंदगी में आसान बनाना है, मुश्किल बनाना है, हमें क्लैरिटी लाना है. इतना कंफ्यूजन जो आप तो this is making it more confusing. सिंपल सी बात है, कब वो नॉमिनेशन पेपर रिजेक्ट करे, कब वो उसको एक्सेप्ट करे. अगर कोर्ट में पहले वो डिस्क्वालीफाई हो चुका है तो जिंदगी भर के लिए है या 5 साल के लिए, इस पे आप आ नहीं रहे हैं. आप कह रहे इधर हो सकता है डिक्लेरेशन, उधर हो सकता है डिक्लेरेशन, तो आरोप हम क्या लिख के बता के क्या उसको इंस्ट्रक्शन दे दें कि भाई ऐसे कर देना काम.
ये उसी से रेलिवेंट है, तो बिकॉज आपने आरोप को ये भी तो बताना है कि उसके सामने क्या और कहां से आएगा, तो उसने क्या करना है.
एक ही जगह से आएगा, उसको कहते हैं नॉमिनेशन पेपर.
नहीं, बट उसने अगर ये डिसीजन लेना है कि ये उससे 62(1)(f) लगाना है कि नहीं लगाना, तो
जवाब देना इस बात.
ये भी देखना है कि वो उसके सामने क्या मटीरियल आ रहा है. और मैं ये कह रहा हूँ,
आप क्या कर, वो कोर्ट ऑफ लॉ बना दिया, उसको उठा करके उसको हजारों नॉमिनेशन पेपर जिनमें देखना.
मैं तो नहीं कह रहा सर, तो
जरा सर आप हमें असिस्ट
मैं ये कह रहा हूँ, आज एक आरोप के सामने कोर्ट ऑफ लॉ की डिक्लेरेशन देखनी, और मैं कह रहा हूँ कोर्ट ऑफ लॉ में हाई कोर्ट एक्सरसाइजिंग जुरिसडिक्शन अंडर 199 आएगा. ये मेरी समझ. वक्त आएगा जब इलेक्शन होंगे, एक शख्स एक पब्लिक ऑफिस होल्ड करेगा, फिर जाके फिर उसमें दूसरा क्वेश्चन नहीं आता है. जब वो एक शख्स पब्लिक ऑफिस होल्ड करता है तो कोर्ट विल डिस्क्वालीफाई. Once he was qualified, he held the office. Subsequently, the High Court can, according to the Court, can disqualify. अब disqualification 63 में दी है, वहाँ में 62(1)(f) की वर्डिंग्स ही नहीं है. तो इसका डिस्क्वालिफिकेशन इस बात पे नहीं हो सकती.
We invited you to help clarify. Sorry, I'm becoming more confused. You are not taking any position. You're saying this भी हो सकता है, this भी हो सकता है. Let's go to the जाएं कहाँ?
When it comes to let's go to the basics करें ना उस पर.
ये आर्टिकल 62 और 63 में हमें जरा बताएं, इसके बारे में आप क्या कहते हैं? Are they different? Are they intellect? आपके ख्याल में how do you see 62? What was the need of having a separate article 62? They could have easily had it in 63. Famous के ज़हन में क्या?
Possibly, they could have had sort of one set of sort of conditions which covered both. They could have done that. They chose to do that because conceptually, and this is how it's been analyzed, they relate to two different things. Qualifications are positive attributes that some aspirant to an office must have. These are positive qualities that he or she must have. Disqualifications are attributes that he or she should not have. If those negative attributes are there, then they will take away his fitness or his or her fitness or competence to hold a particular office. Now, they are linked, as I said. They are like Siamese twins. They are linked. But the reason they have been set out separately is that there are provisions, and I can point out two, for Article 41 and Article 100, which use the word qualified. They do not use the word disqualified.
So Article 41 is about the president. Article 100 is about the attorney general, and I believe the same provision will apply to the advocate general. So if I can just finish this, see, they deal with qualification only, and it has been held by courts that in order to determine whether such and such person can be the president of Pakistan or the attorney general of Pakistan, then only the contents of Article 62 will be looked at, because the word qualified is used in those articles and not Article 63. आप किसी बात पे नहीं चलते हैं, दो मैंने आपको बताया, रफीक कागज केस एक मैंने आपको बताया, देखिए आप किसी बात पे नहीं चलते हैं. सपोज एक शख्स क्वालिफाई कर जाता है, उस पे सबसे एक शख्स क्वालिफाई कर जाता है 62(1)(f) में क्लियर हो जाता है, साल बाद 2 साल बाद वो अमीन भी नहीं रहता, वो उस क्या कहते हैं उनके सगेजेस में नहीं रहता, राइटियस भी नहीं होता. अब एक शख्स उसको निकाल, आपको जाते हैं कि हम इसे निकालें, तो इसको डिस्क्वालीफाई करना पड़ेगा. मतलब तो उसके खिलाफ रेट ऑफ करंट फाइल होगी, 63 में आएंगे ना, वैसे आएंगे तो 199 में. डिस्क्वालिफिकेशन के लिए 63 आर्टिकल 63 दिया गया है जी. अगर आप 63 पूरा पढ़ लें, वहां पे 62(1)(f) के वर्ड्स ही नहीं है, तो डिस्क्वालीफाई किस बात पे करेंगे? डिस्क्वालिफिकेशन की बात नहीं है सर, आप वेरीफाई कर चुके हो, पीरियड खत्म हुआ नहीं, बाद में खराब हो जाता है सर. ये तो इलेक्शन सेक्शन 156 इलेक्शन एक्ट भी देखें तो वो भी कहता है कि इलेक्शन ट्रिब्यूनल इस बिना पे इलेक्शंस को सेट असाइड कर सकता है कि जो नॉमिनेशन थी वो इलेक्शन सेट असाइड की बात नहीं हो रही है, उसके डिस्क्वालिफिकेशन की बात हो रही है. डिस्क्वालिफिकेशन की जितनी बातें हैं वो 63 में बताइए, लेकिन 63 में 162(1)(f) का एक लफ्ज नहीं. बट सर अगर उसके खिलाफ कैसे डिस्क्वालीफाई कर, अगर वो कोवरेंटो है तो उसमें ये भी हो सकता है कि वो 62 में क्वालिफाइड नहीं था, तो इस बिना पर भी हो सकती है, कर गया वो उस बिना पे कोवरेंटो उसके खिलाफ हो सकती है. और आपने वोट किया हुआ है मल्टीपल जजमेंट्स में ये चीज कि ये हो सकता है.
जी भंडारी साहब, आई हैव नॉट रिटन अ वर्ड. हमने आपकी बात यहाँ तक नोट कर ली 184. We have to hear others also. So we have to be a little precise. Precise करें ना. Please continue your submission.
I can only apologize and then
no. But आप कह रहे हैं जरा points, वाला point बताएं ना. Please continue with your submission. आप मेरा मतलब ये जरा अभी have to move ahead.
मैं उसी का सवाल यही है जी कि आरोप
ये ना बताएं सवाल ये आप बताएं.
मैं उसी पे कर रहा हूँ कि ये डिक्लेरेशन सवाल, या तो ये सवाल एड्रेस करने की जरूरत नहीं है कि डिक्लेरेशन कहाँ से आनी है, तो आई मूव ऑन. अगर तो ये सवाल है तो आई कैन एड्रेस इट. आप ये देख लें कि जी डिक्लेरेशन कहाँ से आनी है.
जो अपना आपने जो जिस लाइन ऑफ आर्ग्यूमेंट आपने तैयार किया है, प्लीज कंटिन्यू विद इट और प्लीज कैरी ऑन.
आई एम ग्रेटफुल माय लॉर्ड. I can conclude quickly if I can. My continuing with this point and with apologies to the Honorable Chief Justice, the declaration
we would love to, let me clarify, we would love to hear you. Well, this is a case we cannot afford the kind of leeway which we already grant, because there's an election, there's a scheduled election program, और फिर हमें order लिखना भी होगा.
My lord, absolutely. I am trying to address a question that has been repeatedly raised, and I'll very quickly do that. Because this question has been raised, whether declaration can be granted under section 42 or not. My submission is that the declaration contemplated by 62(1)(f) cannot be granted under section 62, but it can be granted by a civil court under section 9 CPC, because the civil court is a court of plenary jurisdiction. It is not a section 42 declaration, it is a constitutional declaration. And your lordship may just note, in Aladino Bhayo's case, the court said that this declaration can be granted by a court of plenary jurisdiction. I believe other case law has also been cited on it, so that can be done. My lord, then your lordship may note that there is case law, and I believe one counsel cited AIR 1967 Supreme Court on this. Actually, that judgment has been followed in Pakistan by the late Justice Sabiuddin in Arif Majid Malik versus Board of Governors 2004 CLC 1029, to say that section 42 is not exhausted.
and other declarations can be granted in terms of section 9 CPC. So if somebody has a problem, and we can leave the mechanics and proof to one side. If somebody has a problem against a prospective candidate, my humble submission is he or she, provided locus standi can be established, can go to the civil court and seek this declaration. That is.
So the argument is that there could be a section 42 declaration.
Not section 42.
But you said it's not exhaustive, so it could be.
It could be if your lordship could. Otherwise, it could be in terms of 62(1)(f) and read the section 9 CPC.
Yes, still with the plenary court of
yes, court of that can be. So, my lord, so this for me concludes the pre-election period. Then in the post-election period, I say election tribunal is the court contemplated by 62(1) hearing an election petition. The election tribunal can do that. And the fact that it's called an election tribunal is not determinative. Your lordships in Sheikh Riazulah's case, PLD 2013 Supreme Court, held that the Federal Service Tribunal, though it is labeled a tribunal, is actually a court. So, and even in the Elections Act, the election tribunal has all the powers of a civil court, will follow CPC and Qanun-e-Shahadat order, record evidence.
So now you explain the declaration kahan se aayegi.
So yeah, and then my submission is that it can also be granted in a writ of quo warranto. And quo warranto, for example, my lord, quo warranto in Khaja Asif's case, 2018 SCMR 2128, and I'm citing this by way of example. That quo warranto was about Khaja Asif's eligibility to hold the office of a parliamentarian. So while adjudicating that kind of a quo warranto against that kind of a holder of public office, then this declaration can be made. But for example, if the quo warranto is against the chairperson of OGRA, then that quo warranto can be allowed, but this declaration can't be granted. So it would depend on the nature of the dispute and nature of the proceedings, nature of the relief.
When quo warranto can be issued against a person if declaration is shown to the High Court.
No, still the High Court can itself grant the declaration.
On admitted facts, not on factual.
No, but the quo warranto is by definition inquisitorial. The High Court can conduct. That is why quo warranto under Article 199 1B is on the application of any person, not on the application of an aggrieved person. It is like laying information. The court can examine witnesses. Well, it has. The High Court is
clear on the declaration coming from these sources. That's fine. Now comes the duration of it.
My lord, I will come. My lord, your lordship, just look at para 35. Samuel, well, just one other point, which sort of in all this sort of forwards and backwards, I sort of skipped. The other problem, I think conceptually this will help, certainly this line of thinking helped my analysis. One deficiency in Samuel Baloch, as I said, is it doesn't identify what it meant by what Justice Mother said, the judicial mechanism. Now it seems Samuel Baloch said that any finding given in any civil proceedings will suffice. In my humble view, that's incorrect. Because the finding of dishonesty can be given even in criminal proceedings which may not attract 63(1)(d). For example, section 489F actually has dishonest issuance of a check. Dishonesty is an ingredient of the offense, but it may not attract 63(1)(h). So this finding of dishonesty can be given even in criminal context. So that Samuel Baloch, in my humble opinion, is not correct. Number two, and this is more important, a finding of even on the civil side, a finding of dishonesty or profligacy or whatever can be given in any number of proceedings. For example, in a winding up petition, the company judge can say, or in a 290 petition of minority oppression petition, the company judge can say that such and such director was dishonest and he embezzled the funds of the company.
That's a finding of dishonesty. In a suit for specific performance, the court can hold that the plaintiff forged the agreement itself.
We got the point. ये हमें समझ आ गई. अब अगला बात बताए ना.
इसको मैं
आपके साथ बहुत तरीकों से हो सकता है ये.
जी ये हो सकता है. मैं ये कह रहा हूँ कि ये सारे जो हैं ये 62(1)(f) की रिक्वायरमेंट्स मीट नहीं करेंगे. अगर कोई और प्रोसीडिंग्स है
वो बता देना वो कौन सी चीजें 62(1)(f) की रिक्वायरमेंट्स मीट वो
बता दिया. वो मेरा ख्याल में सूट फॉर डिक्लेरेशन भी हो सकता है. अगर किसी ने डायरेक्टर जिसको के खिलाफ कंपनी जज ने फाइंडिंग दी है उसको ये मंशा है कि उसको डिस्क्वालीफाई कराया जाए या तो फिर उसको 62(1)(f) की डिक्लेरेशन सिविल कोर्ट से लेनी पड़ेगी. सो इट्स अ टू टियर थिंग. दैट्स माय सबमिशन.
चल ठीक हो गया. There's an exclusive category of declaration according to you that will attract 62(1)(f) declaration.
जी.
Not all declaration.
Not all declaration. So
now we come to the duration of it.
Duration. So इसमें again for me the key is para 35 of Samuel Baloch where the court held. In sixth line, it may also be noted that the Constitution envisages other situations in which a permanent bar to the eligibility of a candidate for election is enforced, so long as the judgment that records or justifies the disability of the candidate remains in existence and occupies the field. This view is supported by Article 63(1)(a) and 63(1)(b) of the Constitution that provide disqualifications on account of judicial declaration regarding the mental unfitness or the undischarged insolvency of a candidate. These disabilities also continue so long as the adverse judgment is in the field. Now, this for me, I've already explained the point, but this is the context. That this for me is the main plank of reasoning.
That's right. You call it indefinite rather than life.
That's why I'm saying
it can be done.
So, my lord, then the question then arises: how do you limit or make the declaration, which, as I said, it is given in terms of 62(1)(f)? How do you make that time bound or do away with it? My lord, as I said, the key to understanding that is para 6, which I read. My lord, the Chief Justice has alluded to that. The concept of repentance, but that will have once you have that declaration against you in terms of 62(1)(f), then you need another declaration in terms of 62(1)(f). This is also something that
of repentance
that now you have reformed.
You will file a suit for repentance.
This is
जैसा देखिए ये हम सारी बातें हवा में कर रहे हैं ना, तो अब कोई सुन तो लेना भी सूट एक फाइल होगा. सर मुझे ये सजा मिल चुकी है, अब मैं रिपेंट करता हूँ, आप प्लीज डिक्लेयर कर दें मुझे कि मैं बड़ा अच्छा मुसलमान हूँ. अब ये सूट फाइल हो सकता है क्या?
बहुत से केसेस में
आपसे सवाल पूछना, स्पेसिफिक सवाल पूछना.
यस, मेरे ख्याल में 62(1)(f) में यही
सूट फाइल हो सकता है.
यही हो सकता है मेरे ख्याल में 62(1)(f) में
62(1)(f) doesn't confer jurisdiction on the plaintiff.
अगर आगे बढ़े ना
नहीं, वो तो सिर्फ एक
आप एक नई jurisdiction का
राइट दे रहा है.
ये आपकी व्यू है. प्लीज मूव ऑन टू योर
again in support of this again there is this line.
Note this, आप कह रहे हैं कि जो repentance वाला argument para 6 से है, that alone would not do, but a declaration to that effect will do.
Yes.
ठीक हो गया.
And then your lordship may note there are provisions, Article 66 to 69
of declarations. A lifelong of declarations to contest elections.
For me, really, the fault lies with the Parliament. They should have done away with this. They have given this can of worms to your lordship.
Please, not castigate other institutions.
They haven't sorted it out.
Let's not castigate other institutions. Let's focus.
I have the right to criticize them. They are my representatives. They have not done what they did. I have the right to criticize them.
No, you don't.
Article 66 to 69 of Qanun-e-Shahadat actually deal with character evidence. When good character is relevant, how can it be established, what is not admissible. So I am sort of relying on that those provisions can be used, and then if you can go to the court and establish that, okay, you committed a wrong, you were whatever you were in the past, but now you've reformed.
Have you come across any such repentance declaration which is reported?
Well, but there is none in the context of 62.
You could come up with one.
Well, you could, as I said, well, that's how I see the Faisal Wawda case, actually. That's I said.
There was no court declaration of repentance.
But there was no court. But what had been?
He simply just said, I regret and I will not contest election this time.
But your lordship felt that is enough repentance. Otherwise, what he had done felt
At the end of the day, you are saying it's all to do with our feelings.
no, my lord. Not
What
at
you
all.
just said.
Not at all. Not at
We felt.
No, because your lordship accepted that as enough of a repentance.
A person serves a full tenure. In the last days of his tenure, he says, I repent.
My lord, on the fact,
Does he return his emoluments? Does he do any penance?
my lord,
Because we felt. That's the jurisprudence now.
my lord, your lordship,
The feelings of the Supreme Court on a particular moment in time.
your lordship said
If anybody applying Wada's case could say that in this nomination papers that he rejected, I seriously repent and I will not contest these elections, and that's over, then he can contest the next elections.
well, it depends on whether
Wada's case.
that repentance, that penance is accepted by the court.
Depends on
That
whether
is-
the judges are charitable or strict.
No, my lord, it's more, in Wada's case, we were talking about bench number 1 of the Supreme Court.
Well, I'm just posing constitutional questions.
My lord, but in the way I see it, if you go,
देखिए मेरे हिसाब से जो सबसे खतरनाक चीज होती है और जो तबाही की तरफ गुजारती है हमें, जब आप बहुत ज्यादा डिस्कशन किसी को भी दे दें,
मैं बिल्कुल
चाहे जज को ज्यादा डिस्कशन दे दें, चाहे ब्यूरोक्रेट को ज्यादा डिस्कशन दे दें, जो मर्जी करो, जब कोई डिस्कशन स्ट्रक्चर्ड नहीं होता है ना, रीजन नहीं होता है, तो फिर तो मेरा हो सकता है हम दोनों मैं अपने तरीके से समझे बहुत सही है और मेरे साथी समझे बहुत गलत है, तो हम दोनों भी सही हो सकते हैं। तो अगर कोई प्रिंसिपल ना हो, कोई गाइडलाइंस ना हो, तो हम ये नहीं कि कोई बदनीयती से कर रहे हैं काम, मगर मेरे जहन में ये बात आ गई, उनके जहन में ये बात आ गई, स्ट्रक्चर डिस्कशन है ही नहीं।
मैं तो
और
ये कह रहा हूं।
एक सेकंड है, और आप जो मैं आपसे जो एक्चुअली एक्सपेक्ट कर रहा था, जो आपने बिल्कुल उसको नजरअंदाज कर दी उन बातों को, तो मैं चाह रहा था कि आईनी आप मुझे गाइडेंस दें। आईनी आपने तो सिर्फ फोकस कर दिया समीउल्लाह बलोच पे। भाई आईन के मद्देनजर रखते हुए किसी ने अभी तक आर्टिकल 17 का तस्करा नहीं किया है, जो कि प्रिस्क्राइब करती है डिस्क्वालिफिकेशन की सूरत हाल में। किसी ने इस बात का तस्करा नहीं किया है कि जी दूसरी जगह ज्यादा है और झूठ बोलने के लिए लाइफ टाइम हो गया, पाकिस्तान के खिलाफ अब बगावत करनी है उसके 5 साल हो गया। कोई लॉजिक भी तो होता है ना कोई चीज, या अंधाधुंध लकीर की वो क्या कहते हैं, मक्खी पे मक्खी मारे जाए। और कहें जी आप क्या मूड है, अगर आप समझते हैं फैसल वाबडा साहब ने रिपेंटेंट हैं तो ठीक है छोड़ दीजिए, अगर आपके मूड में नहीं है तो मत छोड़िए, उसको लाइफ टाइम बैन कर दें। ये सॉरी टू से ये दिस डज नॉट मेक फॉर सस्टेनेबल लॉ। सो प्लीज वी वांटेड अ लार्जर डिस्कशन। अभी ये मैंने बार बार भी जिक्र किया है, ये जो चीजें आई हैं आईन में, ये किस रास्ते से आई हैं? क्या लोगों ने पार्लियामेंट में बहुत सोच समझ के ये कानून साजी की? नहीं, उन पे थोपी गई ये चीजें।
हेलो नॉट 18th अमेंडमेंट, वो
बात ही नहीं सुन रहे ना। 18th अमेंडमेंट से पहले आया 62(1)(f।
उन्होंने ये 62(1)(f) तो उन्होंने निकाला है, किसी में
62(1)(f) को सिर्फ उन्हें वो ट्यूनिंग की उसकी निकाल दो। आप सुन लीजिए ना प्लीज। तो ये जबरन जो चीजें होती है ना, मेरी मर्जी वाली बात, एक शख्स की मर्जी पूरे पाकिस्तान पे हावी हो गई, उन्होंने फेट अकम्पली दे दी, कर लो या मैं बैठा रहूंगा 25 साल और। उन्होंने कहा चलो जी आप जाइए, हम कर देते हैं ये 8th अमेंडमेंट को और 18th अमेंडमेंट को, फिर वो आपका स्ट्रीट प्रोटेस्ट खतरा ये वो वगैरह आपने देख लिया तबाही जो पाकिस्तान में हो चुकी। कोई भी रिपेंटेंट नहीं और वो लोग फिर इलेक्शन लड़ रहे हैं। रिपेंटेंस हुई कोई? उन्होंने माफी मांगी किसी से? पूरे पाकिस्तान को वो बना लिया, होस्टेज बना लिया। ठीक है, बना लो पाकिस्तान को होस्टेज, आपकी मर्जी है। और हम इन चीजों पे खेल रहे हैं एक तशरीह पे, अब ब्रॉडर पिक्चर भी तो लगाए ना सामने। तो ये चीजें सारी आई हैं मार्शल लॉ डिक्टेटर्स के दौरान, आपको जिक्र ही नहीं करता इन चीजों का। I don't know, we are sitting in a constitutional court, we talk about the rule of law, मगर वकील से के मुंह से डिक्टेटरशिप के खिलाफ बात नहीं आएगी। ये क्या हो रहा है?
मैंने तो ना डिक्टेटरशिप के हक में की है ना खिलाफ किया। प्लीज अलाउ मी टू से नहीं कर रहे खिलाफ। मैं जितना डिक्टेटरशिप खिलाफ मैं 18th अमेंडमेंट वालों को उतना ही क्रिटिसाइज करता हूँ। देखिए वो तो आसान है ना, तो सारे पार्लियामेंटेरियन उनको क्रिटिसाइज करते हैं। आई नहीं पाते सर, जो बंदूक लेके बैठे उसके साथ नहीं लड़ सकता ना। जिसको मैंने वोट दिया मैं उसको अकाउंटेबल करूंगा। उन्होंने क्यों नहीं ये इशू रिजॉल्व किया? राइट, क्यों नहीं योर राइट टू आर्ग्यू टू हैव एन ओपिनियन एंड रिस्पेक्ट योर ओपिनियन। I am not saying कि ये एक शख्स की डिस्क्रेशन है। मैं इसीलिए कह रहा हूँ कि जी वो एक सूट के थ्रू ये हो, आप इस सजेशन को माने ना माने आपकी स्वागत है। आप बढ़े ना आगे, वो सूट होगा
टच नहीं कर रहे हैं, ये मैं कह रहा
सर। मैं उसी में आ रहा हूँ। अभी दो मेरे आर्ग्यूमेंट के दो फ्लैट्स। एक तो ये कि जी समीउल्लाह बलोच के अंदर से ये रास्ता निकलता है। आप समझते हैं
मिस्टर जैद, आपसे ये लेना चाह रहे हैं, we are on a micros and you are throwing this question that for a minute, if you imagine there is no Samiullah Baloch and the constitution is in front of you, how would you like to reach 62(1)(f) as an unlimited provision or with some time frame in the totality of the constitutional scheme?
मैं exactly उसी पे आने लगा। मैं ये कह रहा हूँ कि वो अगर मैं अपने तरीके से चलता तो चीजें दो प्रॉन्ग्स है मेरे आर्ग्यूमेंट के। एक तो ये कि जी आपको समीउल्लाह बलोच के अंदर से रास्ता मिलता है, वो मैंने अर्ज कर दिया। वो सूट अगर होता है उसमें एविडेंस होती है, और कैरेक्टर बैड कैरेक्टर एस्टैब्लिश हो जाएगा। किसी की विम्स और डिस्क्रेशन की बात नहीं है, जुडिशियल डिटरमिनेशन। The second prong is if your lordship either decide to overrule Samiullah Baloch, or as your lordship said, your lordships are writing on a clean slate, what will you do? Now, my lord, the principle there, one principle which I think is directly relevant, is that when the constitution provides a certain manner of doing certain things, and in a similar situation, it does not provide the manner as to how to do something, then the guidance provided in the first situation can be used for the second.
So you're saying guidance of 63 could be taken?
But there is an issue with that, my lord. Now, and there are two cases that I cite. My lord, the first is the famous judges case, Al Jihad Trust versus Federation of Pakistan. PLD 1996, Supreme Court 324, Act 531. Now, in this case, the issue was what is the time period within which judges should be appointed, and the Constitution is silent on it. So what this honorable court did was that they said we will take guidance from the time period given for the appointment of another constitutional office holder, the president, which is Article 41(5), and use that time period for the purpose of appointment of judges also. The same reasoning, my lord, was employed in a full bench case of the Lahore High Court in a judgment authored by Justice Mansoor Ali Shah.
Why are you after me today? Why are you after me today?
मैं तो आप अपने दे रहा हूँ, फिर भी
These things a little later. अच्छा बताएं.
Rabnawaz Nadwana versus Mohammad Akram, PLD 2014, Lahore 591. At 622. Now here again the question was that there was no period given for the appointment of the Advocate General. And your lordship used the same principle, though Al Jihad Trust wasn't cited, but the same principle was used. The 30-day period given in Article 45(1) was used, and a 30-day period was prescribed.
So your argument is that if in the constitution there is a bit of a void and there's no clarity regarding time frames, then whenever there are similar provisions of time frames that could be imported or read with those and to harmonize the scheme of the constitution.
If your lordships were to overrule Samiullah Baloch, or if your lordships were writing on a clean slate, there was no, then this could be done. But there's the problem with that is that the constitution in somewhat similar situations provides multiple guidelines. 63(1)(h). Yeah, that is 5 years, but then there is also provision for 3 years, 2 years. So your lordships will have to see which is the closest.
One has to probably rely on one time frame.
But if, and I'll just sort of conclude.
One question. Fundamental right. The one fundamental right which I think would be involved would be Article 17.
My lord,
if there are two interpretations of Article 17, will that the one favorable to the subject be preferred, or an interpretation which is coming in another part of the Constitution, which is 62 and 63, which I assume has a lower status than the fundamental right chapter, would prevail?
The fundamental rights will be given, but provisions regarding fundamental
If there are
rights.
two in conflict, which will prevail?
The one giving the fundamental right, there is no issue with that.
Article 17 enables elections. And the only disqualification specified, mentioned therein is against Pakistan and all that. So, constitutional framers were very much aware. So, when 62(1)(f) was inserted in the Constitution, another amendment was not brought in to water down Article 17. Great, but 17 was left as is. So, if we have to reconcile the two provisions, rather than going this way, we can simply say a right of this right is paramountcy because of Article 17, and there's no specific mention in the Constitution. And like my Lord said, if there was no Samula Baloch, how would you interpret it? We wanted to hear that.
That's the question. One more question. I mean, now that you've read Samula with that kind of a Rhodes Scholar eye, I just want to know that does it talk about Article 17?
Samula Baloch discusses this in detail.
The strength of 17, and then looking at the Constitution.
Yes. And there was all council had invoked the principle of
the submissions are there, but is there a discussion of 17?
Yes.
So how do they deal with it?
No, well, this is not excessive. They said this is not an excessive period. This last, your lordship may note, this is in the last 4 lines of para 35. Therefore, the permanent incapacity of a candidate for election under Article 62(1)(f) of the Constitution is not an arbitrary, excessive, or unreasonable curtailment of his fundamental right. And
So they take care of that. And do they do a comparison on the thing that we just talked about, that there is a time frame in 63 but not there in 62?
Yes.
What do they say to that?
My lord, they did not accept that. They said that these are separate. These are separate. Your lordship may just note the page numbers.
Yes.
Well, there is extensive discussion on that. If your lordship,
So the discussion comes to an end by saying that these are two separate, distinct provisions, and that's why we cannot overlap.
the discussion starts at para 27,
Right.
at page 438, and it continues till page 442.
And your opinion on it?
Sorry?
Whether they are the same, are they interlinked?
For this purpose, I mean, the Siamese twin argument, are they twins here or are they separated?
Here, I think they are separate. They are separate.
So then this argument of Samula is correct in your view that we cannot import the concept of timelines in 63 into 62.
Yes.
Even though earlier you said that one way of interpreting the Constitution holistically is to pick up a time frame from one, and you refer to two judgments also, and import it to the other. But now, what's your position?
My lord, I am saying that in my view, the balance that Samula Baloch has drawn is correct. If your lordship, sitting at a larger bench, think that balance is not correct and should...
What's your opinion on it?
My preferred view is that Samula Baloch, the balance is right.
Samula Baloch, the fact that can we pick up a timeline from 63 and import it into...
Only if your lordships do away with Samula Baloch.
My lord ने कहा ना कि imagine कि नहीं है
तो फिर
आपकी राय है
फिर अगर कर
हमारी तो सब तरजीह दे रहे हैं
आप दो चीजें कह रहे हैं आप कह रहे हैं कि you agree and we talk about what Mr. Zair Bhandari has to say that 62, 63 are two distinct provisions or are they interchangeable? Number one, for the purposes which are under discussion, and second, whether at all if there's a void, no time frame, and there's uncertainty attached to 62, could we bring in that certainty from 63 and put it in 62? What's your opinion on this?
My lord, my own take, if I was writing the judgment, would have been, I would have done the same thing that your lordship did when in terms of Article 175A, send it back to the Parliament for them to sort this issue out.
Parliament has elected the law now. 5 years.
That law for me goes against what Samula Baloch has held. Suppose Samula law is
Suppose Samula is not there.
My lord.
And the Parliament clarifies through the enactment. Can Parliament do so?
Parliament, for the purposes of Article 62, under Article 62, the Parliament has no power to legislate. It is there in 63(1)(p).
then Parliament can legislate there. 62(1)(f) says subject to law. But it is for laws of disqualifications.
On this ground, I mean, maybe you want to sort of comment on this, that one way of looking at it is that the declaration that's coming from wherever it's coming from a law, some violation of some law. And so therefore, if you want to correct that, and that's an unlimited declaration, which is arising out of law, not out of the Constitution, then the law has put a time frame on that declaration. So why can't that be read into that declaration? So every time we read the declaration of court of law into 62(1)(f), it would be a declaration which is time bound.
But
it's not tampering with the Constitution.
That is not how how clause F is worded. It does not say the declaration is flowing from any law.
It is taken from a court of law.
The court of law, not declaration.
No. I'm saying that whatever that declaration is, be it from the constitutional court or be it from the plenary jurisdiction, that declaration itself is arising out of some violation of a law. Please appreciate my fellow. I'm saying it doesn't matter what court it is, the declaration is arising out of some violation of some law, not the Constitution. Either it's the Election Act, either it's the University Act, it's whatever you call it. So then the law now says that any declaration for the purpose of 62(1)(f), when it's used, because it's arising out of a law, would have a period of 5 years. That's what I'm trying to say. There's a bit of a distinction. Had there been a violation, I understand, had there been a violation of the Constitution itself.
At least empathize with us.
My lord,
the kind of things we have to deal with.
My lord, I have, your lordships have not only my full sympathy but my full admiration. Your lordship, as somebody said, यहाँ पे खड़े होके बात करना बड़ा आसान है, उधर बैठ के सुनना और फिर लिखना बहुत मुश्किल है.
Repercussions सबके लिए होते हैं.
सबके होते हैं. And that is why I'm saying, my lord, this mess was created by somebody else. It should have been sorted out.
On a lighter note, एक चीज on a lighter note, I wonder पाकिस्तान में कोई जज बन पाता अगर ये F वाली क्वालिफिकेशन उन पे भी डाल देते.
ये तो कल किसी
ये आप सुन लेना, मुझे तो डर लगता है. मैं तो गुनाहगार हूँ.
मैं तो इसका गुनाह नहीं करता. किसी बार में
शुक्र पार्लियामान ने हम पे ये नहीं डाल दिया.
किसी को एट्रीब्यूट की हुई थी.
मैंने कहा शुक्र पार्लियामान ने हम पे ये नहीं डाल दिया.
कायदे आज़म भी शायद इस पे न उतरता. पता नहीं कौन उतरता है. देखिए मेरे सब नैब लॉ में अगर आप देखें, वहाँ पे जो कन्विक्शन होती है, पीरियड बताया गया for 10 years the person is disqualified. जी, वो तो कॉन्स्टिट्यूशन में नहीं बताया टाइम, लेकिन एक एक्ट ने बता दिया कि द पर्सन सो कन्विक्टेड इज डिस्क्वालिफाइड. सर उस लेजिस्लेशन की सोर्स और है ना सर, वो 63(1)(p) है, वो उसमें उनको स्पेसिफिक पावर है. फॉर द टाइम बीइंग डिस्क्वालिफाइड. सो वो डिस्क्वालिफिकेशन ऑनेस्ट से होता है ना, डिसऑनेस्ट से होता है, सजा होती है. जी, बट देखिए 62 में तो कोई पावर नहीं है कि पार्लियामेंट लॉ बना सके. देखिए वही बात है, डिसऑनेस्टी की बुनियाद पर लैब से उसको कन्विक्शन होती है 10 साल के लिए डिस्क्वालिफिकेशन. यहाँ पर भी अगर कोई डिसऑनेस्ट हो, यानी ऑनेस्ट ना हो, तब जाके वहां पे 10 साल की डिस्क्वालिफिकेशन है. और इसी तरह एक्ट में पार्लियामेंट एक्ट बना दिया, उन्होंने कहा कि आज के बाद ये 5 साल के लिए डिस्क्वालिफिकेशन होगी, लेकिन सब्जेक्ट टू डिसीजन बाय अ कोर्ट ऑफ लॉ. मैं कह रहा हूँ इसीलिए तो जो जस्टिस याहिया का सवाल था सर, ये उसके लिए भी रेलेवेंट है. नॉट क्वालिफिकेशन और डिस्क्वालिफिकेशन तो कॉन्स्टिट्यूशन ने 2 सेपरेट कॉन्सेप्ट के तौर पे लिया है. डिस्क्वालिफिकेशन पे उन्होंने पार्लियामेंट को लॉ मेकिंग पावर दी है. क्वालिफिकेशंस के बारे में आर्टिकल 62 में 63(1)(p) का कोई इक्विवेलेंट नहीं. आपने मेरी सबमिशन ये है, आसान कर दिया आपने. फैसल ऑर्डर का केस लेते हुए कोई भी आ जाए सुप्रीम कोर्ट के सामने, प्लीज मुझे डिक्लेयर करना, सारे को डिक्लेयर कर. मेरा ख्याल है आप नहीं करेंगे, आप नहीं करेंगे, आप बड़े स्ट्रिक्टेंट टेस्ट लगाएंगे. एंड आई वुड से कि जब फैसल ऑर्डर केस में भी सुप्रीम कोर्ट के बेंच नंबर 1 में था, तो वो अपनी विंग्स और उस पर नहीं किया था, कंसिडर करके किया होगा. आई हैव नो डाउट.
देखिए, वी डोंट डाउट एनीवन सेइंग, बट यही मैंने बात की ना, मेरे साथी यहाँ बैठे हैं, मेरे साथी यहाँ बैठे, हम किसी भी डाउट नहीं करते. हर आदमी अपनी दानिश और अकल और समझ से करता है, कोई किसी का इंटरेस्ट तो नहीं होता है. मगर जब बहुत ज्यादा डिस्कशन आ जाता है ना, वो खतरनाक हो जाता है।
भंडारी साहब आपका केस आ जाता है और वो कहते हैं कि सगेशियस है कि नहीं, तो वी वुड हैव हैड टू से दैट यू सगेशियस।
तो मेरे बारे में तो मेरे साथ आप कह देते कि नहीं है। सर मैं बस एक फाइनल इस पे अर्ज कर दूं।
भंडारी सर का एक सवाल है मेरा, नैब ऑर्डिनेंस के अलावा कोई और कानून ऐसा मुल्क में मौजूद है कि जिस सेक्शन ऑफ लॉ के नीचे कन्विक्शन हो जाए, साथ में उसको ये भी कहे कि फॉर फ्यूचर योर डिक्लेयर एज
ऑफ द कफ मेरे इल्म में नहीं है जी, मुझे नैब लॉ का ही पता है जी, बट आई नीड टू चेक दैट अप फर्दर। मेरे ऑफ द कफ नहीं है,
इवन इलेक्शन लॉज में भी नहीं है।
सर रोपा में था, रोपा में तो बहुत प्रोविजंस थी, वो मैंने खत्म कर दी। अब नहीं, इसमें थी पहले बट वो खत्म कर दी। अब वो सिर्फ उन्होंने कहा जो 62
वो सिर्फ उसको डिसीट कर सकता है, डिनोटिफाई कर सकता है
इलेक्शन कमीशन। जी जी जी,
ट्राइब्यूनल, बट इवन ट्राइब्यूनल
भंडारी सर कोई ऐसी क्वालिफिकेशन उस जज के लिए भी है जो दूसरों को सादिक और अमीन डिक्लेयर करेगा? क्या वो खुद उसके ऊपर पूरा उतरेगा?
Do I have the option of saying that I don't want to
be very careful?
Do I have that option, your ladyship? I would prefer to abstain. मैं फाइनल एक में बस ये अगर आप ये करते हैं कि जी समीउल्लाह इज नो लॉन्गर गुड लॉ, इट हैज टू बी ओवररूल्ड, तो उससे जो प्रिंसिपल, बस उस पर मेरे सबमिशन है कि जी जो उस पर पास्ट एंड पोस्ट ट्रांजैक्शंस हैं दे विल नॉट बी अफेक्टेड। उस पर आप जजमेंट सिर्फ लिख लें। ITO वर्सेस सीमेंट एजेंसी है,
5 साल तो मेरे ख्याल में पिछले इलेक्शन से गुजर चुके कब हुए थे?
मैं तो ये मेरी सबमिशन ये जी जो स्टैट्यूट है 232 इन्होंने जो डाला है वो तो अनकॉन्स्टिट्यूशनल है, बिकॉज इट इज गोइंग अगेंस्ट द इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन।
फिर आप देखिए, एक तो ये होगा, फिर वो दरवाजा ही खुल गया कि कोई अगर फॉर इंस्टेंस समीउल्लाह बलोच भी नहीं ठहरता है और 232 भी नहीं ठहरता है, तो इसका मतलब कि फिर तो कोई डिस्क्वालिफिकेशन नहीं।
फिर आप जो मैंने आपको कहा कि आप कॉन्स्टिट्यूशन की दूसरी प्रोविजंस में से निकालेंगे, मैं तो ये कह रहा हूँ।
आप कह रहे हो उसको समीउल्लाह बलोच को हम सब्स्टिट्यूट कर दें।
आप सबसे अगर आप उसको ओवर रूल करते हैं,
ओके
फिर ये दो जी जी जी, क्योंकि मैं तो किसी एक साइड का प्लीड नहीं कर रहा है। ITO versus cement agencies, PLD 1969, Supreme Court 322 at 331, PLD 69, Supreme Court 322 at 331
जी।
और फिर है जी जो बाद में नूर मोहम्मद वर्सेस मोहम्मद इकबाल खान 1985, CLC 1280 at 1284, but 69 Supreme Court is the one that has been followed. और finally ये जो मैं कह रहा हूँ कि कोई स्टैचूट किसी कॉन्स्टिट्यूशनल प्रोविजन की जो इंटरप्रिटेशन की हुई है सुप्रीम कोर्ट ने, उस इंटरप्रिटेशन को अंडू नहीं कर सकता। इस पे आप जजमेंट नोट फरमा लें सर। अल जहाद ट्रस्ट वर्सेस फेडरेशन ऑफ पाकिस्तान, PLD 1987, Supreme Court 84 at 146 and 193.
Sorry, at
146 and 193. My lord, गुलाम मोहिउद्दीन वर्सेस फेडरेशन ऑफ पाकिस्तान, ये इसकी साइटेशन एक तरफ है PLD 97, सुप्रीम कोर्ट 84, अल जहाद ट्रस्ट वर्सेस फेडरेशन। दूसरा है जी गुलाम मोहिउद्दीन वर्सेस फेडरेशन ऑफ पाकिस्तान, PLD 2023, सुप्रीम कोर्ट 825। The relevant is at page 897, para 23, by Justice Munib Akhtar. Well, then actually there is a very good formulation by the High Court in EU Plastic Industry versus Federation of Pakistan, 2019, PTD 1542 at 1550. Which was then followed, my lord, that judgment has been followed by a division bench of the same High Court in 2021, PTD 542.
So the proposition is that the statute cannot undo a constitutional amendment, which is a constitutional provision, which is interpreted by
yes, Samiullah Baloch has held that this is what 62(1)(f) means. That then becomes, as held in Al Jihad, that becomes part of the constitution. That
cannot be undone by.
In the absence of Samyullah, what's the position?
Once you do away with some,
Then you can do anything.
no, but then you have to see whether Parliament has otherwise the competence
that's right.
in terms of Section 62, Article 62. And I'm saying that it's not equivalent.
Yeah, I understood your point.
So law here. Then your lordship will have to fill in that gap, which your lordships can do by relying on 63. That's my threefold submission. My lord, I'm sorry if I haven't come up to your lordships.
No, actually, this last bit was very helpful. You don't mind my saying I'm a very candid person. I will praise when it's required and not praise when it's not required.
Maybe I was-
But this last proposition was very good. And now, since we don't want anybody's right to be, there must be people here who are candidates for the forthcoming elections. And since they must not violate Islamic injunctions, and I'm sure everyone want to read their Asr prayers, so we will take a short break. Otherwise, someone may file declaration.
Your lordship is
You go to give us a
my lord,
synopsis.
your lordship will give me a day. I'll
अगर आपके पास रफ नोट्स भी हैं तो वो आपकी मर्जी है लिखते
थोड़ा सा मैंने लिखे मैं थोड़ा सा इनको पढ़
वो होगा ये आपने हमारे व्यूज भी देखे होंगे तो आपके लिए बेहतर होगा
जी
हम इनको ईमेल देते हैं
ये तो मिल जाएगा, वेबसाइट से ले लेंगे आप।
मैं कर लूंगा
ईमेल कर दीजिए
लॉर्डशिप अलाउज में कोर्ट एसोसिएट को अगर मैं
या ईमेल भी कर
ईमेल भी मैं कर
जो आपके आसान हो
ठीक है मैं आई हैव योर लॉर्डशिप परमिशन टू
तो थोड़े से ब्रेक करके हम आते हैं
इजाजत है जी मैं
Thank you once again. Thank you very much for very short notice that we gave you. And please don't mind the top of the question doesn't even disagree with you. We want to clarify our own thinking.
बिल्कुल ठीक है सर आई एम वेरी ग्रेटफुल
Thank you very much.
Thank you.
as possible.
Sir, I will cut down my submissions by about 50%. And what I would try to do is that I'll submit a note in which I'll cover most of that. I'll basically cover what I think are issues which are bothering your lordship. And even in that, my lord, my entire focus would be about the issue of time period in Article 62(1)(f). That is what I'm going to concentrate on, and that is what actually Samiullah Baloch is all about. Too much discussion has taken place about what is a court of law. I will not make submission. I will limit myself to what is the core issue, which is one of time period, and that is really is what Samiullah Baloch is all about. My lord, let me start by first reading this new amendment, because it's very important to understand the intention of Parliament which has enacted this new amendment in section 232(2). If your lordships, I think it is in the आपके पास है सर? हमारे पास अलग से भी है सर। वो जो नोटिफिकेशन है ना, उसमें उसकी ओपनिंग है, वो पढ़नी, वो आपकी किताबों में नहीं होगी। अगर आप वो प्लीज, जो सीएमए है मखदूम साहब की, सीएमए 6 है मेरे ख्याल में of 2023, वो एक नजर निकालने अगर प्लीज। We have in this book the amendment also. But the amendment does not contain the opening passage through which the amendment is made, sir, which is critically important.
पढ़े
Sir.
इसके अलावा भी
सीएमए फाइल की
नहीं, ये जो नोटिफिकेशन आप कह रहे हैं ना जी, नोटिफिकेशन ठीक है, ठीक page 149 sir, booklet. I thought only the amendment was there. Sir, if I may read section 1 subsection 2. Now it's important that this entire notification says it shall come into force at once. Now, there is a reason I read this, is because this would not apply to section 4 of this notification. If you, my lordship, may kindly see section 4. Sir, आपको मिल गई सर? Yes, जी 149
मखदूम साहब की कौन सी पेज पे?
सर मेरा CMA है सर 6. Sir, it's the last
page,
last annexure.
रीडिंग नोटिफिकेशन हाँ वही है
जी
इस किताब में भी है
जी I did know that. I'm sorry.
ठीक
सर सेक्शन 4 अगर मैं पढ़ दूं
ये इस किताब में भी है पेज 149।
सर if I may read कुछ और है 151 पे जी section 4 सर
पढ़े।
Substitution of section 232 Act of so and so of 2017. In the said act, for section 232, the following shall be substituted. Now this is critical. And shall, notwithstanding anything contained in subsection 3 of section 1 of the said act. Now subsection 3 of section 1 of the said act, which is the election act, it says that the election act will come into force. We're not with you, just a second, sir. हमें नहीं मिल रहा वो. Sir, अगर फिर अब आप CMA देख लें, please, sir.
Page 40 of the CMA.
152 151 पे. एक सेकंड 152.
चलिए ठीक है, पढ़िए
जी
सबसेक्शन 4 पढ़िए सेक्शन 4
in the said act.
Said act is Elections Act.
And if your lordship looks at subsection 3 of section 4, it says that the election act will come into force at once. But it says, shall, notwithstanding anything contained in subsection 3 of section 1 of the said act, always be deemed to have been so substituted on or from the commencement of the constitutional 18th Amendment Act of 2010. Namely, I stop here. Very critical that Parliament, while enacting this law, has put in this deeming clause and made this amendment retrospective from the date of the 18th Amendment. Now, the 18th Amendment is where those phrase, court of law, declaration, court of law comes in. So it is made applicable from that day. Now, I'll move forward.
Now, what is the amendment itself? The text of the amendment is very important. Qualification and disqualification. The qualifications and disqualification of a person to be elected, chosen or to remain as a member of the Majlis-e-Shura Parliament or a provincial assembly shall be such as provided for in Articles 62 and 63 of the Constitution, provided that the procedure, manner, and duration of the qualifications and disqualifications under this section shall be such as specifically provided for in the relevant provisions of Article 62 and 63 of the Constitution, and where no such procedure, manner, or duration has been provided for therein, the provisions of this Act shall apply. Critical. There are three things for which Parliament is legislature on, and this is critically linked with the question of court of law. Procedure, manner, and duration. Samiullah Baloch only covers duration, but let us move forward and come to subsection 2. Am I with your lordship? Subsection 2. Now, again a notwithstanding clause. Your lordship said the amendment began with a notwithstanding clause and a deeming clause. Again a notwithstanding clause. Notwithstanding anything contained in any other provision of this Act or any other law for the time being in force, and judgment, order, or decree of any court, including the Supreme Court and a High Court, the disqualification of a person to be elected, chosen, or to remain as a member of the Majlis-e-Shura Parliament or a provincial assembly under paragraph F of clause 1 of Article 62 of the Constitution. I'll stop here. Only mentions a specific article, not the entire Article 62. Doesn't mention D and E, it only mentions F of the Constitution shall be for a period. Now it's not 5 years, it says not exceeding 5 years. So a kind of discretion is left.
Up to 5 years.
Up to not exceeding 5 years from the declaration by a court of law in this regard. Very different even from 63 time periods. Very different from, of course, Samiullah Baloch.
Mr. Faisal, for myself, this act came into force in 2017.
Yes.
What is the purpose of enacting from 2010?
Then मैं उसी पे आ रहा हूँ. मैं बस 2 लाइनें पढ़ दूँ and then I'll come to that. So a discretion is left from the declaration by the court of law in that regard. अब ये भी बड़ी important lines हैं जिस पे मैं dwell नहीं करूंगा, but important lines. And such declaration shall be subject to the due process of law. This is critically important to understanding what a court of law will mean. There is a specific provision with reference to 10A, due process have been incorporated. Now, a bare reading, and this is to your lordship's question, a bare reading of this act shows that the purpose of bringing this act is to override Samiullah Baloch. There can be no other purpose, but this otherwise, this deeming clause, this notwithstanding clause, this reference to the Supreme Court judgment, this only reference to Article 62 1F and not to the entire ambit of 62 and 1F would not be there. So, the intention of Parliament, as well as there is no escaping the fact that Parliament was of the view that Samiullah Baloch has to be overruled, and this is how we overruled. And what Parliament had in mind, because it doesn't, here really Parliament doesn't specify the court of law, procedure, other. It focuses on duration. It's left the other 2 elements for the future to be specified, unless they are specified in 63. But when it comes to time period, it specifies the time period. So, my lord, the primary submission which I will make before your lordship is that in terms of the intention of Parliament as well as in terms of the text of this law, the text of the law along with Samiullah Baloch, only one will survive. So 232 would be correct law if Samiullah Baloch is overruled by your lordship. But if Samiullah Baloch is there, then this section, to the extent of the time frame, not the entire law, but to the extent of the time frame, would be in violation of the Samiullah Baloch judgment. This would be my primary submission before your lordship. And the reason I would be submitting before your lordship that your lordship must overrule Samiullah Baloch is because I think it poses numerous problems as far as constitutional interpretation is concerned, as well as the democratic.
But if this law overrules Samiullah Baloch, then why do we have to overrule Samiullah
My lord,
Baloch?
a statutory law cannot overrule a constitutional interpretation of a judgment, as my learned friends have repeatedly submitted before your lordship.
Can you repeat it? Statutory?
Statutory law. A statutory law, my lord, cannot override a judgment of the Supreme Court which explains, interprets a provision of the Constitution. These notwithstanding clauses, my lord, as it has been well understood, can only override judgments which are based not on constitutional law, but on non-constitutional law, sub-constitutional law, if they get rid of the basis of that judgment. So, as I was submitting, my lord, it's important.
Section 4 of the notification. But this effect of from 18 amendment that has not been actually incorporated in the section 232 of the.
It is, but it is the amendment has been brought through this notification, so the amendment would be read with the opening thing.
Section 232, it's itself under the statute that has been amended. If you will read that, it is not giving effect from the amendment.
So these amendments never incorporate
the scheme and policy of the law, but what is the actually amended law is there, which is in the statute book.
No. My lord, this is a very common practice that when an amendment is brought in, its effect is never incorporated in the provision itself. It's always in the opening portions of the law. There are numerous examples of that.
Okay, if you will read 232, they are not giving this effect from 18th amendment. That is why the retrospective effect does not mean.
My lord, they have. If your lordship may kindly read it again, it says.
Section 232 only.
No. But 232 has been brought in through section 4, my lord.
Section 4, so why the legislature has not mentioned the effect from 18th amendment?
Because it is never mentioned. Sir, ये कभी नहीं होता. आप कोई भी amending law देखेंगे, amending law की opening provisions mention करती हैं, वो कब से आएंगे? कुछ amendments होती हैं जो incorporate करती हैं. लेकिन सर, if we leave that debate, जो subsection 2 है, it makes it बाद वो laws में सारे जी subsection 2 है, it makes it obvious. What ठीक है सर? Now, as I said, why is Samiullah Baloch a problem in terms of constitutional interpretation, as well as really, I would say, very problematic in terms of democratic growth in this country, my lord? It's important.
Mr. Faisal, we've read this 232 clearly with you for the first time in detail. Now the question is, could a sub-constitutional amendment like this control the scope of the constitutional amendment? Had it been that the period of that declaration is 5 years, that's a separate thing. I was under the impression that declaration is for a period of 5 years. Here it is that disqualification of the person under 62(1)(f) is for 5 years.
Yes.
Now that is regulating or controlling a constitutional provision.
Yes.
They could have said that the declaration under the, which is being adopted under 62(1)(f) such a declaration which is passed under the law could be for 5 years, that's a different thing.
Yes.
But they seem to have gone over that.
Yes.
So that's directly inconsistent with the constitution. So how can the sub-constitutional legislation start controlling?
It cannot. So I would, one of the things which has not happened, एक तो ये नहीं पढ़ी गई थी इसलिए मैं पढ़ना, sir, there is no doubt one of these two things will stand. The legislature has no doubt about that in order for this time limit to be imposed, Samiullah Baloch is an obstacle. Now, it's important, sir, कि Samiullah Baloch को कि कुछ passages पढ़े जाएं. It's very important because I think that is also quite a misunderstood judgment. Sir, if your lordship may kindly look at PLT 2018 Supreme Court 405.
आपका कंटेंशन ये कि कॉन्स्टिट्यूशन के प्रोविजन को एक ऑर्डिनरी लेजिस्लेशन जो है वो टाइम फ्रेम दे सकता है. सिर्फ आप aren't you reading into the constitution?
नहीं, मैं ये नहीं कह रहा, मैं ये कह रहा हूँ a constitutional provision which has been interpreted.
Suppose there was no interpretation.
Yes.
There was no
yes.
और ये लॉ आ जाता.
Yes.
तो फिर आप उसके बारे में बताइए.
I think a law not only could have been brought, but it was absolutely necessary to execute that provision. That is what I would be submitting.
Mr. Faisal, as following that question, suppose there is no Samiullah and there is this confusion about the time frame in 62(1)(f). Parliament, through an act of Parliament, cannot start regulating and controlling the meaning of the constitutional provisions. They could have only done it through a constitutional amendment.
No, my lord.
The only margin, speaking for myself, could have been, because in 62(1)(f) I see that the declaration is coming from some other source. That declaration could have been time bound through a law, but not the actual disqualification under 62(1).
So, let us leave that debate about that distinction. What I would be submitting after I did Samiullah Baloch, what I would be submitting before your lordship is that this is a case, और ये Justice Mandu Khail ने बार-बार ये बात कही थी. This is a case of the doctrine of constitutional absences, of what is called the doctrine of constitutional abeyances. This is a well-recognized doctrine, which is that when a constitution leaves things without determination, how is the court to interpret that?
To make the provision executable. जी, Article 62 में जो 232 आप कहते हैं कि to make that provision executable.
क्योंकि कॉन्स्टिट्यूशन ने जानबूझ के सर टाइम फ्रेम नहीं रखा है. Now what Samiullah Baloch has done is that it had seen this as an invitation to fill the gap and put in a permanent disqualification. No, constitutional absences are not to be fulfilled in that term. Because constitutional absences then follow up with another well-recognized doctrine of constitutional law, which is constitutional implications. That provisions are interpreted in terms of its implications. And one of the fundamental principles of constitutional implication, the doctrine of constitutional implication, is that gaps have to be filled by looking at other provisions of the Constitution.
So, but ठीक हो गया, फिर legislation को छोड़ दें, we simply looking at interpretation of the Constitution.
Samiullah Baloch. What does Samiullah Baloch do? Sir, it's important, if your lordship may kindly see page 412.
So वो जो argument है कि causes omissus है and Parliament fills the causes omissus, is basically saying we should fill it.
That is what Samiullah Baloch does, that it fills it.
Can't do it.
And it fills it in a way which is a violation, I think, of the doctrine of constitutional absence. जब आप फिल करते हैं गैप, आपको पहले सोचना चाहिए कि ये पार्लियामेंट ने क्यों एब्सेंस छोड़ी है. Samiullah Baloch fills in the gap in a way that there is nothing left for Parliament to do. That is the problem which Samiullah Baloch does. लेकिन मैं पहले Samiullah Baloch यहाँ पर we need to know what the Constitution teaches. If your lordship may kindly see 412. जी.
अगर मैं 401(11) से ही पढ़ दूं लास्ट लाइन से, the crucial question raised is whether the incapacity imposed, if your lordship have it, imposed by Article 62(1)(f) of the Constitution upon a person interested to contest an election to a seat in the National Assembly or Senate is of perpetual effect if there is a declaration against him by a court of law to the effect that he lacks sanctity or righteousness or is profligate or is dishonest or is not a mean. The question is posed because Article 62(1)(f) of the Constitution does not stipulate the duration of incapacitation of a judgment debtor upon a judicial declaration. I'll stop here. This is an exact definition of what is called constitutional absences or constitutional abeyance.
Where do you draw this doctrine from?
Sir, मैं अभी साइड करता हूँ. It's a well recognized, इसका जो सबसे famous किताब है is by Michael Foley, The Doctrine of Constitution, but it's been applied by courts. If your lordship may kindly see page 436. Or 36, जी sir. Above para 24, I read from the top 6th line. In the present context, the conditions and qualifications in Article 62(1)(f) of the Constitution were retained in toto and made objectively and transparently enforceable by the prescription of a judicial declaration for precipitating the loss of the electoral qualifications specified in the said clause, where a declaration made by a court against a candidate for election warrants the conclusion of his misrepresentation, dishonesty, breach of trust, fraud, cheating, lack of fiduciary duty, conflict of interest, deception, dishonest misappropriation, etc. to be derived from such a verdict. अब ये reasoning है कि क्यों fill in the gap हो रहा है. Then it stands to reason that the consequential incapacity imposed upon the candidate should last for as long as the declaration is in force. This result follows, अब ये भी बड़ी reason है. This follows as a rational consequence of the judicial declaration and from the lack of any time period of incapacity of the candidate being laid down in Article 62(1)(f) of the Constitution. In other words, if the declaration has attained finality, the embargo under Article 62(1)(f) of the Constitution acquires permanent effect. So, what is the reasoning behind the judgment? There are 3 or 4 very important aspects to this reasoning. First is, it is recognized that Constitution silent. There is a constitutional silence, constitutional abeyance. Now, how does the bench fulfill that? It applies what is called the theory of constitutional implication. What is the rational consequence of this silence? Now, the court was of the view that the only rational consequence, और जब मैं second opinion पढ़ूंगा अजमत सईद साहब का तो ये बहुत ही obvious हो जाता है, that the only rational consequence which follows from the consequence is, and they use 2 different terms which are self-contradictory. First, they say that this time period will last till the judicial declaration is in field. The second word they use is permanent. Now, these are self-contradictory because not necessarily that the judicial declaration will be for life. But when you use the word permanent, then you are saying it is for life. The word life disqualification is actually not used. These self-contradictory terms are used. But let me strengthen. Ab sir zehn mein rakhiye. They have accepted that the Constitution is silent. They have drawn a rational consequence of that silence. What does that mean? That means if you turn to the next page, 437, second line.
437. Therefore, the consequence of permanent nature, i.e. incapacity, following a final and binding decree of court of civil jurisdiction. Now, very important, these words used, is the ordinary and lawful outcome of civil litigation. The learned bench was of the view that the only consequence which would follow as an ordinary or natural consequence is one of permanent disqualification. That is where the mistake is made, and I'll show. But let me just complete the reading of this judgment, because there is another contradiction in the judgment. If your lordship may kindly see page 442 of the judgment. सर अगर पैरा 32 आपके पास है, उसमें कोई 10-12 लाइनें छोड़ के वर्ड शुरू होते हैं कंसिडरिंग. इफ योर लॉर्डशिप में सी, इट्स अबाउट. Now, your lordship has seen it is based that there is no intention. That is why we are drawing a consequence. Now, what does the judgment say? Considering that the Constitution does not fix the period of incapacitation of such judgment, of such a judgment debtor, shows a clear intention. Your lordship may mark this, that the lack of disqualification under Article 62, 1F should extend so long as the declaration of law envisaged in Article 1F remains in the field. If such declaration is final and binding, then the incapacity to contest election to any of the legislatures provided by the Constitution become permanent. Now, they've taken another leap. They accept that there is absence of intention. They say we will draw a consequence, then self-contradict themselves by saying there is a clear intention that the disqualification is permanent. Now, if your lordship may kindly see para 36, which is at page 444. In the result, we are inclined to hold से पहले भी ये 4 लाइनें पढ़ी. Judicial mechanism. जी. इसी पैरा 35 में. जी जी. The judicial mechanism in Article 62 1F of the Constitution grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate themselves. Therefore, the permanent, now again the word permanent, incapacity of a candidate for election under Article 1F of the Constitution is not an arbitrary, excessive or unreasonable curtailment of his fundamental right under Article 17(2) of the Constitution. In the result, we are inclined to hold that the incapacity created for failing to meet the qualifications under Article 62 1F of the Constitution imposes a permanent bar, which remains in effect so long as the declaratory judgment supporting the conclusion of one of the delinquent kinds of conduct under Article 62 1F of the Constitution remains in effect. So there are two terms used. It continues till the declaration continues. If Samiullah Baloch had limited itself to that, maybe then there was a reconciliation. But the use of the word permanent creates.
तो क्लियर कर देते हैं ना कि परमानेंट यूज कर देते हैं, लेकिन आगे कहते हैं remain till such time that the effect is.
So, लेकिन permanent bar, but that is why the latter case.
अगर डिक्लेरेशन कोई है परमानेंट तो वो जब हो जाएगा ना, सपोज कि सिविल सूट आपका था, फिर अपील हुई, फिर वो फाइनलिटी अटेंड हो गई, तो if the judgment is attains finality, then तो फिर वो permanent हो गया ना.
लेकिन सर यहाँ पे permanence then gives rise to the misconception in later case law where the word used is life. Whereas Samiullah, because of this contradiction, created this problem. But let me come to Azmat Saeed Saab's note, which is much more definitive on this. If your lordship may kindly see page 446, para 3, side marked P. Now he completely eliminates constitutional absence. P. It is clear and obvious that lack of qualification in terms of qualification in terms of Article 62 1F of the Constitution is the effect of a declaration by a court of law to the contrary, which is the cause. The obvious legal and logical conclusion would be, as long as the cause, the declaration of a court of law holds the field, its effect, the lack of qualification, shall also prevail. Now this is very important. This appears to be the only possible interpretation of Article 62 1F of the Constitution. How can you say that when you say that it is a constitutional silence? That the only possible interpretation of a constitutional silence is what the learned judge is of the view. And he is very I would say, disparaging of people who might take another view. If your lordship may see the last line, when referring to another article, he says, no sane person could seriously urge to the contrary. Sir, I
hope you're not pleading insanity.
Sir, if this judgment stands, then I would be considered as one of those insane persons. Sir, page 447, para 8.
Paragraph 8.
Ji, sir.
Did they consider other avenues and then by virtue of deletion come to this or this?
Sir, he doesn't. He is not even considering absence. He says absence ka matlab hai कि there must be one obvious interpretation. That is not what constitutional absence is.
Any judge who disagrees with this judgment would be insane and therefore not able to contest elections under Article 63.
Sir, एक और बात कहते हैं, अगर आप
any counsel or amicus putting forward canvassing the proposition would also fall in the same category.
Sir, I would gladly
cautioning you, Mr. Siddiqui,
I gladly plead that insanity. एक और warning देते हैं सर, पैरा 10 में जरा देखिएगा. अभी 448 448 सर, आप हमें डरा रहे हैं क्या? सर मैं क्या करूं, जज साहब ने जजमेंट डराने वाली लिखी है. None of the counsels who appeared before us confronted the elephant in the room, i.e. the obvious interpretation. He has no doubts. There is no silence. Of Article 62 1F of the Constitution is that the lack of qualification to a member is the effect of declaration by a court of law, which is the cause and period of qualification would be coextensive with the period to the cause, i.e. declaration. Now, here comes the warning. None of the learned counsels refuted the aforesaid obvious interpretation, but only sidetracked the issue. So, my lord, anyone who doesn't agree is sidetracking the issue. Now, the problem, this is the problem which Samiullah Baloch creates. And that is why I say sustaining this judgment is very problematic in terms of how the Constitution is to be interpreted. Now, when the legislature leaves something to the imagination, there is a constitutional. Sir, you are talking about people who have made over 100 amendments in the Constitution, in the 18th Amendment. There is a reason why these constitutional silences are left. And the reason why constitutional silences are left is because, number one, either it is a very touchy issue. That is why the legislature at a particular time doesn't want to take a certain position. And it wants to leave it indeterminate, because putting in a definitive answer in the Constitution would give it a permanent character. That is why constitutional absences, and I now refer.
No, but what's your answer to this constitutional absence?
एक मिनट में जरा अगर पढ़ दूं एक दो पैराग्राफ, मैं पहले जवाब दे देता हूँ.
जवाब बता दें कि हमें जरा समझ आ रही है. आपके मुताबिक क्या ऑप्शंस थे?
एक मिनट दिखाइए. Sir, to me, when there is a constitutional absence,
then that has to be fulfilled
by always keeping in mind that there is no intention of the legislature, whether it's a lifelong ban or a 5-year ban or a 3-year ban. That's the first premise you make. The second premise you make is because you are engaging in judicial interpretation where there is no definitive answer.
Why don't you use the third interpretation? When there is a constitutional absence or abeyance, the constitution makers intentionally
open the field for legislation.
Yes, yes.
Not for constitutional interpretation.
Yes, and any judicial interpretation which is made,
which can be changed from time to time.
Yes, so exactly. And any judicial interpretation.
But he started off by saying that 232 can't be sustained.
मैं कहा Samiullah Baloch cannot be sustained.
Okay.
232 will be sustained. And just building on what the Honorable Chief Justice has said, that is why the constitutional implication which should be drawn from that absence should be such that it should be changeable in the future through statutory interpretation.
Open through legislation.
Yes.
Without taking the cue from the Chief Justice, I mean, could you just tell us what you were saying earlier? Before this comment was
I was going to explain
how would you think this constitutional absence should have been filled? You took the cue and you went on, but before that.
So the solution
he doesn't want you to agree with me.
To me, another obvious implication of this absence, it is so obvious, is that if there is a court, if there is, let us forget about that there is what kind of court should be, can a declaration. If there is a declaration which should apply to the next election, I mean, how can you say, if there is no intention specified in an absence, that this is not one of the logical consequences? You don't even have to go into the time frame, whether you should borrow 5 years from 63 or 3 years from 63.
Just to little more focus. I'm more a practical person. Undoubtedly, you and Mr. Bhandari are more sort of philosophical. Does the Constitution prescribe the punishment for murder?
No.
No. The only provision is Article 9.
Yes, yes, of course.
No person shall be deprived of life or liberty save in accordance with law.
I did
तो वो उन्होंने specify कर दिया with law, तो Pakistan Penal Code आ गया. But are there other provisions where they leave it open? For instance, and it has been supplemented by subordinate legislation.
So it's such a well-established doctrine. मेरी जो problem है,
अगर ये love accordance with law नहीं होता उधर, ठीक है, तो that means there could not have been legislation. Article 30, only the courts could have said it would be death or life imprisonment. In Article 9, I don't know, I'm just imagining things.
Because I wouldn't go that far, sir, but it clearly indicates that there is...
Because they can certain permanences, the Constitution are the guiding lights, it fixes. Some may be a bright light, some may be a little diya, which you have room around it for the Parliament to step in and legislate.
If your Lordship searches the Constitution for the word permanent, perpetual, perpetuity, life, your Lordship will not find it.
Or change eventuality में फिर constitutional amendment is.
Sir,
Faisal, I have a question. First of all, you'll have to take us through this concept of constitutional absences through a text of any book which says.
I am taking you to a judgment.
नहीं उसके अलावा where is it as a text?
Sir, उसी में वो text mentioned.
Judgment में खुद ही लिख दिया होगा.
नहीं.
Where is they borrowed it from what text? So where is this principle?
A Harvard graduate or a professor saying something.
Or maybe of any other. मैं ऐसे basic चीज पर पूछ रहा हूँ. वो तो आप बता दें हमें. So suppose if there is such a doctrine, the constitutional absence has to be filled through judicial engineering, as you say. So one engineering was done in Samullah, and one straightforward answer was that a declaration will continue until such time that a declaration is set aside. It is a straightforward, quite simple interpretation of filling the absence. You say, no, there could be yet another one, which is that he is disqualified for that election, which I find out in the truth to be slightly more difficult one. The more easy one is the one that the declaration holds for such a time. I mean, if you're filling the absences, the more straightforward filling of the absence would be that the declaration continues. आप उसके ऊपर आपकी जो carving है, मैं उस पे मैं क्यों कह रहा हूँ, मैं उस पे where do we draw the line? मैं उस पे भी आता हूँ. Or is there a third option that please send it to the Parliament, let the Constitution be amended accordingly, and sort that out? Why should we get into the business of filling the absences, and where do we take the concept of causes omissus? जरा डॉक्ट्रिन तो पढ़ जी जी सो वेयर इज दिस डॉक्ट्रिन मैं फिर इन सवालों का जवाब पहला डॉक्ट्रिन जी जी इफ योर लॉर्डशिप में सी दिस इज अ वेरी फेमस जजमेंट ऑफ मनोज नरूला इन विच the petitioners also say so, if you say so. In which the petitioners also wanted the court to read a certain disqualification in a constitutional absence in the constitution, and the court refused. If your lordship may kindly see page 21, bottom पे लिखा हुआ है sir pages. Now, मैं सिर्फ आपको बता देता हूं, इशू ये था कि क्रिमिनलाइजेशन ऑफ पॉलिटिक्स को रोकने के लिए द पिटिशनर्स वांटेड द कोर्ट टू से दैट इवन इफ ए चार्ज हैज बीन फ्रेम्ड in terms of a heinous offense, that person should not be appointed as a minister. Now, this discusses this doctrine of constitutional silence. Bottom of the page. Principle of constitutional silence or abeyance. The next principle that can be thought of is constitutional silence or silence of the constitutional or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced constitutional practice, has been recognized by the court to fill up the gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of the public interest, to establish the rights of the have-nots or to prevent damages and protect environment is one such feature. If your lordship may come to para 50, para 49, there is no reference to this principle. Sir, apart from the aforesaid reasons, उन्होंने judgments भी refer किए. अब मैं text की बात कर रहा हूँ. The arguments by the apparent cannot be accepted in view of the well-known constitution paragraph. Para 49, sir, page 22. Para 49. तो कोर्ट मैं अगर पढ़ दूं वो जजमेंट्स में से कोर्ट किया जो जज ऑफ द वेल नोन कॉन्स्टिट्यूशनल डॉक्ट्रिन, नेमली द कॉन्स्टिट्यूशनल डॉक्ट्रिन ऑफ साइलेंस. Michael Foley, in his thesis on the silence of constitution, it's the most famous book on constitutional silence, has argued that in a constitution, अब ये बड़ा important है सर, in a constitution, abeyances are valuable. Therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the Constitution that they invoke, rather than the content or substance of the strictures. Agar main para 50 this means that the silences have an importance. Yes. And they should be left silent. नहीं, ये नहीं है. So para 50 देखिए. The learned author elaborated this concept further by saying that despite the absence of any documentary or material from these absences are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitution as its more tangible and codified components. The question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, ये बड़ा important लफ्ज है. Can a court read a disqualification to the already expressed disqualifications provided under the Constitution and the 1951 Act? This is their election. The answer has to be
in the inevitable negative. For there are express provisions stating the disqualification and section it would tantamount to crossing the boundaries of judicial review. So, my submission before your lordship, इसको easy नहीं लेना चाहिए कि legislature ने कोई चीज जानबूझ के छोड़ दी है. अब वो gap fill किस तरह करना है, that is where the doctrine of constitutional implication comes in, which is the next paragraph. Doctrine of constitutional implication. The next principle which we intend to discuss is the principle of constitutional implication. And to save time, my lord, I'll jump to the next page, page 23, third paragraph. There is no speck of doubt that the court has applied the doctrine of implication to expand the constitutional context, but the context in which the horizon has to be extracted has to be borne out in mind. What is suggested by Mr. Dwivedi is that by taking recourse to the said principles, the words employed in Article 71(1) are to be interpreted to add a stage in the disqualification, i.e. framing of charges in serious and heinous offences or offences relating to corruption. At this juncture, it is seemingly to state that the principle of implication is fundamentally founded on rational inference of an idea from the words used in the text. The concept of legitimate deduction is always recognized. In Melbourne Corporation versus Commonwealth, Dixon J. opinion that constitutional implication should be based on considerations which are compelling. Mason CJ in political advertising case had ruled that there can be structural implications which are logically or practically necessary for the preservation of the integrity of the structure. Any proposition that it arrive at taking this route of interpretation must find some resting pillar or strength on the basis of certain words in the text or scheme of the text. Now, to have constitutional implication by reading 62 and 63 altogether, would I say, let's assume there is no Samuella case, there is no section 230. Then what is the literal interpretation of 62 and F? How you will disqualify the person? So, in the words in the could you read Mason CJ sir, ये तीन लाइनें बहुत important है. In the absence of that, it may not be permissible for a court to deduce any proposition as that would defeat the legitimacy of the reason. A proposition can be established by reading number of articles cohesively, for that will be in the domain of substantive legitimacy. Now this is the problem with the court. It recognizes there is a constitutional absence. It engages in the doctrine of constitutional implication and then comes to the conclusion that there is only one implication possible without justifying it in terms of a overall reading of various interconnected articles, especially 63, especially 17. I think the reading of both is wrong. Now, अब सर अगर आप 62 1F पे मैं अगर आपको ले चलूं, after I have established the doctrinal basis of my argument, if your lordship में kindly say, ये 62 gap था ना, इसको किस तरह fill करना है? मतलब आपको जाना है सर, मेरा ये कहना है 62 1F के अंदर अगर सैमुएला भी ना हो और अभी ये 232 भी ना हो, तो अगर आम हालात में इसको पढ़ा जाता तो आप कैसे डिस्क्वालीफाई करते हैं उसको? इलेक्शन टू इलेक्शन करते हैं, 1 साल के लिए करते हैं. आगे मैं उसी वक्त एक्सप्लेन करता हूँ. अगर मैं आज
So as you are saying that when there is a constitutional absence, it can only be filled by the legislature.
No, I am saying if the court in the meanwhile fills it,
it must be very conscious of the fact that since it's an absence left by the legislature, any interpretation which gives that absence a permanent character would be a violation of the constitutional absence which is left by the legislature.
Okay, now if there's a constitutional absence and the court fills it in, both the court and the legislature can do so.
Yes.
Correct?
Yes.
Which will prevail? Legislature can't.
Well,
One does this thing, the other does this thing.
can't as far as the
Which will prevail then?
देखिए मैं एग्जाम्पल के थ्रू कोर्ट करूं
जैसे भी आप करें,
इफ द कोर्ट
both does it. आज हमने एक इंटरप्रेट किया कोई चीज और आज ही हमें पता नहीं था, बराबर में पार्लियामेंट में एक लॉ बना दिया, हमें पता ही नहीं है, एक दूसरे को कुछ नहीं पता है, हमने भी वही काम कर दिया, उन्होंने भी वही काम कर दिया.
मैं आपको कॉन्क्रीट एग्जाम्पल देता हूं जिसमें देयर विल बी नो कॉन्ट्रडिक्शन ऑफ प्रिवेलिंग. फॉर एग्जाम्पल, अगर 1F को पढ़ा जाता, 62 1F को पढ़ा जाता, not as implying any kind of permanent disqualification, simply a disqualification which is about that election. It is a disqualification. He is unseated. Then that doesn't stop Parliament from doing anything regarding 1F. So it depends क्या आप implication, but you have to take the silence very seriously. अगर आप लेंगे कि नहीं नहीं ये तो हमें इनवाइट किया है फॉर जुडिशियल इंटेलिजेंस.
I've understood the point, but you have not answered the question.
सर देखिए, अगर समीउल्लाह बलूच ने ये ले अगर the court,
अगर I take any other provision, today we are interpreting something and simultaneously Parliament, we don't know what either of us are doing, we enact a law, either one, they're contradictory. Which one will prevail?
Sir, I'll give you two examples. The Indian Supreme Court laid down detailed guidelines regarding the trafficking of women. But with trafficking of women, जिसके ऊपर कोई लॉ नहीं था, तो उन्होंने लिख दिया अपनी जजमेंट में कि these guidelines will remain till the Parliament passes a law.
Recently लिख दिया, अगर लिखते ना, for instance.
एक क्वेश्चन इस पे था, अगर समीउल्लाह में भी ये लिख दिया जाता कि टिल द टाइम,
वो तो मसला ही हल हो गया फिर.
सर अगर लिख दिया जाता फिर तो कोई कॉन्ट्रडिक्शन ही नहीं होगा. लेकिन मेरा मसला इस जजमेंट से और बुनियादी है. सर यू शुड स्टॉप दिस principle where all absences are filled in by the courts in a way that blocks the legitimate power of Parliament. That cannot be.
So how are you saying that? How do you say that the power of the Parliament has been restricted by this judgment? The Parliament can amend the Constitution and bring about changes in Article 62.
Yes. Ultimately it's not. Sir, constitutional amendment के through तो आप कुछ भी कर सकते हैं. But you have to understand the reason why Parliament did not determine 63 में कर दिया, 62 में क्यों नहीं किया? इसलिए नहीं किया क्योंकि this they knew was a very delicate issue. They wanted to leave it indeterminate so that future parliaments could decide on that through ordinary legislation also.
How so delicate? Why should we get into it if it's so delicate and so sensitive? The entire Parliament, in its collective wisdom, was thinking it's so sensitive. Seven of us decide what it should be.
आगे बढ़े.
Another implication of that would be that your lordships could leave it open. Say that this 1F could only be implemented when Parliament legislates on this, which Parliament has now done in terms of Section 232, that we will prescribe procedure, duration.
क्योंकि हमने शुरू में, अगर आपको याद है, मैंने ये कई दफा पूछा था सवाल कि अगर हम कहें कि उस वक्त तो ये कानून था नहीं, तो वो अपनी जगह सही था समीउल्लाह बलोच. अब क्योंकि कानून आ गया है, अब कानून को फॉलो कर लें, दोनों रिकंसाइल नहीं हो जाएंगे.
So this will set another very dangerous precedent, that your courts will interpret constitutional provisions and pass judgments, and Parliament can then get rid of all those judgments by simple legislation.
Okay,
this should never be allowed. This follows another very dangerous route.
जी got it.
एक डॉक्ट्रिनल प्रिंसिपल क्लियर कर दें.
जी सर.
आप कह रहे हैं कि कॉन्स्टिट्यूशनल साइलेंस का जो प्रिंसिपल है वो ये है कि if there is a constitutional silence we should respect and leave it there or we must fill it.
What's the principle?
principle? The principle is that it is to be fulfilled through the doctrine of constitutional implication. Through interpretation, if it is required, if it's absolutely necessary. And such an implication should be taken
from the whole constitution.
So fair enough. So ये clear हो गया कि ideal would be the constitutional amendment, but the next possible thing the court can do is to come up with a constitutional implication by looking at the constitution holistically, and you say that Samuel Baloch does not look at it holistically.
सर इतना obvious था कि अगर आप holistic view लेते हैं, सिर्फ ये आपने बार-बार, but it's worth looking at.
Again, I will ask the question. आप बताएंगे इसको आम हालात में आप कैसे पढ़ेंगे? Because the word declaration is used there.
Yes, मैं दो तरीके से इसको पढ़ूंगा. पहला तरीका मैंने बताया सर कि I would simply limit that declaration to the election which has happened. The second
about the election,
yes,
the first term, during the period of that particular election,
yes,
qualification will
yes. And
what about the declaration for that?
Sir, declaration would be limited to that. जिस तरह RO reject करता है nominations. So what declaration?
In mutually destructive arguments, and somebody has argued that the RO has no right to declare.
नहीं, मैं सिर्फ ये कह रहा हूँ उसका टाइम पीरियड
वो तो एग्जीक्यूटिव एक्ट है,
लेकिन नहीं हुआ. इसी तरीके से इंडियन सुप्रीम कोर्ट की जो इलेक्शन कमीशन की जजमेंट है, उन्होंने भी यही किया. उसमें यह था until there is a law which establishes how election commission is to be appointed, वो president appoint करेगा. उन्होंने in the meanwhile एक system create कर दिया जिसमें prime minister, leader of the opposition. But they said this is until parliament passes a law. So this is also one of the possible constitutional implications.
You are saying if we incorporate the words, if this judgment Samuel Baloch had simply written 3 more words till Parliament legislates,
yes,
this judgment would be okay.
This judgment, at least in terms of giving permanency to this constitutional absence, would be okay. Only to this. But I disagree with how 62.
You are saying वो आपको अलग मसले हैं उससे.
बहुत मसले क्योंकि सर 17 को
whenever you are saying as for future guidance for us,
sir,
we can then always should add the words, though there is a lacuna in the thing and we think there should be the thing. However, whenever Parliament legislates, that will prevail provided it is not violative of.
Especially, sir, when it affects the foundations of democracy. That is very important. That is why this judgment should be set aside. Sir, in this country, democracy has been sabotaged through judicial murders, then through all other judicial acts.
अब Article 17 की आप भी बात नहीं कर रहे हैं.
Sir, Article 17 तो critical था. पहले 62, 63, अगर मैं 62, 63 की एक प्रोविजन की आप बताएं. सर, देखिएगा 62, 1G देखिएगा सर. जरा लैंग्वेज देखिएगा सर सिर्फ. 1G. He has not, after the establishment of Pakistan, worked against the integrity of the constitution or opposed it. Sir, 62, 1G.
The integrity of the country.
Of the constitution. Sorry, sir. He has not, although that should be used interchangeably, my lord. He has not, after the establishment of Pakistan, worked against the integrity of the country as opposed the ideology of Pakistan. Zara 63G देखिएगा. He has been convicted by a court of competent jurisdiction for propagating any opinion or acting in any manner prejudicial to the ideology of Pakistan or the sovereignty, integrity or security of Pakistan or integrity or independence of the judiciary, or which defames or brings to ridicule the judiciary of the armed forces unless a period of 5 years has lapsed in this read. How can you not read these two provisions holistically? Sir,
एक सवाल आपसे पूछूं, it may be facetious, I don't know. What is the ideology of integrity? तो समझ आ जाता है. Ideology of Pakistan से आपका क्या मतलब है?
Does it go into wrong?
Is it specified anywhere?
No, it's not.
That's all.
Sir, एक और आप जरा dangerous implication देखें जो interpretation adopt हुई है Samuel Baloch. It only focuses on F. But what about D and E? D और E में तो आप किसी को लाइफ डिस्क्वालीफाई कर देंगे और आपको डेक्लेरेशन बाय कोर्ट ऑफ लॉ की भी जरूरत नहीं है। जरा देखिए आप डी और ई, उसमें तो कोई सेफ गार्ड ही नहीं है। जी में आप किसी को लाइफ, अगर आपने यहाँ टाइम पीरियड को एज ए कॉन्स्टिट्यूशनल एब्सेंस नहीं पढ़ा तो एफ में तो एटलीस्ट उन्होंने,
ये तो डी ई और एफ जी जो है ये तो इन्फोर्सेबल ही नहीं है। Who will determine that?
सर मैं कह रहा हूँ, लेकिन अगर
इसमें आया ना डिक्लेरेशन में,
लेकिन बात ये सर, अगर आप इसमें टाइम पीरियड्स यूं कह दें कि ये तो डिस्क्वालिफिकेशंस आर फॉर,
आप ये कहना चाह रहे हैं ना कि जब समीउल्लाह वाला केस आर्ग्यू हो रहा था तो the court had an option to fill this silence.
Yes.
And they decided
if it was absolutely,
it was because people are contesting elections and they've been thrown out forever.
Yes.
What is to be done if there's a declaration to this effect? Are they going to miss that elections or all the future elections? So this was a case that had to be decided because elections are critical to democracy and we need to understand the right to contest under Article 17. तो फिर उन्होंने सोचा कि इसको लाइफ कर दें और वो अगर देखते और सारी आपका आर्ग्यूमेंट है कि होलिस्टिकली they looked at the constitution, they would have put some other meaning to it, and one easy meaning that you say comes to mind is that if the person gets disqualified for that particular elections and he gets on with life later on.
And there are two important principles which I have based it on. The first principle is that, sir, this court has to stop this intervention in terms of reading it. Reading is absolutely essential tool of interpretation, but should only be done when it's absolutely necessary, and it should only be done to the extent where you don't give a permanent character to your reading. It's very important. The second is that one should be very careful when it comes to political parties, the foundations of democracy, leadership of political parties. Such interpretations should be avoided, which in any sense would be seen to derail democracy. That is why this notion of permanency, कि लोगों को, political parties को permanently eliminate कर दो, through judicial murders, through lifetime qualification, through criminal conviction, such interpretations should always be avoided by the court. And a minimalist intervention in terms of filling in constitution, मतलब भी पता भी क्या लिख रहे थे,
उनको पता था सजेशियस का मतलब क्या होता है?
मैंने असल में
सजेशियस इज अ वेरी ऊंचा टर्म है, उनको पता भी इसका मतलब क्या है। I mean, I don't know how, on what platform will this be tested. Are you sagacious? I would profess not to be sagacious unless I'm totally arrogant. I would say the two are contradictory.
Sir, I actually asked Raza Rabbani sir, who was the architect of the 18th Amendment, why did you substitute 62(1)(f) and not restore the original provision? And he gave a very important answer. His answer was that, first we were dealing with over 100 amendments. And people, of course, from the religious parties as well as people who are center-right or right were not willing to support other amendments if this amendment was made and the original article was restored. So it was a compromise which was made. And a part of that compromise was that this absence was left. And the court should recognize this absence. You say it was intentional. Intentional. Samiullah says, नहीं, उसका मतलब यह है कि ये इंटेंशन है, और अगर कोई शख्स कोई और इंटरप्रिटेशन लेगा तो वो सेम नहीं है। My lord, that is not a humble way of interpreting.
यहाँ पर कहने के मकसद ये कि एक मर्तबा 73 कॉन्स्टिट्यूशन बना, उसमें परमानेंट डिस्क्वालिफिकेशन, सर उसमें तो सिर्फ 3 थी, उसके बाद 85 अमेंडमेंट आई, उसमें परमानेंट नहीं थी, फिर 18th अमेंडमेंट आई, फिर परमानेंट नहीं किया।
नहीं, 18th में भी परमानेंट, ये तो कॉन्सेप्ट था ही नहीं।
Just being a devil here, in the sense that if you were to look at 63 के जो punishments हैं, so somebody who commits a murder goes through a punishment, a period where there's redemption and then he comes out and then 5 years. So there's a process that he goes through imprisonment of such a period of time, and then he maybe stands restored, reformed, and then there's 5 years. अब इधर जो declaration है, suppose the declaration is to the effect that he's a fraudster. Now, what happens? I mean, he's been declared a fraudster. There is no mechanism for his reformation. He's not been sent to any prison. He's not been sent to any facility. So he is a fraudster, and we say, come on, you can't go into the house because you're a fraudster. The other provisions have a mechanism of cleaning him up. You see, they send him to prison, he goes through a process and comes out clean. In this case, he doesn't. He just is declared a fraudster and left to his own whatever, best whatever. So the question is, do you think there's a difference? Can we really import 63 into this? Or can we just say, are we actually saying when we say for this election, let him go? So we've declared him to be a fraudster, but then we said, okay, well, you are a fraudster just for this election, and without any process of his reforming himself, allow him to contest the election again. We certainly don't want fraudsters to come into the parliament ever again, unless they stand reform. So there is no process of reformation. That's why probably it's silent, because there is no process of cleaning him up or sending him through any sort of a reformative process which is available in 63. We're basically then saying that you're a fraudster, there is no process, go home, stay a fraudster, but contest the next election. How do we deal with that? My lord, that is one of the... I just want to...
I had a question which now ties... Can you go to Samila Baloch, page 446, and what Justice Yahya had also drawn attention to? It is clear and obvious that the lack of qualification in terms of Article 60 declaration, etc. वो जो mechanism की जो बात कर रहे थे, sorry, वो कौन सी mechanism की नहीं, sorry, that is सर वो उससे पहले 35 judicial mechanism, ये किधर है judicial mechanism? Grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate himself. Where is this judicial mechanism?
I'll first answer that and I'll come in back. Sir, your lordship has made two, with due respect, erroneous presumptions. And this is the argument which is given in Samir Lavalot, which your lordship has expressed. The first is, sir, America has the biggest prison population. It is about 22 lakh people. 60 to 70% of the people who go to jail commit a crime within 2 years of coming out. There is no reformation. I don't know, you might have friends there. So these are the statistics. Number two, sir, to denying an election to a politician, you think that is not, even though he is a fraudster? No. He has acted against the integrity of Pakistan, security of Pakistan. He's gone through a punishment of 10 years. But he's allowed. After having served the term. Yes. Well, all I'm saying is, I'm trying to find a solution. There is a declaration of the civil court saying you're a fraud. Not yourself, but the person who's contesting is a fraud. Now, he doesn't go through any mechanism of purging himself, and then we say, okay, we think you should just not contest this election, but you are still a fraud, contest the next one. The reason why there is no conviction is because of different standards of proof in civil law and criminal law. You can be convicted, you could have taken for this declaration in 62(1)(f), the election commission could have filed a complaint and could have taken him through the criminal process. They did not. Yes. So in one case, had they taken him, then 63H, 1H lag jata. Yes. Lekin nahi hua. So the only gap here is, what is the repentance, what's the purging of this person who has been declared to be a fraudulent person? How do we clean him up? Do jawab. And then I'll connect the second question to his lordship's question. Sir, I think denying a politician the right to political activity is the greatest punishment to him. Politics is in their blood. Number two, and which is critically important, the people of Pakistan should judge whether they want to elect a fraudster. It is not for the court to decide. The people of Pakistan.
आपको अपना जवाब देता हूँ.
ये बहुत बड़ी गलती हम करते हैं.
नहीं, मगर ये आप इस पे तो आ जाए जजमेंट में मैंने जुडिशियल मैकेनिज्म to vindicate himself, ये कौन सा vindication mechanism है? ये जरा बताए ना, ये जो पैराग्राफ 35 में जिक्र है.
Samiullah Baloch,
ये जो लफ्ज इस्तेमाल हुआ है.
Samiullah Baloch doesn't deal with this.
He mentioned this.
Yes. It presumes that a judicial mechanism is there? Because this is a judgment.
What it means actually is that declaration through a court of law, you have a remedy to go get it fixed. You can get the declaration set aside by a higher court.
Yes.
But if the final court of the land declares that and upholds that declaration, story is over. So I think the vindication comes through the process of setting aside that declaration through a court of law.
Yes.
So वो vindication का तरीका।
तो मैं आपको वैसे आपको इसका जो मेरे जहन में जो आ रही है बात, इसका सोल्यूशन इस्लाम में पाया जाता है। अब उधर भी कोई नहीं जाता है पाकिस्तान में अनफॉर्चुनेटली। होली कुरान में क्या लिखा है? What are human beings? Human beings is the only creation in which the Almighty has bathed his something of his spirit. That's the Holy Quran, Surah Sajda, verse 32, verses 6 and 7. So no person is per se bad. A person's acts are bad. Try to understand this and it will resolve the issue. No person is per se bad, his actions are bad. I may be a drunkard, I may be whatever womanizer today. Those are my acts. Tomorrow I stop doing those things. So that is the answer. So what the Almighty has prescribed, the status of a human being is very high. It's the only part of creation in which the Almighty has breathed His Spirit for those of us who are Muslims. So we have been placed at a very high pedestal. Our acts are bad, not ourselves are inherently bad. If you debar someone for life, you condemn that person for life. There is no redemption. There is no tawbah. Samila Baloch also touches upon in paragraph 6, tawbah, but doesn't attend to it at all. What happens? So tawbah is not something you come and profess and say, ji main to bada acha ho gaya hu. You may be lying through your teeth. Even it is something from within. So your act can be punished for a particular period, like the other acts are being punished, or any other punishment that is imposed. For theft there is punishment, for whatever, every crime has certain limitations or punishments. It's not forever condemnation. And the minute the person itself cannot be condemned, no person can be condemned. So that door of mercy will remain open. Up there and here, if you say, oh, you're a crook, now you're a crook for life. He stops being a crook. He becomes a very nice person, very honest person, starts helping people. Don't condemn him, condemn his acts. So why can't we draw this distinction between condemning a person's acts as opposed to condemning a person? 62(1)(f), Samila Baloch condemns not the act, condemns the person in perpetuity. Does it accord with Islamic injunctions?
It doesn't, and it doesn't accord with Article 62, 63. All punishments which are given in 63 are time-bound. How can a timeless punishment be added to 60? सिर्फ मुझे याद आता है आपने जो बात की, it's from a different source. Russian writer Dostoevsky वो कहता था कि you cannot be saved if you have not sinned, and you cannot be reborn if you have not been saved.
तो repentance तो कहीं evidence for repentance.
It is 63 आप पढ़े.
How do we know this person is repentant?
That's it.
In answer to my Lord's question, you just fix a time limit. Whether he repents or not,
repentance पे नहीं है. जैसे
Your Islam का concept है तौबा का, so where is the evidence of this guy?
The point is that the issue is proportionate punishment, and that is the concept which is in 63.
If that period alone, आप कुछ और कहना चाहते हैं? आपने बड़ा interesting points दिए.
I did want to repeat what others had argued.
And we really appreciate, at least I've learned a lot about this. I wasn't aware of this. The constitutional abeyance, the doctrine of constitutional abeyance and absences, I must confess. So it's been educational. Any other things you want to bring to on?
This is a very important, my last one. This is a very important check.
Get another one.
No. This is a very important check on this tendency to read things into the constitution. ये बहुत important check है sir, because at the end of the day, that should only be done if the constitutional framework has become unworkable.
you're telling us to read into it by saying
I'm not.
that election.
अगर ये आपके सामने इशू उठता है और फिर ऐसी रीडिंग करें कि उसको परमानेंस ना दे, मैं सिर्फ ये कह रहा हूँ।
आपके मुताबिक कैसे रीडिंग दें?
सर वो तो मैंने बता दिया, नेक्स्ट इलेक्शन जी,
दिस इज
yes, and that will be. अब मैं आता हूँ, आपने, you know, I was very confused on this issue of court of law, but after listening to your lordship's comments, now, you know, that confusion has disappeared. Let me build on what your lordship talked about in interpreting court of law. सिर्फ एक दफा पढ़ ले उसको
कि आपने नेक्स्ट इलेक्शन का बोला है, अभी डिक्लेरेशन बन रही है उसके लिए।
नहीं, कम प्रेजेंट इलेक्शन
62 एक्ट में डिक्लेरेशन
प्रेजेंट इलेक्शन
तो हो गया, खत्म हो गया ना सर। उसको अगली दफा आएगा जब नॉमिनेशन भरी जाएगी तो वो जो चीज उसके अगेंस्ट होगी तो क्या वो वैनिश हो चुकी होगी? तो दैट वाज ओनली कन्फाइंड
डिक्लेरेशन आ गई है, इस इलेक्शन में तो आपने डिस्क्वालीफाई कर दिया, नेक्स्ट के लिए होगी
नहीं सर। वो होगा ये कि मेरा व्यू ये है, मेरा व्यू ये है कि these declarations have to be made by the election tribunal. उसमें प्रोविजंस मौजूद है टू डी-सीट समवन इफ ही डजंट क्वालिफाई।
करने चले गए वो तो यहाँ तो डिस्क्वालिफिकेशन जो है फॉर्म ही फिल हो रहा तो
मेरे ख्याल में वो नहीं हो सकता। The only court of law now that is why he will be de-seated for that election, my lord, for that time.
बट इसका एग्जैक्ट जो है ना, आप उसका एग्जैक्ट आंसर दीजिए ना। ये इस चीज के ऊपर कि इलेक्शन का जब फॉर्म भरा गया उसी वक्त रिजेक्ट हो गया वो। नाउ यू आर टॉकिंग अबाउट द ट्राइब्यूनल, देन द पर्सन विल गो टू द ट्राइब्यूनल and challenge his candidature. So that would not be the court. That is only at the time of filing nomination form. And if he is found guilty by any court and any adverse declaration is against him, he is out of the election.
No, my lord, this is what pre-election, this declaration cannot, I don't know, 62 कैसे होगा? 62 होगा जिस तरह one of the grounds on which an election can be declared as invalid. 60 qualified to नहीं सर। अगर आप देखिए
directly related to the qualification document.
अगर आप देखिए 68 के इलेक्शन एक्ट से आपसे तो
देख लीजिए ना
सर, एक मिनट 68 देख लीजिए,
पहले 62 देख लीजिए। पर्सन शुड नॉट बी क्वालिफाइड टू बी इलेक्टेड, ये उसकी जो है कीवर्ड्स हैं इसके अंदर। फिर आप अगर एफ के साथ पढ़ेंगे, इफ इट इज टेकन इनटू कंसिडरेशन दैट इट इज ओनली वन टाइम एंड इवन इट इज टू बी लेफ्ट फॉर द ट्राइब्यूनल टू डिसाइड, देन देयर इज नो पर्सन।
नहीं सर, अगर आप 68 देखेंगे तो क्लियर हो जाएगा। Section 68 of the Election Act 2017. It's absolutely clear कि ये कब declaration given है। Grounds for declaring election of return candidates void.
No, return
मैं जरा पढ़ दूं सर, क्लियर हो जाएगा।
रिटर्न की बात नहीं हो रही ना।
Election Act 2017 जी। और इसी किस्म की प्रोविजन रोपा में थी सर।
अगर हम देखिए ये जो अल्फाज इस्तेमाल किए हुए हैं, सीरियसनेस और राइटियस, इसको क्या जुर्म के दौरे में अप्लाई नहीं। मैं उसके अगर ये जराइम होंगे तो फिर आप इसको 63(1)(g) के साथ पढ़े
सर। मैं एक उसके वर्ड्स पे भी आता हूँ, मैं पहले वो सेट कर दूँ, 68 पढ़ दूँ अपना सवाल।
68
The tribunal shall declare the election of the returned candidate to be void if it is satisfied that the returned candidate was not on the nomination day qualified for or disqualified from being elected as a member. This is when the declaration comes in and he is de-seated.
अगला पॉइंट बताइए।
जो बात है, जो जस्टिस मंसूर अली शाह की बहुत इंपॉर्टेंट पॉइंट है सर, आई मस्ट बिल्ड ऑन दैट। What does 62(1)(f) say? What is it doing? और ये है कि इनके वर्ड्स का मीनिंग क्या है। Let us read this. He is sagacious, righteous, non-proliferate, honest, and amin. Let us stop here. Where has this been determined? Who will determine this? What are the meaning of this? There being no declaration to the contrary by a court of law. Now, it doesn't tell us how these terms are to be defined. It simply tells us that there will be a declaration by a court of law. Now, what court tries to do is try to solve these problems. It says कि इसमें जो absences हैं कि भाई ये जुर्म क्या होगा, इसके लिए अगर प्रोसीजर नहीं है, चीजें नहीं है, तो that will be legislated on. It doesn't create a qualification itself unless there is some law which will really determine what this disqualification or qualification, whatever you want to call it, would be. So court of law, वो jurisdiction कहाँ से आएगी? Some law will give its jurisdiction. Either there will be an amendment in the Election Act, like it has happened, which will determine कि court of law क्या होगा, वो court of law क्या standard of proof apply करेगा, इन words को किस तरह interpret करेगा. None of this is given in 62(1)(f). It simply says that these undefined terms will lead to a disqualification or qualification, whatever, by a court of law. Now, how that absences are to be fulfilled is for statutory framework to come.
इसमें आप ये कहना चाहते हैं, मैं समझाऊं कि ये जो अल्फाज लिखे गए जी, कि ये प्रिज्यूम किया जाएगा, जो भी कैंडिडेट आएगा वो प्रिज्यूम किया जाएगा कि वो सजेशन से है, राइटियस है, अमीन है, ऑनेस्ट है. मस्त उस वक्त जो कोई डिक्लेरेशन है, इसके अलावा कोई इसको नहीं कह सकता कि आप अमीन नहीं हो, आप साथ.
ना सिर्फ ये, मैं तो ये तक कहूंगा कि जब तक स्टैट्यूट ये स्पेसिफाई नहीं करता, जब तक हाउ अ कोर्ट ऑफ लॉ विल डिटरमिन दिस,
फिर क्या करेंगे जब तक ये डिटरमाइन नहीं होता?
सर, लाइक अदर कॉन्स्टिट्यूशनल एब्सेंसेस, this will not be executable. What is the issue? There are a lot of provisions in the constitution which are not executed. इतनी सारी डिस्क्वालिफिकेशन, सर यहाँ पॉलिटिशियंस यही कंप्लेन करते हैं कि 20 डिस्क्वालिफिकेशन हो गई हैं. क्या क्या डिस्क्वालिफिकेशन नहीं है कि आपको ये ऐड करने की जरूरत है? कंप्लीटली अनडिफाइंड. लीव इट टू द स्टैट्यूटरी फ्रेमवर्क to determine the court of law, to determine the standard of proof, to determine we got the point. My not the last. Sir, one clarification. There is no contradiction between Samiullah Baloch and the Faisal Lamda case. There isn't, no. If your lordship is person saying this, no. My lord, it is obvious to me, and Justice Mansoor Ali Shah was of course part of that. If your lordship may look at the judgment, ये मखदूम साहब ने जो पेपर बुक दी है, इसमें आखिरी वाला टैब है 20 पे. ये वॉल्यूम 1A,
आखिरी वाला है
1A. Samiullah Baloch is erroneously decided, but there is no contradiction. Sir, if your lordship may see, ये टैब 20 है and page 372. जी. पैरा 2.
सर, इसके फैक्ट्स बहुत इंपॉर्टेंट है. We have heard the learned, पैरा 2 में पढ़ रहा हूँ, पेज 370 का प्रिंसिपल बताइए ना.
सर, प्रिंसिपल ये है कि जब डिस्क्वालीफाई हो गया, सर इलेक्शन कमीशन ने फैसल लाउडा को by exercising its powers under Article 218(3) disqualify कर दी for a false affidavit.
वो इस्लामाबाद हाईकोर्ट ने अपहेल्ड कर दी. अगर आप पैरा 3 पढ़ेंगे तो सुप्रीम कोर्ट हैज स्पेसिफाइड that was not a declaration by a court of law and that judgment is set aside. That is why a permanent disqualification under Samiullah Baloch does not follow in para 4.
It was not a declaration of the court of law. The election commission conducted the inquiry and the finalized by the High Court.
Yes, and उन्होंने हाई कोर्ट की
submitted in the High Court.
And उन्होंने हाई कोर्ट की जजमेंट सेट असाइड कर दी पैरा 3 में by saying कि Samiullah Baloch has been wrongly applied. It's not a court of
कोई फर्क नहीं होगा ना.
नहीं, लेकिन सर कोर्ट ऑफ लॉ ही नहीं था.
हाई कोर्ट नहीं, कोर्ट ऑफ लॉ फिर क्या
नहीं, सेट असाइड कर दी.
ये कोई बात नहीं
सर, अब मैं बता रहा हूँ,
ये मेरी मर्जी में किसको डिस्क्वालीफाई करूं या जिसको ना करूं.
लॉजिक बताइए ना इस बात में।
वो समीउल्लाह बलोच की लाइफ टाइम डिस्क्वालिफिकेशन अप्लाई करती अगर इस्लामाबाद हाई कोर्ट की जजमेंट सस्टेन होती एंड देयर वाज अ डिक्लेरेशन।
साहब ये तो no, this is you're just begging the question. So suppose if the Srinagar case would have been High Court judgment was upheld, you would say it's okay. If it's set aside, it's okay.
No, sir, if it was,
what is the principle?
It was upheld because there was, that is why he was allowed to repent.
No, we are talking about the principle of law. Principle of law तो समझ आता है कि आपकी लाइफ टाइम वो
पैरा 4 पैरा 5 में कुछ नहीं मेरे ख्याल में माफ किया, लेकिन कॉन्ट्रडिक्शन नहीं है सर।
अब आप कॉन्ट्रडिक्शन
आप ये कह सकते हैं, आप ये कह सकते हैं चूंकि इलेक्शन कमीशन को इख्तियार नहीं था, हाईकोर्ट उसी कंटिन्यूएशन में आते हुए तो हाईकोर्ट को भी, हाईकोर्ट ने सिर्फ ये देखना था कि इलेक्शन कमीशन ने सही काम किया या गलत किया, तो उस कंटिन्यूएशन में हाईकोर्ट वाज नॉट एक्टिंग एज अ कोर्ट ऑफ लॉ।
जी जी,
दो हाईकोर्ट इज अ कोर्ट ऑफ लॉ, बट एट दैट टाइम
सर देखिए मेरे ख्याल में जिस तरह सब गलती करते हैं और उनके ऊपर
I think you just said this to placate Shah Saab.
I would have loved to have said this. I would have died for his lordship, but this is not in. Sir, on a much more lighter, I think the Supreme Court has gone wrong in Samiullah Baloch. There is nothing wrong in admitted that. And to give your lordship's example, your lordship in a judgment of 2012, PLD 2012, Balochistan 1, in the Ubaidullah case, had also said that the disqualifications in Article 62 are in perpetuity. तो गलती सब करते हैं।
नहीं, हमें तो फॉलो करना होता है सुप्रीम कोर्ट को।
नहीं,
हम कैसे कभी कभी हमें जजमेंट पसंद नहीं आते,
सर उस वक्त नहीं आया था, लेकिन ये चीजें हो जाती हैं, कोई बात।
चलिए गलती
सर, सर मैंने बहुत शॉर्ट रखा है। आप भी क्लोज करिए बजाय इसके कि आप फर्दर किसी
घर जाइए।
lot of other submission, but
we are most grateful to be provided such valuable assistance at such a short notice.
Thank you, sir. Thank you.
कौन कौन रह गया हमारे सामने? एक तो मखदूम अली खान साहब ने कंक्लूड नहीं किया है ना। How long will you take? You can just come here and tell us. If it's a few minutes or it's a few what it's entirely up to you. No, it's entirely up to you. Provided we don't ask you too many questions, how long will you take?
I think within 20 to 30 minutes maximum.
Okay, how long will you take?
Maximum 20 to 30. That's enough.
Anybody else? Nobody left. आप किसके लिए आ गए?
And civil appeal numbers.
नहीं, ये छोड़ो ना, किस साइड पे हो आप?
Not in favor of permanent disqualification.
तो काफी हो गया, कितना सुनेंगे?
But I just need to add for 5 minutes only.
5 minutes ये हो गए। आप?
Sir, I am for
how long?
Just 5 minutes.
5 minutes. We're just counting the minutes to see if we can do it today or not to do it.
लॉर्ड, अगर मुझे आप इजाजत दे देंगे इनसे पहले तो मैं आपको क्लियर कर दूंगा। इट्स अ सेपरेट इशू। 63
सुनेंगे ना, फिक्र ना करें। ठीक, तो बाकी तो कोई नहीं है।
आई टेक ओनली 90
आप किसके लिए हैं? किसके लिए हैं आप?
क्या चाहते हैं?
अच्छा, आप किस लिए हैं करीम साहब?
सपोर्टिंग द लॉ,
द लॉ, नॉट द जजमेंट। आप इम्प्लीमेंट वाली एप्लीकेशन आपने फाइल की है?
बट अपील मेरी पेंडिंग है जनाब के पास। बैरिस्टर फोरम वाज आर्ग्यूइंग माय अपील।
यू सपोर्ट द लॉ? ओके, मैंने इम्प्लीमेंट की थी और मैं सुपर अंदर आपस में जरा पूछ लें। वो तो उनकी थी, आर्ग्यू किया ना सुप्रीम कोर्ट की तरफ। व्हाट अबाउट द सुप्रीम कोर्ट बार एसोसिएशन? उनकी पिटीशन है, आप कर रहे हैं? नहीं, सुप्रीम कोर्ट बार की भी थी ना कोई साहब की।
That petition, author's objections were raised and it was chamber appeal. It was fixed along with these appeals.
तो चाहते हैं कि उनका
सुप्रीम कोर्ट बार क्या चाहती है?
चलो वो
आप क्या चाहते हैं, लाइफ टाइम या
ये सब विड्रॉ करना चाहते हैं? हमारी तो पिटीशन जो हम आपसे सुनना चाहते हैं,
पॉइंट ऑफ व्यू क्या है?
आपका पॉइंट ऑफ व्यू क्या है?
लाइफ टाइम बैन लॉ को सपोर्ट करना, लॉ सपोर्ट करना। ठीक है, विड्रॉ क्यों करना चाहते हैं?
हमारी पोजीशन भी सर यही थी।
चेंबर अपील ऑब्जेक्शन है, दैट इज डील विद दैट।
ऑब्जेक्शन हमने सारे ओवररूल कर दिए, आप समझ लें वो सब हो गए।
आई एम नॉट क्लियर, जरा ये आप आएंगे सुप्रीम कोर्ट बार की कंटेंशन क्या है, आप क्या कहते हैं? लॉर्डशिप हम कोर्ट में ला करते हैं, हमने यही पोजीशन हमारी यही थी सर के जो टाइम पीरियड दिया गया है लॉ में वो आप कर रहे हैं, तो करने में हम वो सर हम यही कहते हैं कि 5 साल होना चाहिए सर, जो 5 साल जी सर नहीं वो है हमारा।
अब आपकी तरह बाकी इशू हम डिसाइड कर लेंगे, तो 184(3) तो हम इन्वोक नहीं कर रहे हैं, हम तो वो अपील्स में आए हैं। ठीक है, चलो हम देख लेते हैं। तो आप कंसेंसस में जरा पूछ लो अपने साथियों से, वांट टू कंटिन्यू और नॉट। उसका फायदा ये होता है एट द एंड ऑफ द डे आप लोग भी थके होते कब बात करोगे।
Let's start in
वो जो 5 मिनट वाली वो पहले खत्म कर लें। मेरी आपकी 5 मिनट स्टार्ट्स नाउ।
Sir, my client took a very principled stance.
छुट्टी की बात
फिर हम लोग कल पे कर लेते हैं।
11:30 है। We can start okay for today tomorrow. Suppose को change करना। The tribunal that the high courts have started functioning.
नहीं वो छोड़े बातें, हम सिर्फ
That's till the 10th.
Yes. So we have till the 10th. तो हम कल नहीं, उससे पहले तो ठीक है, कल के we will start. Can we start 9:30 को?
9:30 अगर
Can we start at 9 o'clock?
Absolutely. We can start at 8:30 if you like.
9 o'clock इसी कर लेते हैं। कल हमने रेफरेंस रखा है गजाली साहब का, तो 9 o'clock हम शुरू करें।
9 o'clock. Whoever is here, we here at 6 a.m. We start at 9, but you be here at 6:30. I'm really fond of coming with so I can be here.
चलिए तो आप उन लोगों को बुला लें। आप तो बहुत बेताब हो रहे हैं, अगर 2-4 बातें करना चाहें कर लें।
नहीं सर, मैं कल ही आपको नहीं सर, मैं I just wanted to emphasize that my client took a very principled stance, being a firm believer of parliamentary supremacy and civilian supremacy. और उसने
So you are supporting the law, supporting the.
मैं तो सपोर्ट कर रहा हूँ माय लॉर्ड, बट मेरा जो अपील है मैरिज से, उसमें इशू थोड़ा सा डिफरेंट है। वो
सामने क्या इशू है
माय लॉर्ड? हाईकोर्ट ने एक इनक्रेडिबल फाइंडिंग दी है,
लंबी बात ना करें, छोटी।
उन्होंने ये कहा है माय लॉर्ड, उन्होंने बेसिकली रिडंडेंट कर दिया 63(1)H को, जो कहता है कि 5 years के लिए डिस्क्वालिफिकेशन रहती है फॉर अ पर्सन हु हैज बीन कन्विक्टेड बाय अ कॉम्पिटेंट कोर्ट। सो मेरे केस में देयर वाज अ कन्विक्शन बाय अ ट्रायल कोर्ट जिसके अंदर 2 साल की सजा होगी। नॉमिनेशन पेपर उन्होंने फाइल किए, आरओ ने रिजेक्ट कर दिया बिकॉज ऑफ द कन्विक्शन, और वो सजा पूरी 5 साल नहीं हुई थी, लैप्स नहीं हुआ कर दिया। फिर अब हाईकोर्ट ने क्या किया? हाईकोर्ट ने कंफर्म किया, रिजेक्टेड ही रखे, उन्होंने रिट फाइल कर दी। डिवीजन बेंच ऑफ द हाईकोर्ट ने कहा क्योंकि उसने एक अपील फाइल कर दी है, देयरफॉर द डिस्क्वालिफिकेशन इज गॉन।
अच्छा, पेंडेंसी दी अपील,
पेंडेंसी दी अपील।
आप जानेंगे डिस्क्वालिफिकेशन आपको क्लाइंट। अच्छा, आप कह रहे हैं सिर्फ
63(1)H की डिस्क्वालिफिकेशन।
अच्छा, वो तो फिर हो जाएगा।
जजमेंट सिर्फ मैं चाहता हूँ सेटिसाइड हो जाए माय लॉर्ड, उसमें
आपके कौन से इलेक्शन का था इस मौजूदा इलेक्शन
लास्ट टाइम का था, बट अपील अभी तक उनकी पेंडिंग है और आप इसके मुखालिफ थे। बुनियादी प्रिंसिपल है जब तक
ऑपरेशन सस्पेंड किया है क्या उन्होंने ट्रायल कोर्ट का?
उसने कहा कि ये डिस्क्वालिफिकेशन नहीं है, ही कैन कंटेस्ट द इलेक्शन, रिडंडेंट कर दिया 63(1)(h).
Last elections was there in 2018. He was not allowed, and thereafter the matter is subject. It's
मैं कल सुबह को पढ़ना चाहूंगा वो जजमेंट का पैराग्राफ, तो आपको क्लियर हो जाएगा कि what has been done by the court.
matter in okay, my lord. Election matter. सस्पेंड हो गई थी, कन्विक्शन तो नहीं सेटिस्फाइड हुई।
सस्पेंड हुई नहीं माय लॉर्ड, हुई नहीं, सिर्फ सेंटेंस सस्पेंड हुई है बहुत पहले, नॉट कन्विक्शन।
सर हमारा भी इसी तरह का इशू है।
वो जो बाकी बोर्ड हम कर नहीं सकते ना, तो कमेटी ना करे। ठीक है, थैंक यू एवरीवन। 9 o'clock tomorrow, not 9.
छोटी सी रिक्वेस्ट काइंडली करना थी सर, हमारे नॉमिनेशन पेपर्स फाइल हुए, उसके ऊपर कोई ऑब्जेक्शन नहीं आए, नॉमिनेशन पेपर्स एक्सेप्ट हो गए। सब्सिक्वेंटली योर ऑनर दे हैव फाइल्ड इन अपील बिफोर, दैट इज
उनकी राइट है,
दैट इज सब्जेक्ट इज बिफोर,
वो नहीं छुएंगे, हम सिर्फ असूल तयन कर देंगे। 232 अप्लाई कर रहा है, नहीं कर रहा है, समीला बलोच कर, बाकी हम नहीं कुछ छुएंगे। ना आपकी राइट ऑफ अपील खत्म करेंगे, ना दूसरी साइड जो आपके खिलाफ है उसकी, हम उस पर कुछ नजरअंदाज नहीं होंगे। वो ट्राइब्यूनल्स अपना काम करेंगे, तो ओनली थिंग इज देयर बी हैव क्लैरिटी टुमारो डे आफ्टर व्हेनेवर।
सर वो हमारी सस्पेंड है,
ठीक है,
I may be excused for tomorrow, sir.
No, you, thank you very much. Yes, you've concluded. Thank you.